नेला ऐसे
कोर्ट ऑफिसर मैडम, कोर्ट ऑफिसर, कोर्ट ऑफिसर,
सर कोर्ट ऑफिसर कोर्ट ऑफिसर सर कोर्ट ऑफिसर कोर्ट ऑफिसर सर कोर्ट ऑफिसर कोर्ट ऑफिसर Madam Court Officer? Madam Court Officer?
ಹೇಳಿ ಮೇಡಮ್.
ಇದು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ತಗೊಳ್ತಾರಾ ಇಲ್ಲ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್? ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್?
ಅದೇನು ನಮಗೂ ಗೊತ್ತಾಗಲ್ಲ. ಪ್ರೊಸೀಡಿಂಗ್ಸ್
ಗೊತ್ತಿಲ್ಲ.
ಕಮೆಂಟ್ಸ್ ಆದ್ಮೇಲೆ ನೀವು ನೋಡ್ಕೊಳ್ಳಿ ಮೇಡಮ್.
ಓ, ಥ್ಯಾಂಕ್ ಯು
ಮೇಡಮ್ ಯಾವ್ದೇ
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಆಯ್ತಾಯ್ತು.
This is called Karnataka Land Revenue Rules.
Karnataka, my lords may kindly have a look at this 46K.
Yes. 46C and K.
46C is issuance of license and its renewal.
Yes, license.
46K is cancellation and suspension. Subsection 1 deals, subrule 1 deals with suspension. Suspension of licenses surveyor. License issued under Rule 46 capital A shall be kept under suspension if the licensed surveyor contravenes any of the provisions of the Act or rules, circulars and directions issued by the government, commissioner, director, survey settlement and land records after giving show cause notice and an opportunity of being heard. The power to suspend license will be vested in the Deputy Director of Land Records, Department of Survey. Appeal against the order of suspension shall lie to the Joint Director of Land Records. While placing me under suspension, they will suspend my login ID also. Then, my lords, I represented and they restored my login ID by annexure C at page 15/12/2021.
Examination thing, where do you get it?
Yes, ma'am.
They have to appear for some
Exam.
test.
No, not at that time. I need not appear
No,
for the
now.
exam.
Now you're asked.
Now what they do, that is for 46C.
That will.
46C, what it says is, the third para there in 46C, renewal of license shall be subject to service rendered by the licensed surveyor, which is assessed by the concerned DD, the Deputy Director of Land Records of the district or through continuous evaluation mechanism. If the performance at any time is below the service after successful completion, then they have to depute me for training. How they assess this performance is they will ask me to undergo the.
This would arise at the time of renewal of license.
At the time of renewal of license only. It is due for renewal in March 2027.
Lord, yeah. Earlier, my lord, they are the private license surveyor, private licensed surveyor. My lord, as senior counsel said, my lord,
No.
earlier also, my lord.
His license is till 27 or not?
My lord?
His license is up to 27 or not?
No, my lord, up to 27, but in the middle, my lord, they have discontinued the license. They didn't perform their duty. Therefore, we have removed them. Thereafter, my lord, once again they made application. Once again, they made an application for license. Therefore, my lord, 46C applicable. Then,
When did they apply?
my lord,
When did they apply? You are saying that they made an application.
yes, my lord.
When did they apply?
When
for
did they
that?
cancel also, let them say, man. There is neither cancellation nor the fresh application.
I'll get the records.
So
There,
it is
my lord,
adjourned.
yeah, my lord, what happened, my lord? As per instruction of the concerned authority, my lord, what they said, once they have removed, they failed to perform their duty in a continuously in 1 month, they have to automatically they will remove. Thereafter, if they wanted to continue as a surveyor,
Let us come to.
they wanted to continue there as a
No, you are
surveyor.
referring to that 2021 order, Mr. Senior Counsel, where is that?
There is annexure C, page 26. The login of the following surveyors is licensed surveyors is activated as per the order of the Honorable Commissioner.
This is dated
This
15.
is dated 15/12/2021.
21.
Hmm.
Thereafter, it has
Then
been
after
deactivated.
that, where is it deactivated?
It has
When
been
is it?
deactivated.
Huh?
It has been deactivated.
When?
He told my lord, he'll send a record, my lord. He didn't reach the court. Even
For
What
me
is the
to-
exam?
My lord, the examination is on Monday. The training, I have to report for training on Monday, along with the deactivation certificate.
yes, thereafter,
Kindly,
my
my
lord,
lords,
we have
annexure
deactivated.
So
C.
that is what their case is. It is not deactivated.
Annexure
Therefore, my
A,
46C,
condition number
my
5 is, I have to produce the deactivation order about my login ID.
According to you, it
Deactivation
is not deactivated.
It is not deactivated. Even today I am
means, my
working.
lord, they are not performing their duty. We are not assigning any survey work. It means that it has been
It
deactivated.
automatically goes.
Yes, my lord. Yes, my lord. It automatically go. Therefore, my lord, annexure C, 46C,
You're
46
making a
means,
submission that if they don't perform their duties for some time, it automatically
yes, my
deactivates.
deactivated.
There should be a provision saying that.
46C, my lord, thereafter, 46C, kindly, my
What
lord.
is it?
That is 4
See.
months.
Let's see.
46C, my lord,
Uh,
once license has been issued, my lord,
Hmm.
thereafter, my lord, period of, second para, my lord, period of license once issued shall be extended by renewal of an application to be made by the license holder within 1 month from the date of expiry of period of license.
are you reading?
Before the deputy. Thereafter, my lord,
No,
3,
no,
renewal.
46C starts with license shall be issued with the commissioner,
Yes, my lord, it is a process for license.
Hmm.
First,
Hmm.
second para, my lord,
period of license.
period of license.
Uh,
If they deactivated within 1 month,
Let's read that.
uh,
Period of
period
license.
of license once issued shall be extended by renewal of an application to be made by the license holder within 1 month from the date of expiry of period of license before the deputy commissioner of land records of the respective districts along with the fee as notified by the commissioner director.
According to
surveyor.
them, that situation won't arise in this case because their license is not expired. It is still 27 according to them.
As instructed, my lord, it has been deactivated. Now they are not working.
No, you're submitting that if they don't perform their duties, it will be automatically deactivated and you're relying on you want to read the provision where it says that for a period of 4 months, if no work is allotted, it will be deactivated. Where is it? Come up with your instructions or your objections. The,
A and B, A series and B I have sought statement.
Now, my lord, only question is, my lord, if they wanted to continue as a private surveyor, they should attend to the technical.
their cases, because it is
Training.
not deactivated, that is the,
Then they are not
while
working.
appearing for that, they should have that. They don't, it is still in force according to them.
Yes, my lord.
If you get instructions on Tuesday or Monday
Please,
and tell
please,
the
please.
court, then I'll post this matter on Monday.
Yes, my lord. If it is stayed also, my lord, they will not get work. Therefore, my lord, I am concerned to say all those things.
Question is
Therefore-
not work. If I have to comply with annexure A and B, I should have a deactivation card. And condition number 5 in annexure A is that, kindly take the translation copy at page 1, my lords. Page
number?
1
Where
of
is
the
that?
translation of the translated documents. Page 1.
Hmm.
Condition number 5 is I have to produce letter at page 4, letter given to you by the land survey department regarding deactivation of Mojini login.
No, what is the consequence of an order now? How it is going to go? inure to the benefit of-
I need not participate in the training because the condition in the annexure A is impossible to comply with. At page 3, they say, my lords, you are requested to appear before this organization, that is the institution, on 3/6/2026 at 9 AM with the following documents. Document number 5 there is the letter given to you by the land survey department regarding deactivation. This is applicable only for those who are deactivated. According to my learned friend, if I am not going to get the work, and if because of the stay granted for annexure A and B, it is at my risk. That is actually factually incorrect submission being made.
Then a senior counsel appearing for the petitioner submits that. The petitioners are agreed with the. This is dated. Annexure A
Yeah,
is
30th.
dated.
Annexure A date, say A series dated 30th April 2026
30th April 2026.
and annexure B dated 15/4/2026.
That is,
That is 15/4, annexure B is the order passed by the commissioner. That we have to write the competency test, technical competency test.
on 15th.
Pursuant to that,
This is a consequence.
yes, yes.
Petition is agreed with the order of the commissioner dated 15/4/2026, where the petitioner is directed to undergo the competency test. It is submitted that the petitioner's license is renewed and it is valid up to 2027. The senior counsel has drawn the attention of the court to the text section 46K and 46C of the Karnataka Land Revenue Act rules, submits that, and underlying on the same, it is submitted that question of going through the exam will arise only at the time of renewing the license. But in this case, the petitioner is having a valid license as on date. Further, it is submitted that pursuant to the said said order of the Commissioner dated 15/4/2026, the petitioner has received the letter dated, this is dated, Annexure A is dated
Annexure A is dated for 30th April 2026.
30th April 2026, whereby the
Whereby the
petitioner
principal issued
petitioner has to submit the letter given by the Land Revenue Department regarding deactivation of Mozini login. It is submitted that such condition cannot be fulfilled by the petitioner as his license is invoked and it is very much his what is that called?
login ID, ma'am.
A
Restoration of
ID.
login ID.
Login ID is still active. Next, the AGA submits that their login ID is deactivated. And if the petitioner is not, any work is not allotted for a period of 4 months,
46K,
huh?
46K.
4 months, it amounts to automatic deactivation. Next para. In the light of the submissions made by both the parties and the fact that according to the petitioner, his login ID is active, and according to the respondent, his login ID is deactivated. And without cancelling when the license is very much in force till 2027, as per 46K,
Yes.
the question of appearing for the exam would not arise. There shall be stay of all further proceedings pursuant to Annexure A and
A to A7 and
B.
AB.
Let
and B.
AGA takes notice. Already you have taken notice. The the respondent shall file their objections.
Since
This
matter
matter-
46K, my lord, cancellation of license 4 months. ಇದೆ.
List this matter on 24th of June.
Great.
Chetan AC.
But I sought for a mandamus directing the KIDB not to release the compensation to the other respondent because there is a partition suit pending.
Why is it adjourned on the last occasion?
Lord,
ADB to
to
get
answer,
instruction.
Is director take notice? issue
to find
notice
out, my lord, whether the
3 to 8.
1 and 2 have taken.
Huh?
The
1 and 2 have taken notice, my lord. 3 and 8 are private respondents. Lord, the compensation has not been released so far.
No, I think last time you're supposed to, I asked you,
Whether the compensation
What-
released or not.
or
The
not.
compensation has not been released to anybody.
Hmm.
There is a representation given by the petitioner. So that has not been disposed of as of now. Claiming that
consider it.
that can be done, madam. That can
And
be done.
by issuing notice to the respondents, instead of keeping it pending,
That could be
let
done.
notice be issued to the respondents.
That
And
could be done.
then you
Last
can,
time your lordship had suggested they can keep an FD or.
no. What we do is, I'll dispose of this so that they'll issue a notice
In
to
3
them.
weeks or 4
And
weeks,
if they
it can
can
be
do it,
disposed.
they'll do it. Or if you have no case, they will disperse it.
Within 3 to 4 weeks, timeline can be fixed, madam.
The presented petition is filed,
Annanta bandide,
seeking the
ಚೆನ್ನಾಗಿ.
following prayer.
ಚೆನ್ನಾಗಿ.
It is the case of the petitioner that the petitioner is the daughter of the fourth respondent and granddaughter of the third respondent, niece of respondent number 5 and sister of respondent number 6 to 8. The petitioner is married and staying separately, while the respondent 3 to 8 are staying together. The petitioners and respondents are joint owners of the properties. And properties as mentioned in the schedule in OS number 249 of 2025, which is filed for partition on the file of the third edition of senior civil judge and JMFC Kolar. It is stated that earlier the petitioner had filed OS number 430 of 2024 before the civil judge and JMFC Kolar, which was returned for want of pecuniary jurisdiction. While the said suit is posted on 17/6/2026 for further chief examination of PW1. The respondents 1 and 2 who had acquired the property That is a sue schedule property.
Please, madam.
Sue schedule property, property or releasing the compensation in favor of the unofficial, in favor of the respondents.
3 to 8. 3 to 8.
3 to 8. In this regard, the petitioner has given a representation to the respondents on 7/5/2025, requesting not to release the compensation amount to respondents 3 to 8. It is a grievance of the petitioner that the respondents have not taken any action on the said representation. Next para, when counsel appearing for respondent 1 and 2 submits that they have received the representation dated 7/5. It's on 7/5/2025.
It's not been disposed of because the compensation is also not been determined so far. So it is pending at that stage.
It is submitted that he does not dispute the fact that they received the representation on 7/5/2025. However, however, it is submitted that they have not disposed of the same so far. Next para. The petitioner has given a representation to the respondents. The respondents ought to have considered the representation. If the petitioner is entitled for any relief as sought, they can pass appropriate orders, but they cannot keep the representation pending consideration. In that view of the matter, this court deems it appropriate to dispose of this petition, directing the respondents to consider the representation. This court is not proposing to issue notice to the other respondents, as the court is not passing any adverse orders, and the respondents 1 and 2 has to issue notice to the respondent 3 to 8 before considering the representation dated 7/5/2025. In that view of the matter, this court is passing the following order: that a petition is disposed of, directing respondent number 1 and 2 or any one,
2 madam.
respondent number 2
Respectively.
to consider the representation dated 7/5/2025 within a period of 4 weeks
Please.
from the date of receipt of the copy of the order. The respondent 1 and 2, the respondent number 2 shall issue notice to the respondents 3 to 8, 3 to 8, 3 to 8, and after giving reasonable opportunity to them, shall consider the representation. The representation shall be considered within 4 weeks.
Right.
So,
Cell number 9. Cell number 9, Harish Kumar.
no, in that case, I said I'm not issuing, though notice is not, instead of saying issued or not serving notice, say, though notice is issued and not served, but this court is inclined to dispose of the petition as no adverse orders are going to be passed against. Yes.
9, Harish Kumar.
My lord, I appear for the petitioner. On the last occasion, my lord, the respondent was directed to show the power to issue such instruction to the corporation to
Yes.
change the Khata.
Yes, that's all.
I got two humble submissions, my lord.
Yes.
Point 1, my lord. I have been given a duty, not my lord's, the power or the right,
Huh?
to sell the property. The Honorable Special Court has imposed upon me a duty to auction the property and disperse the money that we recover. But pending holding of the auction. Because I have asked that there should be no change of Khata in anybody else's name.
Can you ask so?
Please, my lord.
How?
But settled principle of law, my lord. If law confers upon me a power or a duty to do something, all matters incidental and necessary for the discharge of that function are deemed to have been given on me. Now, my lords, he is not in the possession. I am under a duty to auction the property. But whether it comes in my name or somebody else to whom the property is sold, my lords, may not be his right. Kindly appreciate this, my lord. As it is, my lords, a compelling auction. It is not, my lords, arm's length sale. Unless the prospective buyer,
How the registering authority is bound to effect your whatever your request?
must kindly see the impugned order, my lord.
Yes.
But before that, my lords, there are two humble submissions. One, what is challenged now is only a consequential order and not the substantive order. Kindly see Annexure K.
No, that he has challenged, which is pending before the
Yes, and for the
appeal.
time being, Lord, the Honorable Division Bench has passed a conditional interim order that he has to deposit a sum of rupees 1.5 crores within the next
No,
8.
the other day when you were saying that he is ready to deposit, I said it is before the division bench, there he'll go.
But there 1
Now we
crore.
are only on this point.
Please,
We are only on this point.
Please, my lord.
Now pending all this, whether the the respondent who is a competent authority, can address a letter whether the registrar is bound to implement it.
Please, my lord, I'll submit, my lord. Point one, my lords, I have not said that the property should be registered in my name. I have not. If at all such a submission is made, my lords, it may not be correct. At page number 106, my lords may permit me to translate, my lords, as much as
The
possible.
same thing, what happens is even in the surface proceedings also, when they have taken possession of the property and so many other, when during the said process, they were asking for a relief, saying that it should be notified by the registrar, saying that the bank has got charge over the property
Please.
and other things. Now, why should the registrar do all that?
But why not the register? It is not anybody's case that the register is having a
Do
difficulty to comply.
do it as per the procedure. Now, you
I have
can
power.
auction it,
But-
sell it.
Please, no.
And what is this procedure in
Under Rule
between?
5, under Rule 5, which constitutional right has not been challenged, I have the power, I'll read out Rule 5 for the benefit of the Honorable Court, to say that the name of the property should not be changed or the property should not be permitted to be sold, in as much as there will be a multiplicity of litigation. My lords, may kindly permit me to read the rigor of Rule 5, my lords.
My lord, just I want to clarify. My lord, if they say
Rules.
there must be an endorsement
Written
stating
rules.
that it should not be sold to anybody, or it can be said that, my lord, it has been attached by so and so, I have no objection whatsoever. Now, my lord, the specific in the instruction is that the property has to be transferred in the name of the competent authority. For that, I have objection. My lord, let them mention that it has been attached, or their name also can be mentioned that as it is attached, or it should not be sold to anybody. That is the only objection what I have, my lord. Now, my lord, I have translated version where they have sought a clear instruction stating that it should be in the name of competent authority. Quote. Immediate last page. Last page. Accordingly, a copy of the order of the Honorable Special Court is being sent herewith, directing that the account of the property described above be immediately transferred to the name of competent authority measure so and so. This I have objection.
Which one?
Immediately transferred to the name of competent authority measure SMN Credit Sauharda Sahakari Limited. In last page.
Where is that?
Last page.
Someone,
Accordingly.
further, since the said amount has not been paid to the account of the competent authority, action has to be taken as per the order of the special court, and it is necessary to transfer the following assets to the name of the competent authority.
That is I have objection. Now, my lord, rule says that whatever attached, it should not be sold by all those things are fine. Now, if they want to transfer the property itself without there being any power or direction from the Honorable Court, that is illegal. To that extent, I have sought.
It will be my very humble submission that he is not aggrieved by the fact that the property should be in my name, because if I have to put the property to auction, so I cannot auction somebody else's property. And now the Honorable Division Bench, minutes before the arguments commenced here, has said that whatever steps are required to effectively put the property to auction can be taken, subject to a condition the
Generally,
property is not put to auction.
Generally, what is the procedure?
My lords,
When a particular property
please,
is
my lord.
notified.
Lords, there is,
No, when the particular property is notified, when the competent authority sells a property,
please,
what is the procedure? First,
Please.
you transfer it to your name.
please, my lord. No, first we'll transfer it to in our name, then we'll got the property, my lords, evaluated, my lords, in terms of the guidance value, my lords, or whatever the value, and then, my lords, it will be put for auction by putting it in a couple of newspapers. But ultimately, my lord, I ask myself, what is the grievance? But at a drop of a hat, after, my lords, 160 days of the order having been passed and not being challenged, now, my lords, I take steps to auction the property, and during the vacation bench, the bench is moved. But I have no difficulty. It's his right, my lords, I bow down. But, my lords, what is the grievance, I ask myself? If I have to auction the property, I will take all steps that are required. But tomorrow an objection will be raised. The property was never in the name of the competent authority. It was in somebody else's name. It was in my name. And then the property is being put to auction. So ultimately, I ask myself, what is the grievance? What is the difficulty? What is the cause of action? What is that thing which makes me come before this honorable court? Whether it's in my name or in the name of B, I have to put the property to auction. I should have done by that now, but only to give sometimes, my lord, giving opportunities is also wrong. Now they say they'll deposit 1.5 crores before that court. 1 crore, my lord, they're submitted before this court, and, my lord, when facts were brought to the notice of the court, They have agreed to pay 1.5 crores.
No.
Ultimately,
Sorry,
my lord,
it is not correct.
ultimately.
It is not
No,
correct.
1 minute, sir. If I ask myself, my lord, if my lord, a substantive order is not challenged, this notification says, in terms and in compliance of the orders passed by the Honorable Special Court, I am taking these following steps. Without challenging that substantive order, my lord, I ask myself,
This question,
my lord,
the substantive order is
but
questioned.
now that it is questioned there, my lord, now that my lord is a stay operating on the auction of the property, but permission given to me, my lords, to do all such, take all such steps necessary for putting the property to auction. But this petition itself may not survive for consideration.
My lord, my humble submission is this. First of all, my lord, there is no such procedure where property has been attached. It should be transferred to the name of the person who is entitled to receive the amount. My lord, the whole procedure is this. Once property is attached, that has to be brought into auction. Suppose, my lord, there are cases where in auction, no one will come and buy for that property for that particular time. It is, my lord, under the provisions of the Karnataka Cooperative Societies Act. There is a provision, my lord, where they can request the competent authority to transfer the property in their name for time being.
No. As rightly submitted by him, what is your grievance?
My lord, my grievance is this. Property, when, see, I am not the borrower, my vendor was the borrower. Anyway, I am liable to pay that amount. What I have to pay, that is one thing. Second thing is that, my lord, any buyer, if they want to participate in the auction, my lord, they must know that to whom it belongs to.
That is their
No,
problem. Why you
not that.
know?
It is my right, my lord. Property, right? It is my
No,
property.
you say that
Only
the
it
other
has.
No. Say the other person should know. About his rights, he will take care of it.
No. Even otherwise, it is my right. It's my property right. It is only I am liable to pay some amount. My lord, if the person comes for auction, my lord, when in bidding takes place, my lord, these point will come to their aid or to my aid also to fetch a higher price. That is the main. The second thing is that, my lord, if something is right or it is necessity for the party, it cannot be done as it is. There must be a procedure in law. What is the order of the special court? The order of the special court says that the so-and-so has to pay this much of amount. In case if he fails to pay that amount, the competent authority it has been attached and it can sell the property in an action.
No, as on today, the
Please.
division bench has not interfered with the order passed by the.
It has been stayed.
No. And not the entire order, only the auction is stayed.
No. Impugned order has been stayed, subject to payment of 1.5. Yes, my lord.
I'll file an
My-
affidavit. I will
Yes,
file
my
an
lord.
affidavit. I will file an affidavit. my
What
lord.
submission has been made by my learned friend was that, no, till that, my lord, I will proceed with sending a valuator to get the actual price and other things. For that, I objected.
Where is the submission?
Nothing else. Nothing
Ultimately,
else.
What is the order? The entire order of the special court notifying these
Yes, my lord.
properties
Is stayed.
In that case, how this can, how you can address the letter?
Submit, my lord. My lord, this is a submission. Ashwattamo hataha narova kunjarova.
Let there be affidavit by himself. My lord, what is, I'm not able to understand why he is harping on this. It is a point.
It is a contention of the then counsel for the petitioner that the order that is passed by the special court is suspended by in its entirety by the honorable division bench. It is a submission of the land council appearing for the competent authority that only the auction proceedings are stayed by the division bench. It is submitted that it is a grievance of the petitioner that the competent authority cannot address a letter to transfer the properties or to reflect the name of the competent authority as the owner of the property. Is it correct?
My lord,
To reflect the name of the competent
Please,
authority as the owner of the
Please,
property.
please.
As owner of the property, when the order of the special court itself is suspended by the division bench in the light of the submissions made by both the parties, the order copy
Produce
would be
the copy.
sufficient. Why the affidavit shall be
Yes,
filed?
my lord, we'll place the
the order
copy.
has been passed about 15 minutes ago, please, my lord.
Or today itself. it
Today,
is-
now only we argued and we
In fact,
came.
my learned friend
We'll
wants to.
place the copy.
They submitted the division bench's order is passed today itself, and they need to have the copy of the same.
Please.
This is matter on Tuesday.
Much obliged.
Plus, Tuesday, the order may not be available. May I pray for something, Lord? My Lord, may kindly subject to the orders of the division bench.
Huh?
Subject to the orders of the division bench, because
No, we'll have it on Tuesday.
please,
But if
order may not be
Tuesday-
necessary, order may not be
If
available by
not
then.
Tuesday, we'll have it on Friday.
Please,
Yes,
please,
Friday.
Much.
Yes.
oblige me.
Cell number 10.
But there's been a disconnection of electricity from Bescom.
Yes.
Respondent, I served the notice to the respondent.
Temporary connection was
Huh?
given, temporary power supply was given for construction purpose. Where the construction was made in violation of the plan. The GBA has written a letter to that the construction is in violation, therefore disconnected. You have written a letter, show cause as to why that you have not so far as that getting, until so far as that submit objections before the BBMP and get it settled. That is a notice was issued on 4th April 2026. 4th April 2026. That against that matter that they have not filed any objections. The disconnection was made in the month of the middle of the May, that then they have filed a writ petition. We have no objection to restore power supply.
No. Which provision, as per which provision either under their act or under the Electricity Act, that you have a power to disconnect basing on the communication by the BBMP.
That the BBMP that it is a supervising the construction as per the plan of UI. That we have given a power supply for the purpose of construction. Even BBMP,
Is it-
I'll make. Even BBMP initiate a proceedings. That even despite initiating proceedings, that taking advantage of the existing power connection, they are constructing the buildings, violation of the bill.
He has a permission. He has a permission.
Yes.
He is making the construction contrary to the sanctioned plan.
Yes.
In that case, BBMP will address a letter to the Bescom and you will disconnect the
That
power
they
supply.
will take action against them and also intimating us that we have taken action.
But you have
to
no power. Under which authority you do it? Under which authority you do it?
That regulation says that
Do
where.
it, show the regulation.
That
Which
I'll place it
regulation
on
say-
record, that subject to that it isn't.
No, if there is a,
That I'll place on.
that they will do. That is
I'll
their
place it-
problem. How
that
can
I'll
you
place it on
disconnect?
record. That we have so far as that local authority have intimation, we have to act on that, I will place it on record. That so far as the interim order is concerned, that it is
Give
interim order
the
concerned,
connection forthwith.
that interim order concerned, the restore power supply temporary connection subject to paying regular consumption. That is my submission.
That is not at all your case, but.
That is
in
not
any
our
of-
case, not on merits, not that we so far as. that
Of
is
the
concerned.
default on the part of the petitioner, you have disconnected. Now, if somebody is making another, if he has a permission, contrary to the permission, some construction is made. The BBMP can't write a letter to you, say that you disconnect the supply. That is for them. If they are making, they'll issue a notice and they will demolish it.
That definitely not that it requires to take a step to demolition is concerned.
But you
That-
have no role to play in this.
The role is concerned that further it should not be any so far as the ampere is concerned.
You have anything with regard to your department, you take action against them. The present writ petition is filed. Agreed with the action of the respondent, number 3, in disconnecting the current supply to the property. Then counsel for the petitioner submits that without any basis, the third respondent has disconnected the power supply. Then counsel appearing for the third respondent on instruction submits that the petitioner is making construction contrary to the sanction plan, basing on the letter received from the.
The letter received from the GBA.
Huh?
Letter received from the Joint Commissioner BBMP
Letter received from the Commissioner BBMP.
on 18/3/2026.
They have disconnected the power supply.
We are not immediately disconnected. We have issued a notice to the
Issued a
petitioner.
notice to the petitioner. Later, when the petitioner has failed to reply to the same, they have connected the power supply. If the petitioner is making any construction contrary to the sanction plan, it is for the BBMP to take action against the respondent, against the petitioner. But the BBMP cannot direct the third respondent to disconnect the power supply. If the petitioner, there are any latches on the part of the petitioner with regard to the payment of the amount and all, and any other deviation, the third respondent can take action. In that view of the matter, the third respondent shall forthwith restore the power supply to the petitioner.
Temporary power.
Huh?
Temporary power.
Whatever it is.
Whatever it
Your
is.
connection is
Whatever
there.
it is, what was earlier stated.
Yes, yes.
Temporary.
Same. They shall
Published.
forthwith restore the power supply, which was disconnected on what date?
On 19/5.
19.5.
19/5/2026. Notice to first respondent AGA takes notice. Respondent
2 and 3 I'll take.
2 and 3 so and so takes notice. This is my, or shall I dispose it off?
That I'll place.
Print
that
disposed
record.
of.
This is matter on 24th of June.
Much.
Case number 11. HS Prashant.
I have a memo for posting, ma'am, before this bench. I have an urgency here. By 3:30, if the matter can be heard. I went to the DB bench. They told it will be listed before the single bench.
What is urgency?
Urgency, ma'am, there is petitioner 1 and 2. Respondent advocates have filed a malicious prosecution. So now when they got to know that the stay was given in 482, they have gone to the extent of the forging the judicial order pertaining to the framing of charges, with the intentions that the 482, the petitioner 1 and 2
What
does
is the
not get a relief.
classification of that writ petition?
MCR,
Huh?
482, your lord.
Not this court. You have to go to the other court. Yes.
This is writ petition, madam. This I have complained to the State Bar Council of Karnataka. I have asked the State Bar Council of Karnataka to transfer the case to Bar Council of India because the respondent advocates already have a warning to adhere to.
So why should we take it up today? Why not on, why not after the court
They,
reopens?
they are filing malicious FIRs again.
Let it be. You move the regular court. No urgency now. Yes.
Then at least
11.
then this.
No, you file it, it will come. We will not grant any. Yes.
Then
11.
is it a DB matter, ma'am, or if it's a single bench or a DB bench when Bar Council of India and Bar Council of Karnataka? Because the filing counter is telling DB matter, and I
That
requested.
the court will not tell you which is it. You have to go and find out. Yes.
Case number 11. HS Prashant for petitioner.
10 Lord, additional Lord, tax demand notices not annexed A1 to A9 for the past 10 years. On the wrong premise, Lord, that I own Lord extent of Lord 40 into 60. In fact, Lord, I am the owner of Lord 40 into 40. By way of 2 sale deeds, Lord, annexed C and D, I purchased Lord 40 into 60. Out of which, Lord, while annexed E, Lord, I gifted Lord 20 into 40 Lord in favor of my son. Now, on the premise, Lord, that I own the entire property, the additional tax is demanded. Similar notice, Lord, was also issued to my son.
No, against this, which one? 11.
By there is a provision, my Lord, to
Under Municipality Act, the taxes and all, the writ petition comes to the High Court.
it comes.
It can be
No?
filed, my petition.
No,
There is
Your Lordship,
there is
kindly-
no, in Telangana, we have this civil court will have this with regard to all this tax
Yes, yes.
issues and all.
Here, not
Appeal provision
page
to the
107.
Corporation, my lord.
It is
Then they
appealable
can
to
do.
not to the
Huh?
corporation itself. It is appealable. Page 107. Page 107.
Hmm.
This was the error message not I got. In case of my son, my lord, he was able to file. That is the previous annexure. Page 107, my lord. I could not upload, my lord, my objections, my lord, online.
What is the intermodal you're seeking?
Please, my lord. Now, my lord, the demand notice is issued, my lord. Annexure H, my lord,
Their
is
whole case is
the
that
annexure
their
H, my lord, is the reply given
whole
by.
case
Let him
is,
say.
their whole case is their extent is less, and for more extent, we have issued the notice. So I have taken instruction. We'll consider their representation, my lords.
When
where
is, when
we will
was it given?
re-inspect. It was given on 22/5.
Hmm?
Annexure H is there.
Annexure H, my lord, page 100,
25/2.
25.
We will consider it and
And till such time, don't give effect to that.
we'll consider and we'll give them an opportunity and then we'll pass an order, my lords.
Then we'll dispose of this writ
It
petition.
can be disposed of.
Please.
Because if we once inspect, it will be, after inspection, the extent will
Yes.
come out. We will consider.
The writ petition is filed. So the following prayer. Is a case of the writ petitioner that the it is a grievance of the petitioner that the 40 by 40 feet portion The petitioner has constructed the basement and ground floor measuring 790 square feet SPA, and in the first floor to fourth floor, the petitioner has constructed building with each floor measuring 1036 square feet SPA. Since she has to leave about 10 feet of area of the road, she could not construct the building to the entire extent. The total extent in the 40 by 40 portion is 5,720 square feet of super built up area, for which the petitioner has been separately assessed to tax and has been regularly paying the property tax. In another 20 into 40 feet portion, the petitioner has constructed basement and ground floor measuring 535 square feet SPA, and in first floor to fourth floor, the petitioner has constructed building each floor measuring 651 square feet SPA. Thus, the total construction is 3139 square feet of built up area. The said portion was subsequently gifted by the petitioner in favor of her son by registered gift deed dated for 8/4/2025. The property tax for both portions has always been paid separately. The petitioner has paid approximately 89,827 towards the property tax for the portion of the commercial building. Her son has paid an amount of rupees 48,994. And despite the existence of separate ownership and separate tax assessment, the respondents have initiated reassessment proceedings by issuing show cause notice, several show cause notices. And if upon receiving the notice, the petitioner submitted a detailed representation dated 25/2/2026, explaining the factual position regarding extent of land. But the respondent, without conducting any inquiry and without considering the representation of the petitioner, has passed the impugned proceedings. It is stated that the impugned proceedings are passed on the assumption that the petitioner possesses construction measuring 8,977 square feet and reassess the property tax. It is submitted that the respondents have failed to consider the actual extent of land, and no inquiry was conducted in that regard. Land counsel appearing for the respondent submits that the petitioner has given a representation. The representation date 25/2/2026.
A reply given. It's a reply given by them.
The petitioner has given a reply date 25/2/2026, and that reply, they would consider that they will inspect the premises, and they will consider the same and pass orders considering the submission of the land counsel appearing for the respondent and the fact that in the impugned proceedings, the reply that is given by the petitioner dated 25/2/2026 is not considered by the respondents. The impugned proceedings will set aside this.
Demand notice may be set.
The notices dated so and so that's there in the prayer are set aside.
A1 to A9.
And accordingly, this court is passing the following order that a petition is allowed by setting aside the so and so. The respondents shall consider the reply dated 25/2/2026 given by the petitioner in accordance with law by giving a reasonable by conducting the necessary inspection within a period of
4 weeks.
4 weeks from the date of receipt of the copy of law. Yes.
Obliged.
Given this matter for this point 4 and 5 minutes.
Lords, this is the day before yesterday's matter. Can I just pursue your lords? May I kindly have a look at page number 29. It's a very short dispute. Probably it could be disposed of on a short ground. Lords, I'm not requesting your lords to read it, but in one survey number, which was an erstwhile government survey number.
Yeah, mandamus to consider the representation.
That is all.
dated
No, it's now.
8/2020.
They only
That's all.
want the khata. They have given a representation dated 23. The Saguvali chit or the grant is made in 2019. Then in 2023, they make a letter saying, please transfer the khata. The prayer is only to consider it and to consider the khata. There is nothing for us. We are in a different land and a different portion. So if they want the government to consider the representation and do the khata in their favor, there is nothing. And the only thing sought is interim prayer. Main prayer is to consider the representation of 23.
Yes.
Kindly see. And
Can I just say
1
this,
minute,
Manoj?
in the interim prayer,
There is
it is to
something.
maintain status quo on my
There is-
land at page 14.
But we are passing the final order, the status quo will not arise now.
Manoj, there is
Exactly,
something,
exactly.
I'll just say this, Manoj. There is a reason why we said this. For the purposes of seeking for Podi and survey now, because of this Bhumi software, the khata has to be in my name for the purpose of seeking the Podi and Podi proceedings, etc. The reason why I drew your lordship's attention to page number 29 is, on a given day, the regularization committee granted different extents of land in the same survey number in favor of 11 persons. Now, these 11 persons, at page number 30, there is a rough sketch, more or less a rough sketch drawn, which shows the blocks. If your lordships were to kindly have a look at, it shows the blocks. Lordship gets it. There are block numbers, which is in the numericals 12, 3, 10, 9, 2, like that. There are block numbers. Now, what happened? If at all they wanted to conduct the survey and fix the boundaries of these 11 properties, they had to do it in one go because they are all adjoining properties. Now, what they did was, the person who was granted with 25 guntas of land, for whom my learned senior friend appears, they fixed only that boundary for survey number 207. Then we gave a representation saying that my khata has to be done. Now, as a matter of procedure to change the khata, what they have done is, the property is to be identified and a separate survey number will be tentatively given for the purpose of change of khata. This is the present procedure. When they carried out this exercise, what they found was, the land which is granted in my favor 1 acre and 25 guntas which is granted in favor of my learned friend, there is a overlap. Extent of property is available, but the manner in which they have conducted the survey is in a manner that it overlaps into my area. So the report was generated by the revenue inspector, submitted to the deputy tahsildar. Deputy tahsildar submits a report to the tehsildar. Now the matter stands there. They have kept the matter.
That should have been questioned.
Now this is a report which is in my favor. The report is in my favor saying that this is done.
If that's the case, then by issuing the notice, they have to redo that.
That's all what I am asking. What I am saying is, now the entire exercise is to be redone. Even it is in respect of my learned senior friends, client's interest that this exercise is to be redone because this is something which is to be resolved by the revenue authorities. Extent of land is available. Whatever extent is given, it is available. Whatever we are entitled to, we are entitled to 25 guntas and 1 acre. We are
1 acre,
entitled
10
to.
guntas. Anyways, I have my sale deed. He is not challenged my sale.
No, I'm not disputing their title at all.
Conduct the survey.
No, that
It has to be redone. That's it.
can happen.
The aggrieved party has their
That
own
can
mechanism.
happen. There is no
This
difficulty.
entire
That
exercise
can
has to be
happen.
redone by them.
That can happen.
So that,
but that is
I'm
his prayer.
not claiming a square inch of property. But
No, that can
we are
happen.
only saying if the government refixes the boundaries based on the regrant order or the regularization order which has been passed along as per the block numbers, all disputes will get resolved because they should
They may
not.
want to do,
Revenue
they may do it.
department
Government
having
can do
granted
it.
the property should not create disputes. That's
Government
essentially.
can do it if they are doing it. That is not the prayer. That's all I'm saying. Prayer is to do the khata. If the government says, okay, we are going to redo the survey, the government has every right to redo it.
Direction to the respondents to redo the survey.
That is all, my lords.
As per, now whatever it is.
It may not
Lords,
be as
as
per
per-
any of those reports because in those reports, what my friend is
Page 29, look at page 29.
And page 30.
And by
These
virtue of
sketch-
this, particular property is given to you also.
No, my property
In the
sketch is at page 54.
No,
In
no,
fact,
where
kindly
is
just
your
for a
name in
moment
this?
see,
Where is your name in this page 29?
20, no, mine was done later, page 54 is kindly just for.
That is independently done. That's what is the
Yes.
question. Instead
Yes.
of doing
That's
the entire.
Venkatramanappa,
in
son of
entire-
Kondappa.
So where is the
Venkatramanappa,
petitioner at
do
page
it.
number 29? Page 29. I mean respondent's name.
Lord, serial number 6 is respondent. Venkatramanappa bin Bale Kondappa, he is the respondent. Serial number 6.
And where is your name?
And my name is not there itself.
No,
in page 29.
Venkatramanappa bin Bale Kondappa, that is the,
Ah,
yeah,
that is-
that is the person.
No, but that shows 25 guntas. Mine is 1 acre, 10 guntas. So I don't think this is referring to me. My vendor is also Venkatanaranappa, but mine is not 25 guntas. My sale deed shows it's 1 acre, 10 guntas. So I don't think this is mine.
No, there is in the entire.
1 to
this
11.
table, there is no 1 acre 10 guntas.
Yes, that is because that's why I'm saying this may not include mine. They may redo a survey for the whole survey number where they may check even
That
my
is all what
boundaries.
I'm
I have
asking,
no
Lord,
difficulty because
this-
I have my title documents. I have
Lords,
no
wherever
difficulty.
this has been the
But not
practice.
as per this 29.
Where is your representation dated 3/8/2023?
Lords, annexure E, my lords, which
Page
is
number?
at page number 32.
And in fact, that has nothing to do with asking any survey or whatever.
Let's see what is that
Yes,
he's asking.
this is at page 32.
Page 32, my lord, 33 is a typed copy. Only they are seeking for changing of kata.
Yes.
Lords, I told, the reason is unless the khata gets into my name, it is something like, unless a person get married, he will not get rid of the.
We'll
Now,
ask them
unless
if he's
the,
entitled for change of kata, they'll do. Otherwise, no.
In
but
accordance
now it
with-
is something like this. Unless they conduct the Podi proceedings, khata will
Then you
not be changed.
should ask for a suitable relief. then.
Lords, unless, can I request this, my lords?
I'll-
Because I can
I'll
rather.
adjourn this matter
Lordships may have this matter on Tuesday, my lords. I'll just
So that you
ask
can
them.
find
I
the
understand,
appropriate,
holistic relief it is sought for, it will be helpful for both the parties. Lordships.
Is this matter on
Okay, my lords.
Wednesday?
Lordships,
Wednesday?
great.
Yes.
Great.
Cell number 13. Dhananjay Kumar.
For the petitioner, my lordship. Your lordship had directed me to file an undertaking of affidavit stating that I would pay the entire amount, my lordship.
Have you given it to him?
I appear for the respondent number 2 society.
So ultimately, you appear for the society.
Yes,
They are ready to pay the money.
Yes.
That's what you want.
yes.
Take that, give it to him, a copy of it.
Well, I have
I hereby undertake that willing to pay the outstanding arrears within a period of 3 months.
My lord, I have a section for 2 points. One is it is not 15 lakh 10,007. It is 17 lakh is the as on today amount. That is the amount which. The second
is
thing
here.
is,
No, party is in Mangalore.
the second thing is,
Then file a proper affidavit on
yes,
Tuesday.
the second thing is tomorrow is the auction. Let them show bona fide by depositing some amount.
Ma'am, we're ready to pay. We will file an
no,
affidavit.
that's it.
No, the entire amount is 18 lakhs and not. According to, you said it is 15 lakhs.
According
No, to show your bona fides, tomorrow is auction, pay some amount, not the entire amount, some amount. And then later on that condition, I'll stay. And you come up with an affidavit basing on that affidavit, you can dispose of the matter later.
until then, the auction notice may be stayed.
First of all, what is that you're going to pay tomorrow? That you get instructions, pass over.
Cell number 14. Petitious for petitioner.
Petitioner is a temporary lecturer, my lord. On the last occasion, similarly placed petitions also approached this court and interim orders granted.
It's
My
covered
lord
by
had directed respondent to take instruction. The same
an
interim order.
identical interim order may be passed. Identical interim order may be passed, my lords. Similar matter and may be connected, my lords, along with 2131 of 26.
And they pass on the interim order granted in similar matter.
Even now, we have not disturbed the petitioner. The similar
Take
order
that.
may be passed.
Page number 3, my lord. Last paragraph is the
Not to discontinue the service of the petitioner is what the order has been passed. my lords.
page number 3, my lord. Last sentence. May I read, my lord?
Who are the petitioners?
My lords, petitioners are the my lords, the professors, my lords, not a permanent visiting professors. They are
The
working.
counsel for the petition submits are for the similarly in a situated persons. The coordinate bench of this court in WP number 2131 of 2026 had granted an interim order directing the respondents not to discontinue the services of the petitioners, if not already discontinued, till the next date of hearing. When counsel appearing for the respondents does not dispute the fact, hence there shall be a direction to the respondents to not to discontinue the services of the petition, if not already discontinued, till the next date of hearing. This is matter.
Can I seek for liberty, my lord, if in case anything necessary for modification, I seek liberty, my lords.
Yeah, such an order is not at all required. If it is required, you can always come. You file your own you can file an application accordingly. The state list is matter for filing objections. List is matter. The respondents are directed to file their objection. List is matter on 8th of July.
Lord, may I request both the matters may be connected.
Just along with that writ petition.
Great.
When is that writ petition coming up? No date
No
is given.
date.
Date is-
Both along with that writ petition on that day. Yes, 14.
Great.
Obliged.
And what about non-payment of the court fee?
I have complained. My last occasion also I made the mention.
It is submitted with the land council that the court fee is paid. Yes, next.
Great.
So and so takes notice on behalf of so and so. Registry is directed in the name of so and so.
Already.
Yes,
Cell number 15.
yes, 15.
Please, Malas, on
Appeal
the
for
last
the
occasion,
petition
it's
regarding disconnection of electricity on 20th of May. Your lordship directed him to take notice.
Please, Malas, the only ground they've taken is that there no notice was served, my lords, and the disconnection happened in the month of May, my lords. But we have already served them a notice in the month of February, my lords. 3 months, nothing happened, my lords. On the day of disconnection, we disconnected, and that day they filed a reply, my lords. That reply is already on record, my lords. So therefore, they've been aware, my lord, the notice was served on them. After the disconnection is
Why you have disconnected?
the reason is that, my lords, one document is forged, my lord, without having a sanctioned plan, my lords. They've asked for the electricity, my lords. This is the reason, my lords.
My lord,
That may be anyway discussed, my lords. Now that we've given them a notice, they've replied to that, my lord. That may be considered by the authorities, my lord.
Yes.
That is what my submission is.
before disconnection,
What is the reply given?
on 18/5, I have given a reply. 20th May, they have disconnected.
My
Let
instructions
them
are that
consider
18th
my.
May was the disconnection, my lords.
No. When was the disconnection according?
After that, my lords, 3 months before we've given them a notice.
You can't vaguely say after that, after this.
No, my lords, it is only after the disconnection they came running to giving the replies. What?
Date of disconnection.
18th May, my lords.
No, disconnection is on 20th of May. I have stated in para 7 of my writ petition. The representation given is on 18th of May.
20th May,
20th May disconnection
you gave your reply on 18th.
on 18/5.
When was the notice to you?
No, my lord, actually, I have not received the notice.
Then where is the question of reply?
No, I came to know of it, then I given a representation. Now, I have not received it.
When you have not received a reply,
Huh.
how it is the notice, how will you know what is their case and how will you give
No,
a
my
reply?
lord, whatever my submission, I was submitted to the,
What did you submit?
submitted that, my lord, in annexure L, translated copy also on file. Which,
Take that.
no, as far as that area is concerned, it is not in dispute. I have constructed a small 4.
Let us see what is that reply you
What?
said. The complaint by the complainant.
Ah.
Is
They,
that
one Chetan, respondent number 4, against whom a civil judge court order in my favor. That man is creating the problem for me to get the. Chetan has threatened to kill the original owner of fake Biscom connection for more than sites in Kalkare and Banjara layout and has committed page number 4. So, FIR have been registered against him. He had filed a similar complaint against everyone and gave those fake documents. I am the original owner, Mamta, hereby take possession of this.
No, what is, and what is that you will consider? What
Ah.
is?
My lords, the question is, my lords, we have given them the notice on.
What is the purpose of giving this? What is that they will do?
Fourth,
Yes, my
Somebody
lord.
has cheated you, what
Ah.
they will do?
Please, my
now
lords.
fourth respondent against whom there was a dispute in the civil court, I've got an injunction against him. He is making a representation to the BESCOM to disconnect my power connection.
There's a clear title dispute, my lords, which has to be settled by the court of law, my lords. We have nothing to do here. My lords. That is one submission, my lord.
In the
And
meantime, let power be.
Please understand, you write something to them,
Ah.
which they are unconnected with.
My
You
lord,
say somebody has defeated.
Correct. My lord,
What they will do?
I will give a representation, my lord. My lord, I do not know what is there in the Shoka note because I have not received it so far.
But
If it
you
has,
are not
if
staying
it has,
in that building.
if it
Are you
has
staying in
been
that building?
affixed in the building, I do not know, my lord.
Are you staying in that
No,
building?
I am not staying. My
Yes. No, let you please take whatever the notice. Give him a copy of it.
Already
Give
served,
him-
served,
No,
my
no,
lord.
copy kotila.
At this point, no, not necessary to restore the power supply.
Your Lakshmi have it on my way.
Yes, this is matter on 9th of June. The respondent shall serve the copy of the
Notice.
show cause notice dated
Dated 2021 to 2026.
21/2/2026 to the petitioner, and the petitioner shall respond to the same within a week. And thereafter, the respondent shall pass orders. After that, we'll see.
My lord, in the meantime, let there be
No,
a
not
restore.
required. Yes,
I let them give that.
they'll
shop-
give in a day. In a day, you're giving
Getting
it
my lords,
right
I'll
now.
give it right, hand it
The
over right.
respondent has, the counsel, the respondent handed over the copy of the notice, show cause notice.
My lord,
to the petitioner.
now I read this Shoka notice. What it says, my lord, Chetan, respondent number 4 has given a
Whatever
representation.
you want to tell them, please
No,
tell
my
them.
lord, that is the only the
That you
Shoka.
can tell them now, please.
No, no, my reply is according to this Shoka
You have
notice.
not.
Which means they've received
Ah.
them.
No, in the Shoka notice,
Show cause notice. yes.
Shoka notice what they say, Chetan has given a complaint for disconnection. Therefore, we are, it is in Kannada, my lord.
What is this? What complaint he has given?
Chetan has given a complaint.
One, he says that there is title dispute, my lords. And second, that they don't have any sanction plan, my lords. So based on the sanction plan, therefore, we are not supposed to issue any temporary connection, my lords. That the Supreme Court has laid down, my lords. It's come heavily down upon any unauthorized construction, my lords. So therefore, we gave them a notice that this is the allegation against you. Is there anything you give them?
You have a sanction plan from the.
No, my lord, as far as that is concerned, up to the 1,200 square feet, that is not required. My area is 4,000. I am not constructing the building. A small 450 square feet.
For that you respond.
Please,
In
ma'am.
that notice, forgetting about that, what is the dispute between you and that other person, about that second limb of it, it is there. So for both, you respond. Yes. Next, give the copy to him.
My lord, can it be had earlier, my lord, on
The matter on 8th June.
one day?
Yes, next.
Cell number 16. Prithvi Pralhad Katrina.
Lord, there is an urgency in this matter.
On the maintenance of
My
welfare.
Lord, there is a,
Yes.
My lord, counter is always open for receive the files complaints. my lord. Let him go, my lord, we will receive.
The
my Lord,
petition.
we are,
He said it's open for the writ petition is filed. Sing the following prayer. It is a grievance of the petitioner that when the petitioner has approached the Assistant Commissioner under the Senior Citizens Act, that is Maintenance and Welfare of Parents and Senior Citizens Act 2007, on the ground that it is vacation. They have not entertained the case of the petitioner. They entertained the application filed with the petitioner. On the last occasion, when the matter came up, this court has directed the AGA to get instructions in this regard. On instructions, it is submitted that the office of the Assistant Commissioner is very much working. There is no vacation for the same.
Yes.
And if the petitioner, and according to his instruction, they have not stated so. They have not stated in the said manner.
Lord, the senior,
Accordingly, the writ petition is disposed of, directing the Which respondent?
Respondent number 2 to take quick action. my lord.
To respondent number 2, to consider the application that's filed by the petitioner under the act in accordance with law.
Cell number 17.
My lord,
Rajesh.
kindly for hand delivery.
Why you
Memo.
want hand delivery for that?
Let him go, my lord. I'll telephonically.
He will inform.
Please.
Yes, 17?
17. Mohan Raj.
I appear for the petitioner. But this is the matter where the cancellation of speed was
My lord, yeah.
challenged.
Meantime, office objection shall be complied with.
Lord, I shall comply the office objection.
Basing
with
on
it.
the application filed with the father, the court and has passed an order not to alienate the property. So they died. Thereafter, the mother made it. Yes,
As per the communication made by the assistant commissioner, my lord, the.
you can use the mic. I'm not able.
Sub-registrar, my lord, sub-registrar is present. Come, Undevan.
Use the mic.
Yes, ma'am. Sub-registrar is present before the Sanabha court, my lord.
Let a government advocate
Illa, idella.
shall place the order, if any, before the court. Let the commissioner under the maintenance has directed the registrar to cancel the gift deed. If there is no such order, the registrar shall appear before the court with relevant record.
Yes, ma'am. Sub-registrar
He
is.
he has an
present.
order with him. Ask him to
Sub-registrar
come.
is present.
Ask
But
him.
there is no order, my lord. Here, what
To
happened?
do so.
Yes, ma'am. I'll explain, ma'am. Here, what happened, my lord, the assistant commissioner, my lord, on
Annexure H.
Annexure H. He has communicated to the sub-registrar saying that, my lord, the matter, the proceedings before the assistant commissioner has disposed of, the gifted has been cancelled. Therefore, it has to be entered into the registration login. There
Where
is
is
a
that communication?
this communication, my lord. This
Take
is
that.
Kannada, in Kannada, my lord. There is a.
I've produced a translated copy of it in the last state of Annexure H.
And have you asked this, the assistant commissioner's office that whether any order is passed?
My lord, that is the mistake, my lord. Apology, my lord. He is tendering apology. That is the mistake, my lord. He has not
No, it is not a mistake. It is not a.
He has
it
not
is not a
verified.
mistake.
Here, my lord.
Whoever has done it, there has to be an action on them.
Here, my lord, what happened, my lord? Thereafter, the miscommunication.
It is either it is a mistake of the assistant commissioner or it is a mistake of the registrar.
My lord.
Whoever has committed it has to face the consequences. Who is the concern, which the principal secretary has to look into this and take action against both.
Miscommunication, my lord, with
No
regard to.
miscommunication. He needs to have an order. No communication is required.
Yeah, what
Unless and until there is an order before him saying that the gift deed is set aside, he cannot do this.
Gifted not at set aside.
Then why
In
did
the-
he do it?
In the login, my lord, there is an provision in the, my lord, the Registration Act, section 17, my lord, says, my lord, 17(3). A separate file shall also be maintained for communications received from the officers of the departments, that is assistant tribunal, my lord, intimating the cancellation, modification or rectification of the transaction evidenced by papers
No,
previously
whether
filed
whether the cancellation of a gift deed is now effected in the registration department
It
or
has
not.
been effected. Thereafter, now, my lord, thereafter, my lord, after we came to note, it is a.
We will not go thereafter. What has happened, on what basis it is done is the only question.
Yes, my lord. In my lord, first page, my lord, we have already modified, remodified. It has been cancelled, my lord. Now, which is the cancellation file has been filed. It has been restored back. It has been restored back. We have restored back. In page number 1, my lord, first page, my lord, we have restored. On communication, my lord, next page, my lord, next page.
So how come a officer
There is
works
a
like
provision, my
this?
lord, there is a provision under
What
section
provision?
17. If any mistake
What is a mistake in this?
occurred
You
by
tell the court.
the officials,
No, what is a mistake in this?
my lord, it is a mistake by the, my lord, assistant commissioner has given a.
How can you call it a mistake?
Yeah,
How
my
can you
lord,
call it a mistake?
miscommunication, my lord, they failed to understand the orders of the,
There is no order. Problem is
there is
there
no
is
order,
no
my lord,
order.
there is no order. But
Without,
yeah, my
no,
lord,
no,
what
you,
happened?
you can't call it a
5/11/2020
mistake.
5/11/2020, my lord, there is an interim order, my lord, there
No,
is an
there is an
interim.
order. He understood the order in
Not
a
to
different
alienate.
way. No, he understood the order in a different way. That I can understand.
Yes, ma'am. But my lord, both the officers,
Cancellation
my
of
lord,
the sale deed is not, you can't understand not to alienate will as a cancellation of the sale deed.
Both
And you
the-
can't call it a mistake.
both the office, my lord, in here, my lord, tribunal, there, my lord, sub-registrar, my lord, tribunal has communicated. Based on the communication, my lord, the sub-registrar has deactivated, file a registration, my lord. There, they have not cancelled. Simply, they have filed a, what is that, modification of order.
Rule 17(3) of.
Hmm?
As per Rule 17. My lord, EC has given a direction to enter that this gift deed is cancelled in 25.
Yes.
Whoever has given it, he has to face it. Who has given that direction?
AC has
AC's
given a
office,
direction.
AC's office.
AC office.
AC.
Yes.
Yeah.
Where is that communication from the AC?
That's what I have submitted.
Then what if,
Annexure,
where is your,
G, my lord, annexure
150
H, annexure H, my lord.
Annexure H.
then why did he give such a communication?
Hello?
Your AC, why did he give such communication?
Now, my lord, I have to depend both of them. Here what happened, my lord,
Here
there
it
is
is,
a some
you are an
mistake.
officer of the
There
court. It
also,
is
my
not,
lord,
you are not here to defend them. First of all, you are an officer of the court. You have to argue before the court and submit basing on what is the facts. What are the facts of the
Fortunately,
case?
my lord, it is a mistake. Unfortunately, my lord, it is a mistake.
Where is the assistant commissioner?
Assistant Commissioner, my lord,
List this matter on Wednesday as parted. Interim order earlier granted is extended.
No
On the day, on Wednesday, the assistant commissioner shall be present before the court with the relevant record pertaining to this case.
My lord, no interim order was passed in the last.
Not to take, I said so.
No, my lord, no interim order is.
yeah, my lord, we have already rectified.
Already that you are,
We have
it is
rectified, my lord,
stated
there
that
nothing will happen.
the registrar is present before the court, deputy registrar.
Assistant Commissioner.
No,
Yeah, sub-registrar.
Sub-registrar is present before the court. It is submitted that they have already rectified the mistake that had taken place earlier.
As
And
per the AC, again they have.
Again, my lord, AC has given a communication saying that we made a mistake.
Cancelled, it
Please
is,
rectify all those things.
That's why.
Based on that communication, my lord, we have rectified.
This is only filing under Rule 17(3).
then we'll allow your petition.
Therefore, my lord, it
One
can
more
be.
aspect is, after the cancellation is recorded, respondent number 3, mother, executes a fresh gift deed in favor of the respondent number 7, granddaughter, who is daughter.
Consequences of it
All
is
those
like,
things may be
Please,
civil court, my lord.
no, it is gone.
Please.
We'll allow your petition.
Maybe
We'll pass orders.
disposed, my lord, please.
But you have to be careful.
Please,
This kind
sorry,
of
No, my
basing
lord.
on communications you can't do.
Being.
You have to look at the order,
Yeah,
isn't it?
yeah.
You have to convince yourself and look at the order. Then you should enter, not because somebody said something.
Apologize.
Yes,
Sorry.
allowed. Writ petition is allowed. There are no unofficial respondents in this.
No, my lord.
My lord.
Any respondents are there apart from the official
Yes, my
respondent?
lord.
Yes, my lord, there
Children
are
of the late
respondents.
father as LRs is arrayed, my lord.
Here what happened, my lord, thereafter, my lord, father also died, my
The
lord.
notice, the issue notice to the so and so takes notice on behalf of AGA takes notice for other respondents, issue notice. This is matter as part heard on Thursday,
Please.
That's
Watch out.
on not Thursday, list it on 11.
11. Yes.
Lords, there be status quo in respect of the scheduled property because
Please, ma'am.
respondent number 3 and 7
Oh,
are,
why do you
they
require all
have
that?
demolished the outstanding.
Doesn't require, now that whatever is your relief,
Please,
that is already worked out
Please.
as they have already set aside that order.
please.
Yes, my lord, we have rectified. Let
Yes,
him-
yes, next.
Lords, in view of section 27, my lord, there is a bar to the civil court to pass any injunction orders. Therefore, I'm seeking.
You want
status
everything
quo.
to be decided here.
No, my lord, there is an
That is
express
not
bar.
the question. That you have not questioned that before this court.
My lord, I have challenged the gifted also.
How can you challenge that?
As a consequence of this cancellation, the
We
mother.
will see on that day.
Lord, let there be status quo, my lord.
No. Yes.
18 Sheshakartik.
Watch out.
I appear for the petitioner's counsel. The last occasion, my lord, your lordship said directed us to, my lord, serve copy on the Assistant Solicitor General. We have
Yes.
already done that.
Serve a copy of the writ petition, the council Sri Shanti Bhushan.
Yes, my lord.
Yes, where is the council? Shanti Bhushan.
Shanti Bhushan, my lord.
His name is there, name is not printed.
It's printed.
Printed, my lord, DSG,
Yes, then where is he?
central government. I'll inform.
Inform them. Paso.
Central government.
Yes, Paso.
Serial number 19 is for serial number 20. Alakrishna MR.
I appear for petitioner, my lord. My lord, petitioner, my lord, is seeking extendment of his earlier parole granted by this honorable court. May I request my lords to, my lord, take page number 10, my lord. Petitioner, my lord, approached this honorable court, my lord, in WP number 4474 of 2026. And my lord, this honorable court, my lord, were order dated 24th March of 2026. My lord, granted parole for 60 days. Now, my lord, I am seeking extendment for another 30 days. Since, my lord, my mother, my lord, is suffering from, my lord, paralysis. Hence, my lord, I am seeking, my lord, extendment of another 30 days, my lord.
What is the
My
instruction?
lord, once, this is, my lord, I have not received copy, but I have seen in the CCMS, that is a, up to, my lord, 6/6, there is a, you have is in the parole, my lord. It may kindly have done first week of third or second, my lord.
My
Third or
parole-
second,
my
second, my
parole
lord.
will be.
Till 6/6 he has the
Yes, my
parole.
lord. Till 6/6.
This is matter on Tuesday. AGA takes notice on behalf of the respondents.
Please.
Yes.
Serial number 21. Stella Kaushik.
This matter. Matter, no? You send it to the, have to order some conditions. Yes.
My lords, for the petitioner in this matter, on the last occasion, my lord, the question was, can a writ petition of this nature be maintained against a private limited company, challenging the posh rules, my
You
lord?
wanted to place a judgment?
Yes, my lord.
Pass off. Have you given him a copy of it? AGA?
Yes, ma'am.
Yeah, which one? 21.
My lords,
In this writ petition, Union of India is a party, Karnataka State Transport Authority is a party.
yes, my lords. But there, another question was, my lord, the petition was against Ola, my lord. And page 50, my lord, of the judgment, the court has answered in the affirmative, my lord. Paragraph 17. Petitioner in her first prayer has sought direction to
One minute,
ICC.
let me look at paragraph number 17. Yes.
Petitioner in her first prayer, page 50, my lord. Petitioner in her first prayer has sought direction to ICC to inquire into a complaint dated 30/9/2018, produced at Annexure F in accordance with the provisions of the POSH Act 2013, which is resisted by ICC and Ola by questioning the very maintainability of the writ petition against them. And para 18, my lord, Apex Court in the case of St. Mary's Education Society and so at paragraphs number 75.1 has held as under. An application under Article 226 of the Constitution is maintainable against a person or a body discharging public duties or public functions. The public duty cast may be either statutory or otherwise, and where it is otherwise, the body of the person must be shown to owe that duty or obligation to the public involving the public law element. Similarly, for ascertaining the discharge of public function, it must be established that the body or the person was seeking to achieve the same and for the collective benefit of the public or a section of it, and the authority to do so must be acceptable by the public. And further, my lord, reliance is also laid on Andi Mukt Sadguru versus V.R. Rudani and others, my lord, wherein at para 20, at page 51, my lord, it goes on to hold the term authority is used in Article 226 in the context must receive a liberal meaning, unlike the term in Article 12. Article 12 is relevant only for the purpose of enforcement of fundamental rights under Article 32. Article 226 confers power on the High Courts to issue writs for enforcement of the fundamental rights as well as non-fundamental rights. The words any person or authority used in Article 226 are therefore not to be confined only to the statutory authorities and instrumentalities of the state. They may cover any other person or body performing public duty. The form of the body concerned is not very relevant. What is relevant is the nature of the duty imposed on the body. The duty must be judged in the light of
Act, POSH Act 2013. Act.
Check, sir.
may I continue, my lord? POSH 2020, 13. My lord, if section 11 of the act may be looked into, my lord, the duties imposed by on the IC.
One minute. Yes.
My lord, if your lordship is convinced on the maintainability aspect, my lord, if I may move on to the facts, my lord. My lord, the question before your lordship is, my lord, the issue stems from the fact that an internal committee is constituted against the statutory framework, my lord. Section 9(1) of the POSH Act mandates that when a complaint is filed, there is a statutory time limit within which it has to be filed, my lord. That is, when a date is alleged in a complaint, within 6 months of that particular date, my lord, a complaint has to be filed. Now, in this matter, what has happened is, my lord, the primary incident, if your lordship were to look at the complaint, my lord, the complaint is at Annexure C, page number 31 to 32. The date of incident is August 2024, and the complaint is filed on 12th of February 2026. 18 months after the statutory limit is exhausted, my lord. That amounts to almost after a period of 531 days from the first alleged incident, my lord. And my lord, the very first thing that the committee needs to do when a complaint is filed at a delayed state is to pass orders on the condonation of delay, my lord. No such orders have been passed. Cognizance is taken. And my lord, the petitioner raises several objections throughout the course of the inquiry. That is not addressed at all. Even in the final report that the committee issues, that very issue is not addressed, my lord. Point number 2, my lord, the committee, the POSH rules section 4(2)(c) mandates that, my lord, that the committee, that the members of the committee should not have any association with the company, my lord. And my lord, the conflict of interest, the very first aspect is, my lord, the person who sits as the chairperson, she is a witness and she is named in the complaint, my lord. If your lordship were to look at the complaint, my lord, at page number 33, my lord, Annexure C, she is in fact named as a witness and she sits as a chairperson, my lord. And her signature also appears in the final report where she signs off as the chairperson. And the external member, my lord, who sits on the committee also is a registered vendor with the company. And the rules mandate that, my lord, the external member should not have any association with the company, whereas she, as an external member, is a registered vendor. And not only that, my lord.
Stage now.
My lord.
What is the stage now?
My lord, I have been terminated, my lord. And my lord.
When was this termination?
On 25/5/2026, my lord. And my lord, the shocking factor is this, my lord. When all of this is happening, I bring this to the notice of the district commissioner, who is in charge of the IC committees that are there within the companies. And an inquiry is pending there before the district commissioner. While the inquiry is pending, my lord, they terminate me from employment, my lord. And my lord, furthermore, what happens is the district commissioner has been in.
What we will do is, we will issue notice. Please take out hand summons. Immediately, I'll give a date on Wednesday.
Obliged, my lord. My lord, if the only issue being that,
No,
my lord,
you already, termination is already done.
no,
Now we'll
my
not
lord,
pass
just one last submission, my lord.
Yes.
The only issue is that, my lord, he's been an employee for the past 20 years of the company, and now several of the vendors who he has brought into the company, my lord, they are contacting him and asking him with regards to the termination, and he's unable to answer anything, my lord. And my lord, if the termination could be stayed, my lord.
That can't be.
My lord,
When this this writ petition is filed against AT&S India Private Limited and when this court has, as a petitioner, with regard to the maintainability of the writ petition, he has relied on an order passed by a coordinate bench of this court in WP number 8127 of 2019, dated 31st September 2024. It is submitted that in gross violation of the procedure contemplated under the sexual harassment of women at workplace, within brackets, Prevention, Prohibition and Redressal Act 2013, the petition is terminated from service. The petition has pointed out various various latches in the said inquiry, and it is submitted that the petition is terminated from service, and there may be hence the same may be the said order of termination may be suspended. This court is not inclined to grant an ad interim order. The petition is permitted to take out hand summons on all the respondents.
My lord, just one last submission, my lord. The external member is actually the company's own advocate's wife, my lord, and she sits as the external member, my lord.
That all will consider. The registry is directed, the notice to 1234 In addition, petitioner is permitted to take out hand summons on all the respondents. List this matter on, you want it on 5th or 8th? 8th would be convenient. We have to take notice to all of them.
8th, ma'am.
Yes, 8th.
Published.
Number 22.
Give him that book. Yes.
Number 22.
Lord, I appear for the petitioner. This is pertaining to the affairs of Karnataka Rural Infrastructure Development Corporation, which is popularly known as Land Army. Land Army. The Land Army has got a power to execute the work
Yes.
under KTPP Act. The petition number 1 is the executive engineer, and petition number 2 is the
Order
assistant.
dated 23/9/2025.
Yeah, yes, my lord. Annex A is the inquiry order by a retired district judge.
18/5/2026.
Is a retired district judge. He has conducted the inquiry. Meanwhile, Lokayukta has instituted a suo motu case. In the suo motu case, the honorable, the coordinated bench of this court in page annexure, yes, page 384, has directed them to not to take any precipitative actions against these petitioners and other petitioners. Annexure, yes, page 384, my lord. The Lokayukta also had a suo motu inquiry, and in the corporation also appointed a retired district judge to investigate
No,
the matter.
anyhow, that is state, and why this should be state?
No, no, my lord, here the first show cause notice was issued to this petitioner. They have replied for the show cause notice. Pertaining to after the reply of the show cause notice, inquiry was conducted. In the inquiry, all the documents which are part and parcel of the head office were used, and on the based on that document, they wanted to, the second show cause notice has been issued to us. There is a very danger of removing us from service or keeping under suspension. That has forced me to approach this honorable court, my lord. Even in the inquiry also.
Yes. What are your submissions?
Instruction.
Get instructions, I'll have it on Tuesday.
Please.
List this matter on Tuesday.
Respond number 1, I'll accept.
Show cause notice may be stayed.
No, let it come on Tuesday, let him get instructions.
Respond number 1, I'll accept.
Respondent number 1,
Two
AGA
and
takes
three.
notice to,
1 only, my lord.
2 who appears?
2 and 3, my lord, Yogesh D. Naik.
So and so, write the name and give. So and so is directed to take notice, registry is directed to print his name and counsel for the petition, serve the copy of the petition on the council. List this matter on Tuesday.
Meanwhile, we are not to take them.
Tuesday, yes.
Cell number 23. Javides.
Hearing for the petitioner, my lord. Petitioners are working as FDA and staff nurse under various schools, my lord, and respondent number 4, my lord. Karnataka Residential Educational Institutions, my lord.
In the other matter,
Please,
what happened? There is some other matter has come up today.
Yesterday.
it is adjourned, my lord, to
It's adjourned.
Tuesday, my lord.
Huh?
Not here, there is an apprehension for the petitioner that they might be disturbed or they might be relieved, my lord.
Because Karnataka Residential Education
Please,
Institution. Morning that matter has come.
Adjourned to Tuesday, my
He
lord.
he took notice, my lord. Then it has been adjourned to.
Is that, which
First
item?
serial number, my lord.
Look at it.
Siddharth Kapura. 2, my lord.
What happened to serial number 2?
4-6. 4-6.
4-6.
Yes.
The petition is directed to serve the notice on AGA takes notice.
Notice, my lord, 1, 2, 3.
AGA takes notice
1, 2, 3.
on behalf of respondents 1 to 3. 4 and 5 also.
Five,
Social welfare.
Siddharth Babu.
5. Huh? 5 is social welfare department.
5 is also, my lord, social
5.
welfare department.
4.
Karnataka.
So and so is, what is the name of the advocate?
Siddharth Babura.
So and so is directed to take notice. List along with that serial number 2.
Yes.
2 on 4th.
Lord, there is an apprehension for disturbance, my lord. Not to.
I have not granted interim order in that. So no interim order in this also. Yes.
No blood.
Cell number 24.
This matter, my lord, since 1983, since 43 years we are in possession of the agricultural land, my lord.
Hmm.
My father had entered into an agreement of sale, a registered agreement of sale, and put in possession of the
Order
property.
dated 29/4/2026 passed by.
The learned second respondent, deputy commissioner, my lord.
Hmm.
He has, in the revenue petition filed by me, revision petition, a memo has been filed by the fifth respondent, who is the respondent herein, filed a memo seeking permission to cut and use the sugarcane plants grown by me. For that, he has granted permission, and he has also directed the learned SP to give police protection. It is my revision petition. And since 43 years, I am in possession of the property, my lord.
Who is under the benefit of interim order, my lord, is the subsequent purchaser.
Huh?
He is a subsequent purchaser.
Hmm.
Therefore, my lord, he has produced the sale deed along with Kata. Therefore, my lord, we have given it.
She has purchased it from some stranger who is nothing to do
Whatever,
with
my
the
lord,
property.
Where is that order? Let's see.
My lord, annexure D, my lord. Kannada is
Annexure D, my lord.
What it says?
Yes, my lord, is the subsequent purchaser. He had a revenue documents. Hence, he is entitled to.
Where are your documents?
I have produced the registered agreement of sale at Annexure A.
Sir?
The registered agreement of sale, registered in favor of my father. And
Agreement of sale will confer a right on you.
I have put in possession of the property. However, I have not filed a suit for specific performance.
What is to the
And I have
respondent?
also filed an injunction suit. An injunction has been granted by the jurisdictional
alienation.
court not to alienate it.
Notice
Has
to
been.
respondents 1 to 4, AGA takes notice.
Yes,
Fifth respondent notice. Does this matter on 24th of June?
25.
Yes.
This is patent, Lord, administrative, rather judicial error committed by NCLT. Lord, we had moved, my lord, I am a government company, a company owned by, my lord, the government. It's an age-old company. A reduction of share capital was necessitated. We filed an application before, my lord, NCLT. NCLT allows the application, disposes of the case finally. Your lordship sees, my lord, page number 23 for a moment, my lord. I will not take more than 2 minutes. Your lordship sees page number 23, my lord. This has the complete detail.
Yes.
Your lordship sees, my lord, CA number 66 of 2025 is the case, and my lords would then see petition presented on 21/4/2025. Last date of hearing was on 30th/4/2025. Order delivered on 1/5/2025. My lord, then order reads, an application has been filed on behalf of filed on so and so under section 66B, etc. of Companies Act by Mysore Lamp Works Private Limited for prayer to permit the petitioner committee to pay off the shareholders holding 5.6% of public shares at the rate determined in the valuation report, and allowed the petitioner company to deposit the said amount, etc. Petition was heard in detail, and my lord, it was completely allowed. Your lordship sees, my lord, page number 26. My lord, the bolded portion, the petition is allowed subject to the condition, and my lord, conditions were all complied by us. The matter is totally disposed of. Now, my lord, after this disposal, my lord, suddenly what happens?
Where are you reading? Page number?
I am reading at page number 26, my lord, the final operative portion.
Proof of opening of escrow account.
Yes.
Deposit of directed amount to fund.
Yes. The petition was disposed of.
Uh,
Now we completely complied with this order. My lord, it's a government-owned company. We comply this order. Unfortunately, what happens? Your lordships now sees page number 44. After my luxury length of time, somebody comes and files an application, recall this order.
40?
Page number 44. 44, my lord.
Hmm.
A company, my lord, by name 3A Capital Services Private Limited, my lord, claiming to be that indirectly I hold some little of the shares in this company. There is an order passed, recall the order. Now the NCLT does, my lord, the impugned order. Your lordship sees, my lord, page number 21, annexure A. I don't know where the NCLT would get this kind of a jurisdiction, or once the matter is already disposed of. There is prohibition under law that once the final order is signed, the court becomes functus officio. Page number 21, the same NCLT, my lord, says, now as I am taking this application, don't precipitate in furtherance of that order. An order which has reached its finality, the court cannot, my lord, try to rewrite the order. There is a direct prohibition under the NCLT rules and under the general law.
So where is that order?
My your lordship sees that order on page number 21, my lord, 21.
21, what it says?
My lord, entry 3, my lord, on page number 21, parry 3. In the peculiar facts, let no further steps be taken in furtherance of the impugned order. At the final order, after the disposal is impugned before the same tribunal, the same tribunal wants to, my lord, once again wants to recall and rehear the matter. Lord, this is unknown to law. That's the reason, my lord, the Honorable Supreme Court has been repeatedly, my lord, I'm sorry to say this, my lord, complimenting the working, my lord, style of NCLTs. An order is passed, now the same NCLT wants to recall. Lord, this is not, Lord, there's a direct.
Under which provision of law this is done?
There is absolutely no provision of law, first of all. And NCLT, my lord, grants indulgence on this kind of an order. That too against a government company. The last order which was passed, final disposal, the order is completely acted upon. The government of Karnataka goes ahead, pays back all the shareholders.
No, you're showing that application.
Yes,
That
your lordship
application
sees,
is
my lord,
filed
the,
under which provision?
the
Let us see
recall
that.
application. My lord, this is under the general provision of the NCLT rules. My lord sees page number 44, 44. My lord, this is an application. Under rule 11, my lord, rule 11 of the NCLT rules, my lord, is a general provision. Your lordship sees, my lord, rule 11. NCLT rules, my lord. My lord, before your lordship sees rule 11, my lord, I have just flagged rule 154. It's a direct prohibition, my lord.
Rule 154.
Rule
rectification
154.
of order.
Only the arithmetical errors, my lord, which is a general power to, my lord, correct the orders as available with all the plenary courts is available. Except that, my lord, the entire order can't be recalled. Neither it can be corrected.
So what is the prayer in this page number 44?
Page number 44 is to recall the original
What-
order.
Let's see that. The
If
prayer.
your
let's see
lordship
why
sees
they
the
say-
prayer which is on, the prayer, my lord, is noticed.
Recall the order passed by the tribunal, including
Yes.
company application as modified by the
It's a
order.
very lengthy application. My lord sees the relief sought at page number 60, 60. Recall the order. That's as good as recalling the
Rights are agitated here.
Yes. Recalling the judgment, my lord, is an impossibility. Lord, can I ask the court to recall the judgment?
Please come. The petitioner is before this court, questioning an order passed by the NCLT, whereby the court has directed no further steps to be taken in furtherance of the order dated 1/5/2025. Then a senior counsel appearing for the petitioner submits that. Where is that 1/5/2025 order?
1/5/2025 order, your lordships has it on page number, my lord, 23, 23.
Get that. On 1/5/2025, an order is passed by the NCLT and the petitioner has complied with the same. Then some third party has come up with an application seeking review of to recall the said order, and by order impugned, the NCLT has entertained the same and further had passed an interim order not to take further steps. It is submission of the senior counsel that once an order is passed, unless as per section 154 of as per rule 154, only the clerical or arithmetical mistakes can only be rectified by the tribunal, but the tribunal has no authority to recall its order. And the impugned order is beyond the jurisdiction conferred on the tribunals. Considering the submission of the senior counsel, there shall be stay of all further proceedings pursuant to the order dated. This is order dated?
Lord, this is order, this impugned order is, my lord, 29/4/2026.
29/4/2026 till the next date of hearing. Notice to the respondents. In addition, petition is permitted to take out hand summons. This matter on 19th of June.
I'm greatly obliged.
Number 26, Anupam Agarwal, for petitioner.
Yes.
Your Lordship, this is with respect to challenging the order dated in prayer C, 29/4/2026. Your Lordship, the petitioner is the husband of the respondent.
What is the amount granted?
Lordship, 25 lakhs.
25?
25 lakhs, in which 15,000, there was a arrear of dues.
Where is that? Come to that order. Page number.
Page number What, two, 280, 279, Your Lordship, to be more precise. Your Lordship, in this case, there was a order granted for maintenance pendente light under Section 24 of Hindu Marriage Act.
This is a final order.
This is not final order, Lordship. I am challenging the interim order. In
Where
which
is the interim order?
This is the same order, Lordship. In page number 2, it starts from 279. It's an interim order.
Order starts at 247.
No, Your Lordship, 279.
247?
279, page number. There are multiple other orders for references, because this case has multiple cases to be referred.
You are questioning an order passed in execution.
Yes, Your Lordship.
Hmm.
Your Lordship, the issue is like this. The trial court has passed an order of 25,000 rupees in the year 2021, in which 15,000 was for the daughter and 10,000 was for the mother. Now, I am already paying a amount of 25,000 to the daughter from 2019 itself. So if I am already paying an amount of 25,000, that is more amount in the another proceedings, why should I be liable to pay?
That questions you will not ask in execution.
Execution, for that
Cannot ask.
I
When there
agree
is
to
an
this.
order, when there is an order staring at you, you have to pay that.
Yes, Your Lordship, I come to that point also. So subsequent to which I have went ahead and filed the writ petition before the Honorable High Court. High Court has dismissed and I filed the writ appeal. During the pendency of the writ appeal, since I have not made the payment of Section 24 amount, the trial court has dismissed my divorce proceedings.
An order that is passed in a family court writ petition, you preferred a writ appeal.
Your Lordship, I have filed because there was a gross error with respect to the finding, because they have not taken into consideration the fact that I'm already paying.
According to you, an order that is passed under WPFC, you can file a writ appeal.
Writ petition I have filed because there was a gross.
It's more or less, it's a GMCP, it's a instead of CP, it's a CR revision. It is numbered at WPFC. There won't be any appeal to the division bench. Appeal goes to the Supreme Court.
So that was pending before the High Court, and during the pendency, this.
First of all, now the point is very clear. There is an order.
Yes, Your Lordship.
That order execution is sought. You cannot question that order saying that I'm paying something else. Why should I pay? You should pay the amount as per the order that has attained finality.
But Lordship, I am being double paid, Your Lordship, because
we can't.
Because I am paying the child maintenance from 2019 itself.
Petition is permitted to take out and summons on the counsel appearing for the respondent before the executing court.
Because in the
to that effect.
At least my restoration of the restoration
once a
of
memo
the
is
petition.
filed, list is matter. Yes.
27 adjourned, 28.
Yes.
My lord, I am appearing for the petitioner in this matter. My lord, I am a BISCOM employee, my lord. In this petition, I am challenging the order of suspension, my lord. Very interestingly, the
Have you served
suspension
the papers on the
Yes, my lord, I have
respondents?
served those papers. The acknowledgement
On
is
whom you
here.
have served?
On the BISCOM, I have served, my lord, to their legal team.
Who is the counsel?
PL Sanjeev.
Huh?
PL Sanjeev.
To their legal team, I have served, my lord.
When is the order?
My lord, the order is passed on 16/5, my lord. I've received it on 21/5.
Can you all have it on Monday?
My lord, there is some urgency in the matter.
There is Lissus matter on Monday.
My lord, if I may request for
It is
Tuesday, my lord.
Tuesday, Lissus matter on Tuesday. Print the name of Mr.
PL Sanjeev.
So and
My lord, if I may, one indulgence, if I may ask, my lord. Now they are asking me to hand over the charge to another person, my lord. There is clear bias in this matter. I can point out in the matter.
That's what I'm saying. Counsel is not here. Tuesday, he'll get instruction. On that day, you can argue. Yes, Tuesday, 29.
Number 29. Yes.
A petition is an educational institution, my lords. By virtue of impugned communication at annexure P and memorandum at annexure Q, my lords, they have sought to restrain the petitioner from taking admission of students for the academic year 2026-2027, my lords. And the main premise of the report is one FIR registered against
What are this? What are the facts?
the facts. Basically, they are making an allegation was made by respondent number 5 against the petitioner institution, my lords, stating that they have forged and submitted fabricated documents to the education department for the purpose of procuring permission, my lords. The allegation is that Panchayat has not granted approval for construction of the building, my lords, and a fabricated sanction plan has been purported to be filed with the petitioner, my lords. And FIR was registered in the year 2024, my lords. But till date, as per the knowledge of the petitioner, no final report has been filed, my lords. Now, on the basis of the said impugned FIR, my lords, this impugned communication has been issued by respondent number 2 to respondent number 3 to take
Stating that?
respondent number 2 to respondent number 3, my lords.
What did they say?
They say to take coercive steps, my lords, to restrain petitioner from taking admission of students for the upcoming academic year, my lords.
You have the permission from the Panchayat?
Permission was taken, my lords. Even sanction plan produced at annexure E3, my lords, page number.
No, where is the permission from the Panchayat?
No, that's the allegation they're making, my lords.
Forget about their allegation. To give you an interim order, show something to show that you have permission.
Annexure E3, my lords, that's the copy of the approved sanction plan.
Page number?
Page number 73, my lords. Annexure E3. The lordship permit,
No, this is not the, this is a, how can you call it a permission? Permission from the Panchayat department to construct the Panchayat.
like building sanction plan, my lords.
Where is that?
Yes, my lord, that's the annexure E3, my lord. That's the sanction
Annexure?
plan, my lord. Annexure E3 and hard copy.
Yes,
of
who
the plan.
appears?
Lordship, as per the annexure fee, Lordship, the documents are all forged, my lord, and uploaded in website, Your Lordship, and took the permission.
No, is it somebody's complaint or on your verification?
No, even though FIR also done, Your Lordship.
FIR is registered at whose behest? Your behest. You are the complainant.
No, I am not the. I am not the.
Some third party has given a complaint. On that basis, if somebody gives a complaint, how can that be a basis? Have you asked for, have you given a notice to him? Have you sought for any explanation from him? That can't be the basis.
Lordship, I get the information, Lordship. Just
Get instructions. List this matter on Wednesday.
No, so in the meantime, let them not take any.
No, nothing will happen in meantime. In 2 days, what will happen? The respondents, all respondents you appear except for?
Respondent number 5.
1 to 4, Your Lordship.
For respondent number 5 will be taking the notice, my lords.
You take notice for respondent number 5. So and so is directed to take notice on behalf of respondent number 5. 1 to 3, HCGP takes notice. 4, notice to 4, petitioner is permitted to take out hand summons. Yes, next.
Because academic year is commencing, my lords. That's the only reason.
But we can't put the life of the children in. Let it come on that day. You can ask for. You can argue your case. Yes.
Serial number 10,
What's serial number 10?
30, Sundaram.
For petitioner, my lords, in this matter, we had engaged a senior counsel. Due to some emergency, he is unable to appear. On 2nd, my lords, Tuesday.
Just on Tuesday.
Grateful, my lords.
31, 31,
My lords, for the petitioner, my lords. My lords, my bank account has been freezed by the respondent number 5, my lord. This is writ against impugned order, annexure A, B, and C.
Who is the reassessment order?
Reassessment order is dated on 3/2/25, my lord.
Why are you questioning now in the
My
vacation?
lord, my bank account has been freezed on 13th of March this year, my lord.
What are you doing from 13th March?
My lord, this has been an ex parte order, my lord.
In your
Annexure page number.
I will take notice and let it called after
yes.
next week. And my name is Thirumal.
1 minute.
Page 36, my lord.
No, I'm not going to grant any order.
Copies have to be served.
1 minute. You appear for
Income tax department.
income tax. So and so.
So all 1 to 5, I think.
All 1 to 5? Yes.
The bank, I don't appear.
Bank is, yes, 6. 1 to 5. So and so accepts notice. 6 and 7, notice to 6 and 7. This is matter on 8th of June.
Much obliged.
Number 32.
Appearing for petitioner. The third respondent has passed an eviction notice, my lord, to the petitioner in contravention to the order passed by this honorable court, my lord. My lord, kindly come to the page number 59. This is order passed by this honorable court in previous round litigation, my lord. Kindly come to the para number 5, 59.
Where is that order?
Well, order is annexure N, page number 70. I may be permitted to furnish the relevant translation of relevant portion, my lord. My lord, the third respondent adjourned the matter to 15/5, my lord. But 7/5 he has passed an order, notice, issued notice. This honorable court in previous round writ petition.
Where is that writ petition?
Please, my lord. This is a
Take that
translation.
order.
My lord, kindly come to the page number 69, which is annexure M.
No, where is the order of this court?
Yes, my lord. My lord, order of this honorable court, page number
56.
59, my lord, para number 5. Page number 59, para number 5.
The writ petition stands disposed of, reserving liberty to the petition to file objection before the respondent number 3, Tehsildar, within a period of 15 days. The Tehsildar shall consider the objection that could be filed by the petitioner, afford an opportunity, and pass orders in accordance with law.
Kindly, I may be permitted to read completely, my lord. Including the petitioner and thereafter pass a necessary order only in accordance with law. Needless to observe that till a decision is taken by the Tehsildar in accordance with the law, the Tehsildar shall not precipitate the matter in any further, my lord. Thereafter, my lord, I have appeared before the third respondent, and my lord, and filed objection along with wakalat, my lord. The matter has been adjourned to 15/5 for further hearing on the documents, my lord.
15/5 is over already.
My lord, I may be permitted to make submission. Before 10 days, my lord, I am sorry, 8 days, 7/5, the Tehsildar issued eviction notice, which is under challenge in this petition, my lord.
It's wrong. We will, my lord, your lordship may kindly
Why
direct
the officer is not able to understand what the court says, or he does it?
Therefore, my lord, your lordship may kindly direct the Tehsildar to consider their representation and pass a speaking order, your lordship.
No, first you have to cross the first step.
Sir.
Then counts for the petitioner submits that. The order passed by the Tehsildar dated 7/5/2026. The notice is 7/5/2026. By virtue of that, what did he say?
But in notice stated that I have to evict.
Dated 7/5/2026 is contrary to the order passed by this court dated 14th January 2026 in WP number 424 of 2026. A perusal of the order shows that the Tehsildar was directed not to take any coercive precipitate to the Tehsildar is directed not to precipitate the matter any further till the order is passed. Admittedly, as on 7/5/2026, no order is passed by the Tehsildar. Hence, there shall be stay of all further proceedings.
Notice, my lord.
Notice dated 7/5/2026.
It may be quashed, my lord, directly with us. We will pass necessary order, my lord.
No, let it be pending. You file your objection.
My lord, it will take further. My lord, therefore, my lord, it may be quashed and your lordship may kindly
Respondents
direct.
1, 2, 3.
It may be quashed.
AGA takes notice.
1, 2, 3.
The third respondent, Tehsildar, shall file an affidavit, file his objection, stating an objection why an order is passed contrary to the orders passed, why a notice is issued, notice of eviction contrary to the orders of this court. Yes, this is matter in the month of August.
Much of it.
Then number 30. Rashmi Deshpande.
I appear for the petitioner in this matter, my lords. The respondent 7, who is my neighbor, is undertaking construction of a house which clearly seems to be in violation of the BBMP bylaws. I have produced all the photographs evidencing the setback that he has provided.
Yes.
And now,
So there,
Have you considered this representation?
I'm awaiting instructions, my lord.
Huh?
We will consider it, my lords. Because they are the
Get
neighbors.
instructions or you will consider?
We will consider, my lord, as if not.
Yes.
no, but some time frame may kindly be
Yes.
fixed, my lords.
The present petition is filed. Seeking filed seeking the following prayer. Counsel appearing for the petitioner submits that. They are given representation dated 29 March 2026 and 5th April 2026, bringing to the notice of the respondents that there is the third,
Seventh respondent.
the seventh respondent is carrying out unauthorized construction.
Please.
Is carrying unauthorized construction, but the respondents have failed to take action. Hence, the petition is constrained to come before this court. In counsel appearing for the respondents,
2 to 5.
2 to 6.
2 to 5, my lord.
2 to 5 submits that they'll consider the representation of the petitioner. The learned AGA takes notice on
That's
behalf
number
of
one.
respondent. One. Takes notice on behalf of respondent number 1. And then you will appear for 6 also.
6 also.
6 also.
2 to 6.
6 also, 1 to 6. Though this court is not proposing to issue notice to the seventh respondent, as no adverse orders are being passed by this court. And the respondents, before considering the representation of the petitioner, will give an opportunity to the seventh respondent. Accordingly, this court is passing the following order. The writ petition is disposed of, giving liberty to the directing the respondent to consider the representation of the petitioner dated 29 March 2026 and 5th of April 2026 in accordance with law within a period of 4 weeks from the date of receipt of the copy of the order. Before considering the representations of the petitioner, an opportunity shall be given to the seventh respondent. Accordingly, disposed of.
Number 34.
My lordship may make it 6 weeks, my lord.
6 weeks.
6 weeks.
Case number 34, Mohammed
Opinion.
Mujahid Singh.
My lord, ex parte order has been passed, my lord. Subsequently, it's pursuant to that, bank account has been attached, my lordship. My lord, kindly see, my lord, the demanded amount of tax or liability, entire amount has been repaid, my lordship, by the petitioner, my lord. Before, it is, though the order is passed, it is not been communicated to petitioner, my lord. I have produced the challenge, my lord, where the entire disputed amount has been paid, my lord.
Notice give the
Is a,
counsel for the respondent who appears for the
my lord, it is
center tax.
Arvind Chauhan. Arvind Chauhan, my lord.
So and so. Petition is for directed to serve the notice to second respondent. This is matter on Wednesday. Yes.
Case number 36. 35, case number 35.
Yes.
Before the division bench, the government said there is a ban for recruitment. As such, we are not recruiting anybody. Here, the petitioner is the only PhD holder in sculpture. He applied for the post of lecturer post in Chamaraj in Kawa, Chamarajendra Academy of Visual Arts in Mysore. Kindly peruse page 30, page 30, my lord, inner page 8, para 3. Page 30. Consequently,
No, all these are of the year 2015 and.
no, I concur.
Then why,
But here what
why
happened?
it was
No,
moved
no,
in
no.
a vacation court?
Meanwhile, out of 3 reserved forts for the scheduled caste, the petitioner belongs to scheduled caste. There were 3 vacancies. 2 vacancies were filled by the general merit. Even they are applying for appointing one more general merit fellow in a post reserved for scheduled caste. Agreed by that, I approached this honorable.
When is that?
Notification, my lord.
No.
Page 74.
Notification is dated,
Circular, it is a circular annexure G.
no dated.
Dated, it is 19/3/2025. Now
why
they
are
are, the
you-
process is complete. They are completing.
Why are you questioning it in the vacation court? That's what I meant. What is the urgency for that? Then why, how are they numbering these writ petitions which have no urgency?
No, they are intending to issue notification. My instruction is they have issued a notification yesterday, that is my day before yesterday.
Then that should be there on record.
But
Consider
meanwhile, my
a-
humble submission before Lordship
We
is,
can't entertain writ petitions of this nature. Yes, who takes notice?
I'll accept notice for 1 to 3, my lord. 1 to 3.
To all the three?
No, no, 1 to 3 only.
1 to 3?
4 and 5, my lord.
1 to 3, AGA takes notice. 4, 4?
4 and 5.
Notice to 4 and 5. Let's this matter on 9th of June. Yes, 37,
6, 36.
36.
Harsha Swarup.
Appearing for the petitioner in this,
Yes.
my lordships had passed an order which is in annexure B, my lordship.
Come to the prayer first.
My lordships, there is a small amendment in the prayer which we need to do. If the leave may be given, we would like to amend the prayer, my lord, because we have asked we have left out the main prayer was on DRT, basically directing the DRT because this court had passed an order with a 30-day protection. This very
Let's
court.
this matter on 2nd.
My lordships, leave may be granted to amend the prayer in the.
You file an IA, then we'll, that will come before the court. Yes, 38.
Obliged,
Yes, 37.
Lords, I appear for the petitioner. Lords. This is a challenge to an order passed by the respondent number 1 under the Parents and Senior Citizenship Act, my lord, which is against the judgment of the Honorable Apex Court in Chikara's case, as well as this Honorable Court. Lords, apart from that fact, there is no pleading with respect to the case that the case of the respondent number 2.
What are you doing from 21/7/2025?
Lords, this is an ex parte order. We didn't give notice.
Did you come to know?
It is only in May, my lords. And after having passed this order in 6th, 2/3/2026.
Come to the cause title.
Please.
What is the relationship between the parties?
The petitioner is the daughter-in-law of respondent number 2.
Hmm.
Subsequently, the respondent number 2, on the basis of the order at annexure A,
Who are other respondents?
respondent number 3 and 4 are, my lords, the witness to my gift deed.
Hmm.
They have been made party before the respondent number 1. That is the reason I have made them party, my lords.
Hmm.
Notice may be dispensed.
What is the order?
Now, order says that the gift deed which is issued, which is made by the respondent number 2 in my favor, has been cancelled. Though the parameters which she has pleaded by the respondent number 2 before the honorable respondent number 1 doesn't fall within section 23.
Have you seen this?
Yes, my lord. See,
Are there any
there is no,
clauses for?
there is no recitals.
Huh?
There is
No
no
recitals
recitals
for-
to taking care of the.
And furthermore, my lord, she doesn't even state that is my case.
Please come. The present writ petition is filed questioning an order passed by the Assistant Commissioner under the maintenance and so of the Senior Citizens Act, whereby the gift deed that is executed in favor of the petitioner by the second respondent is cancelled. Land Council for the petitioner submits that it is an ex parte order. Further, the order passed by the commission is contrary to section 23.
Please.
Section 23 of the act. There is no recital in the gift deed with regard to the maintenance of the second respondent. Any maintenance is awarded?
No, please, my lords. And subsequently, my lords, may kindly have page 42 for a moment. As soon as she gets this order.
Did she ask for maintenance?
No.
No, sis.
What did you write? In the sale deed with regard to the maintenance of the second respondent, it is submitted that the order passed by the commissioner is contrary to the judgment of the apex court. There are the judge, what is that, Cecilia something is?
Chikara, please. my lord.
In Shikara's case, judgment of the honorable apex court in
This is
Shikara's case,
lords.
take that.
Sudesh Chikara.
In Sudesh Shikara versus Mati Devi and another, arising out of civil appeal number 174 of 2021, dated 6/12/2022. Learned AGA also does not dispute the fact that the gift deed does not contain such a recital. In that view of the matter, there shall be stay of all further proceedings. The order dated so and so passed by the commission is suspended
May I make
till
one
the next
submission?
date of hearing.
post this order, respondent number 2 has gifted the property to respondent number 5 and who is alienating it. So I have asked for
We
the,
will grant, after that, we'll see. That order of the commissioner is suspended, that's it.
that is acted upon. That's why I've asked for a stay on the further alienation by respondent number 5. That's why I've asked for it. Right now it is respondent number 5 who is holding the property.
Now, what is the consequences of further alienation when this is suspended?
But this being suspended will not show in the sub-registrar, please, because the kata has already shifted from respondent to
It is
respondent.
submitted that during the pendency of the petition, the second respondent has alienated the property in favor of
Respondent number 5.
respondent number 5. There shall be a direction to the fifth respondent not to further alienate the property.
My lords,
Yes.
respondent number 3 and 4 may be dispensed with notice, my lords.
Where is the memo?
I'll
Memo is
place
filed
it.
seeking,
I'll-
write a memo and give.
Please, write
Memo
it.
is filed seeking dispensation of notice to,
Respondent number 3 and 4.
now who is alienating the property?
5.
A memo is filed seeking dispensation of notice to respondents number 3 and 4. The same is dispensed with at the risk of appellant. Yes.
Respondent number 1, I'll accept.
1 HA takes notice. Yes. Next.
Case number 38.
And in all these cases, wherever office objections are there, in the meantime, office objections to be complied with. Yes, 38.
38.
Lord, 38, my lord, I appear for the petitioner. Lord, the petitioner is an employee of my lord, third respondent corporation. But I am an employee of my lord, third respondent corporation. Lord, the complaint was given against my lord, one Mr. Ravi Kirti and Siddhaya. Lord, in this regard, my lord, a committee is constituted to look into the, my lord, examine the complaint against Ravi Kirti and another. Lord, the committee is yet to submit a report. No, my lord, I have been kept under suspension by the second respondent, who is not the disciplinary authority. Lord, I am an employee of, my lord, Mysore City Corporation. Lord, working in, my lord, Town Municipal Council. Lord, the second respondent was the disciplinary authority. I would concede, my lord, it was the disciplinary authority. My lord, till 2022. Lord, there is an amendment to the, my lord, CCA rules. But insofar as employees of the corporation is concerned, it is only the third respondent. Commissioner is the competent authority.
And that.
Malad,
But I have produced at page 64.
Malad, yeah, what happened? Is the petitioner Malad has transferred e-kata in the name of other person.
No, that is on the merits of the matter. Now, what he says is he is placed under suspension by an authority who has no jurisdiction. Whether he has a jurisdiction or not is the issue now.
Okay.
Where is that order?
At page 64, Lord, your lordship may kindly come to page 64. Lord, fourth column, presently power vested with. Fifth column is, my lord, powers delegated to. Kindly come to, my lord, page 65. Punishment for group C and D is the, my lord, was DMA, who has passed the order now. Last column is, my lord, corporation commissioner.
No. Where is the impugned order?
I'm sorry. Impugned order is at page 61, my lord, passed by the DMA.
He is which respondent?
Second respondent, my lord. Third respondent is the authority to.
By virtue of this order, you are placed under suspension.
I am placed under suspension.
The next come, then counsel appearing for the petitioner submits that. The second respondent has placed the petitioner under suspension by order dated
25/5/2026.
25/5/2026. It is submitted that by virtue of the amendment in the year 2022, the competent authority to impose punishment for group C and D employees is a commissioner of the corporation.
Third respondent.
It is submitted that the order that is passed by the second respondent is without jurisdiction, considering the notification dated 2012/2022. They shall be stay of all further. The order dated so and so is suspended till the next date of hearing. You take notice to all the respondents.
1 and 4, I'll accept notice.
1,
CA takes notice.
2 and 4, my lord.
AGA takes notice on behalf of respondents.
1 and 4.
1 and 4.
Yes, ma'am. 2 and 3, my lord, municipal corporation, Mysore City Municipal Corporation.
Director Municipal Administration 2.
Two also, my lord. 1, 2, 4, sir. I accept.
One,
marks.
two, four, AGA takes
Three is
notice.
municipal.
Three,
3, my lord, notice may be ordered.
notice to the respondents. This is a matter on 1st of July.
But the only office objection is court fees, my lord, I have paid, your lordship may.
Inland council submits that the office objections are complied and the court fees paid. Yes, next.
Bill number 39, hearing on introduced application. Hema Kadiyappa Gowda, 14%.
Third respondent's counsel, Lord.
Yeah, for the second respondent.
Yes.
May I make subject to your lordship's thing? May I take leave for 1 minute? Matter relating to my lord's election allegation is there are certain malpractices. Now the latest Honorable Supreme Court's order, they have constituted separate election tribunals to deal with all these matters, my lords. I have the order copy that's dated, my lords, 21st May 2026. 18/5/2026, sorry. Now, my lords, any election dispute relating to any of the elections to any bar council in the entire country, lords, I'll just pass this order if your lordship sees this.
Are you aware of that?
Yes, my lordship, I already produced before this honorable court along with IA, my lordships.
Now, my lords, with that, if your lord.
No, when you receive the complaints generally during the course of.
After, my lords, after the elections are over, counting process, they start making certain allegations. Now, those are election malpractices or whatever complaints. It is only those can be tried only in an EP. In fact, the returning officer has considered and has rejected certain complaints. The High Powered Committee considered, which comprises of retired judges, my lords. They have also said there is no basis, and these will require evidences. And one of the requests is furnish the CCTV recording copies. That can be only in an election petition where it will be produced before the court.
Let's see where is the direction.
Lords, please come to, Lords, the order. It starts from para 1 itself. It's a short order if your lordship sees, my lords. This is the order dated 18/5/26. Sorry, may I just pass on? I think there are a lot of pages in that. They have comprised the old petition copies. Leave that, my lord. Just see the order, my lords. It should be this.
Yes, it is here.
Yes, my lord. I'll just read that, my lord, because it's only a small.
Yes.
These matters were heard in part on 15/5/26 and were adjourned to explore the possibility of constitution of 1 or 2 election tribunals for the purpose of speedy adjudication of the dispute arising from the ongoing elections of different state bar councils. We have briefly heard the senior counsels for the parties. In addition to the existing election tribunals, we hereby constitute 2 more tribunals. The first tribunal shall consist of Justice so-and-so, Deepak Gupta, former judge of this court, as chairperson, Justice Dheeraj Singh Thakur, former Chief Justice, Andhra Pradesh High Court, and Ms. Mahalakshmi Pavani, senior advocate. Second tribunal shall consist of Justice Hima Kohli, former judge of this court, as chairperson, Justice Tarlok Singh Chauhan, former Chief Justice, Jharkhand High Court, and Ms. Kavita Wadia, senior advocate. Bar Council of India is directed to obtain their formal consent and notify the constitution of these tribunals within 3 days. Aggrieved parties shall be at liberty to submit their respective claims before these tribunals. We request the tribunals to decide all the issues, including interim directions, expeditiously. All the state bar councils are directed to keep records intact till the election disputes are finally decided by the tribunals. We may hasten to add that the petitioners in so-and-so claim to have secured the highest votes amongst the unsuccessful candidate shall also be examined expeditiously, the writ petitions. So, my lords.
Let's hear her. What is that she wants? Yes.
My lordships, even I have produced the same hard copy also, my lordships. In the same day of the 18/5/2026, one more order is passed, Your Honor. In that, I will read out in the page number 23 of my IA, Your Honor. In that, my lordships, still the High Court decides the matter finally. Further counting of the ballot papers shall be kept abeyance. Because my lordships, used in the similar case, in the paragraph 2, I will read out, my lordships. All these matters have been arisen out of the recently conducted.
Where is that order?
20, my lordships.
Which is that order?
Order copy I produced before. In the IA, along with my IA, I produced this order copy, my lordships. Page number 22.
Have you given him a copy?
Yes, already served, brother. Already served to other side, sir. Page number 22, my lashers.
Date of the memo,
We go and put.
date of the memo.
IA number 1. I have filed only one IA, so IA number
We
1.
dated 19/5, I think, subject to correction.
Your Honor.
Page number 22.
Yes, my lashers.
This is order is dated
11, 18,
18/5.
2026, my last, same day, my lordships.
You are referring to the same order.
No,
No,
there are two
same-
orders, my learned
The
friend.
same day.
If your lordship sees, please come to page 18 minutes.
My lordship, I
In
will.
that. That's a different SLP.
What is order in this?
My lordships, in this order, my lordships, in the similar case, it is court has, Honorable Supreme Court has stayed the matter, my lordship, until unless completion of the High Court, completion of the High Court counting ballot papers will be stayed, kept in abeyance, my lordships.
We have to read
Until
the
further
entire
counting.
order.
Until decides the matters by the High Court finally, so further counting of the ballot papers shall be kept in abeyance, my lordships, in the page number 23. I will read in the 22 of the page number, my lordships, paragraph 2, your honor. Similar matter, this is the same, High Court HPC, same similar mark,
Then
similar case, my lordships.
contrary to the other order.
My lords,
My
please
lordship,
see,
based on this silent, my lordship, my submission.
para 5, if your lordship sees, there was a consent, there were matters pending. Please see para 5 onwards, my lord, at page 20.
The court has accepted to consider it
Yes, my
without
lordships.
going to the election tribunal.
No, then, my lords, that is why, my lords, they were transferred with a request to, my lords, hear that matter. But then subsequent order says, all matters, my lords, otherwise in a writ petition, if your lordship sees,
Two were passed on the same day.
my lords,
My lordships.
that's a different SLP, this is a different SLP. My lords, what has happened, that particular, what page 22 your lordships are referring to, that arose from an order, my lords, from the High Powered Committee's order in a writ petition pending before the Delhi High Court. Here, my lords,
The irregularities taken place in the election.
in the election. Here, my lords, and the counting process has started. They give a complaint to the High Power Committee. High Power Committee considers, returning officer considers and says all these issues we cannot, and the complaint is regarding polling. The polling which had taken place earlier. Now, these matters in a writ, my lords, even if I say, my lords, if your lordships say alternate.
I understand your submission, but see, this order at 22 on the same day and the other order
Yes,
at
Same days.
My
Lords,
lordships.
that's the
My
Supreme
lordships,
Court.
I have
That's why.
submissions, my lordships.
Lords, that's why, my lords, I'm only saying, please see the context in which the page 22 order was passed. Please come to para 2 onwards, my lord, because the context is all these matters have arisen out of the recently conducted elections of Bar Council of Delhi. Several representations were filed.
one more writ petition. In all this, they have made several allegations about
Yes.
the irregularities, and time and again, they have been
No,
bringing
no.
it to the notice of the Bar Council. Nothing has been
No,
done.
no, my lords, please see para 2 onwards, my lords.
My lordship, my humble
Yes.
submission. Based on this order, my lordship, they kept abeyance. Based on this order, they given direction to the honorable supervisory committee. They formed and also formed the two additional supervisory committee for the conducting this election related issues, my lordships. In the same way, it is kept the abeyance of this ballot counting, my lordships. Same order, same day, my lordships. And also I have some other submissions, my lordships.
Ma'am, my lords, we'll read that order if your lordship sees. There was a different thing, situation was different. Para 2 at page 22 if your lordship sees. I was reading that several representations from the second line in para 2 were filed alleging various irregularities in the conduct of the elections and counting of votes. However, prayer for repolling having been declined by the High Power Election Supervisory Committee constituted by this court by order dated so and so, petitioners have approached this court. There they went to the Honorable Supreme Court. Some of the contesting respondents are also on caveat. Then please see para 5. During the course of the hearing, learned counsel for the parties have fairly agreed to our suggestion that since the effective adjudication,
Apex Court
gave that, Mala.
given a suggestion. That I
That's
can
all.
understand from that. No, when in one order, the apex court says that all that has to be decided by the election
That's-
tribunals or committees
Lords.
that are constituted. No, something like there has to be some uniformity in the order.
Lords, that's the apex
One
court.
petitioner, so
Lords.
why not we rely on this order of 20?
Lords, this is all,
Please wait, I'll hear you, let him submit.
Lords, these orders are all under 142, my lords. Under Article 142, the Honorable
The
Supreme.
other order also under 140.
Under 142 only. Now, my lords, the counting process is almost complete now. Elimination rounds are going on. At this stage, my lords, if their entire thing is stop the counting, consider my complaint.
I am not on that aspect of stopping the counting and all. When certain things are brought to the notice of the bar council or
Not the
whoever-
bar council.
the
Yes.
whoever is conducting the election.
That has been rejected.
So that has to be, no, not rejected. They're not at all considering.
No. It is, my lords, it has been, orders are passed. One is, my lords, on 12/5/2026. Copy. Yeah. On 12/5/2026, the returning officer, who is a retired judge of this court, has considered all the complaints and has rejected them. I'll just pass it on, my lords, for a moment. 12/5.
Shall I submit my lordship?
Lord, I appear for the R2, the High
Because
Power
this-
Committee. As on date of the polling date, there has not been any complaint filed.
Not on
Complaint filed by any candidate. There's no complaint filed by any voter.
My lordship, it is
No
there.
complaints filed by the advocates. If my lord,
Lords, I'll just pass it on. Your lordship may kindly see this.
Transparent manner,
all I'm
what their
saying.
grievances.
Lords,
if
please
two
see this.
Orders are passed by the Honorable Supreme Court. In my view, my lords will have to see what is the order passed by the Supreme Court while constituting the election tribunal. Insofar as Delhi High Court is concerned, it can be only confined to that writ petition or SLP alone. The Honorable Supreme Court has made it very clear in 18(5) order that all disputes, any party who is
Go there.
aggrieved can approach the election tribunal. If that was the intention, the
If you
second
look at
order
the-
would not
if you
have been
look at-
passed
if
at
you-
all.
If you look at the second order, that is also a dispute that is arising out of the election.
It has to be confined only to the facts of that writ petition or the SLP. My lords may kindly see the election 18(5) order.
That I've seen.
That's very clear, my lord. It was never meant
order
to
is also
expand.
very clear.
It was never meant
Lords,
to expand the scope of
first page of that,
interference.
letter, order, my lords, 12/5/26. In that reference number, your lordship may kindly come to 7. Complaint dated so and so by Hema Karyappa Gowda. That's. Then, my lords, the other one is also keep in mind reference number 9.
Also again, her complaint.
Yes, 7/11. And, my lords, there is another connected writ petition at serial number 68 by Sandhya Prabhu. Even that is considered. And, my lords, the returning officer says.
What's the relief you are seeking the other day?
In my case, my lord, it's entirely different because presently, my lord,
No, what is the relief you are seeking?
my lord, in that, my lord, I have given many representations. They have to consider my representation in which one was, my lord, before the counting could commence. I had sought for transparency to be maintained on the counting process. That was done in Delhi. So before counting itself, I had asked for. And insofar as this complaint and petition and my petition is concerned, my lord, my petition, my lord, they cannot consider, it's not a different, my lord, it's on a different fact. That is, on the day of election, I was the only person who had complained to the returning officer that few candidates.
But anyhow, the election is over now. Election is over now.
Election is over, but on the day of election itself, if there is a complaint, then, my lord, they say that it's applicable to us. But on the day of election, my lord, I had given a complaint. That was oral complaint to the returning officer. When I went for polling, my lord,
No, basing on the material, if you are able to produce the material
My-
to show that.
my lord, that
One minute,
material is
one
with the
minute.
CCTV, my lord.
There was,
My lordship,
Lord,
my lordship,
my lord,
in my
I'll
petition.
make it very clear, my lord. That document, my lord, there are
I think
cameras.
it is.
My lordship,
My lord, there are cameras. There are cameras. my
I
lord.
think that this is not possible for the court to decide this matter.
In a writ,
My lordship,
My lord,
my lordship.
one more submission, my lord.
Kindly,
Because my matter was not heard, my lord. My lord, I have an objection with regard to the appearance of the senior counsel, my lord, who himself is election officer. He's appearing for the bar council.
my lords,
Lordship, I
that
have
we will
submissions.
meet, my lords,
He
that.
himself is a, my lord, election officer.
Is
Who was
yes,
present on the
is the
day of the
election
election
officer.
also. We have some, my lord, grievances against that particular issue also. When we, my lord, are standing as a party persons here, I am not opposed for
My lordship-
appearance of senior counsel, my lord.
My lords, may I just submit this?
My lordship,
Your lordship may issue rule and consider it brief. We'll file our counters.
My lordship-
Because, my lords, there are.
My lordship, I have submissions. my
I don't know,
lordship.
my lords, from
Before-
where these things are coming about.
My lordship,
Monday.
My lordships, I produce the proof of all the documents, my lordships. What
Monday.
the court, my lordships.
Both the matters, my lords.
Yes, both.
My lords, till then at least direct the issue the mandamus, my
Nothing will
lordships.
happen in one, till Monday, yes.
68 also, your lordship may tag it along with this, my lords.
And so far as 68 is concerned, my lord, the urgency is, my lord, my counting, my lord, presently is on, my lord.
Correct.
Yesterday, they completed, my lord, because there was a, though there was a government holiday, they have continued the process and completely they've completed for first preferences. Now they have started with second preference. Presently, my lord, I have 160 people before me. 60 people before me. Lord, insofar as, my lord, let them not declare the result, my lord. They are in such a hurry, my lord. The counting, there is no timing
Counting
as
is
such,
going
my
on
lord.
for last-
There's
I don't know.
counting, there is no
The
counting as
counting
such.
is more than
Lord,
one, my lords, any,
my lord, nothing goes wrong, my lord. If
my
the
learned friend
preference is this, my
appeared
lord,
now, it is posted on Monday, she says my matter is different. And I have not come across any petition where counting process is stalled when in an election matter.
once I've told that senior counsel cannot speak in my matter, Lord, I have
My
a
lords,
serious-
letter file an affidavit.
Monday.
I will file it.
On Monday. Yes, 40.
Serial number 40.
Appearing for the petitioner in this this matter, I may be permitted to submit the copies of the document. On the previous day I have submitted certain documents. Now it is comprehensive and all the annexures have been marked. Translate. My grievances with regard to the issuance of annexure K, by which the recognition is withdrawn.
May I make a submission, my lord, before that?
Call for the records pertaining to the order dated 13/5/2026 issued by the fourth respondent. What is that order?
My lord, annexure K, the translated copy, my lord. That is, your lord may- It is at annexure K, is at page number 13. Now I have given the translated copy, my lord.
Where is that?
Now I have given. Page number
Yes.
13 is the translated copy of the impugned order at annexure K. So 15:4.
I think you wanted to get instructions.
There is an appeal provision, my lord.
Huh?
There is an appeal provision.
Appeal
Under
is not
section 130,
efficacious
my
because
lord.
there are high court judgments, high courts have given the,
No, you wanted to get instructions in this. Last
Yes,
occasion. it
yes,
came
my
up.
lord, I already.
Whether
took
there is
instruction.
any intake of students for the
Yes,
year.
my lord. Yeah, my lord. 2023-24, my lord. 8th standard, my
No,
lord.
he was
2
saying the
students.
other day there was 17 students.
now
You
there are
said
27
1 minute.
students. I'm sorry.
Now
That
17
it is
students.
zero.
Now, no doubt, my lord, 17 students.
What
they
will
had.
happen to those students if they, if you have to,
Take over the some other school.
that should reflect in the order.
We will file affidavit.
No, you are in this order, you are referring to the teachers.
Yes, ma'am.
What will happen to them?
Now,
Then what
my
will
lord-
happen to the students?
We will take over the some other school.
Why, when you can mention about the teachers, you should have also mentioned about the students.
In this, we have not mentioned, my lord, we will file undertake to, we'll
Huh?
undertake. We will undertake, we will take over the some other
No,
school.
this is for only one this year I am seeking.
This
Otherwise,
school,
if I won't have the strength
My lord,
in the
completely,
coming
my lord,
year, it will automatically close.
from 2023 onwards, my lord, there is no strength. As per the rule, my lord, annexure 4. May I read, my lord? Annexure 4 of the recruitment and terms and conditions of the
Yes.
rules. Here, my lord, standard staffing pattern of high schools. The minimum strength that is actual student attendance in each classes of the high school from standard 8 to standard 10 shall be 25 in each.
Please read this.
My lord,
The order at page, will you read this?
no, the annexure K, my lord.
Page 12, annexure K.
Yeah.
In view of the zero student,
Yes, zero student enrollment during the year, during the 25-26 academic year at Sri Sita Raghava Pre-University High School section, so and so, under the management of so and so, Puttur, Dakshina Kannada district, the management passed a resolution to close the school wide reference number 2.
that is on 29/3/2025.
Earlier, no, yeah,
Complete,
I have requested for it.
complete reading.
Yes, yes. Consequently, the teachers of the said school were temporarily deputed to an inter-management school. And the deputy director, by reference number 1, recommended declaring the school non-viable and withdrawing its recognition. Based on the deputy director's report under reference 1, a notice was issued to the management from this office under reference 3 pursuant to section 39 of the Education Act. The management submitted an appeal wide under reference number 4.
Condition may
One minute, ನಾನು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. Reference number 4. Reference number 4, the date may be seen. It is on 17/3/2026 I have given. Now I will further read it, Minor. Stating that due to a decline in student enrollment and attendance during the 25-26, and because several teachers had retired, the previous management had allowed the school to close owing to financial crisis. Thus, they stated that the management has now changed and the new committee has resolved to continue running the high school. It's a Kannada medium school. The students are residing there. The management is giving them the midday meals also, and the government is not supporting it. Therefore, they requested to condone the 2025 enrollment shortfall, release the 2 deputed teachers, continue the recognition, and support the school's educational development. This office forwarded management's request to the deputy director, Department of School Education, Dakshina Kannada, on 24/3/2026, directing them to examine the management's request in accordance with the rules. They were instructed to verify the written explanation received from the management in response to section 39 of the notice of Karnataka Education and to submit a report along with clear opinion and necessary documents, information by written post without delay. Now, my lord,
By the respondents.
this
And there are
letter
about-
has not at all been considered.
Condition 1 we have already stated. Condition 1, in that condition 1.
There are 19 students in the school. That is for the academic year 2025-26. The AGA shall get specific instructions. What is the implication of this order with regard to the existing, the students who are already enrolled in the school? This is matter on 5th of June.
My lord,
40.
may I make a request? I may be permitted to continue with the admission. Now there are 20.
No, it will come on Friday, yes, 40.
Hold on, first it may be given, my lord, on 1st June. If the term is over, the admission period.
On first.
Number 41.
I appeal for the respondent, may be permitted to file the objections, man. Permitted to file objections. I've served the copy.
We'll have it after.
Please.
140.
Great.
Yes. 18, I don't remember. The file I have said that was.
ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಟ್ಟು
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮಧ್ಯಾಹ್ನ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್ ತಗೋತಾರ.
ಇಲ್ಲ ಸರ್, ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್.
ಹೌದಾ, ಸರಿ, ಥ್ಯಾಂಕ್ ಯು. ಥ್ಯಾಂಕ್ ಯು.
42, 43 ನಲ್ಲಿ ಏನೋ ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಇವ್ರು ಯಾರಪ್ಪ ಇದು? ಸರ್ ನೀವು ನಮ್ಗೆ ಹೇಳ್ತೀನಿ ನೋಡಿ, ಅಡ್ವೊಕೇಟ್ಸ್ ಎಲ್ಲ ನಮ್ಮ ಫೋನಲ್ಲಿ ಕಮ್ಯುನಿಕೇಶನ್ ಮಾಡ್ತೀವಿ.
Court officer. Court officer. Madam court officer.
ಹೇಳಿ ಮೇಡಮ್.
ಇದು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ತಗೊಳ್ತೀರಾ 2:30ಗೆ?
ಮೇಡಮ್ ನಮ್ಗೆ 2:30ಗೆ ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ, ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಪಾಸ್ ಅವರ್ ತಗೋತಾರೆ, ಬಂದ್ಮೇಲೆ ಗೊತ್ತಾಗೋದು.
ಓಕೆ, ಥ್ಯಾಂಕ್ಸ್.
court officer, there's no volume.
Covering up for my colleague, my lords. From Monday onwards, the CGC who's on record will be appearing, my lords.
So, my
But
lord,
today
the only
I'm-
thing is, 1st of June, my lord, if we don't, my lord, give that solar cells, we are liable for prosecution. So, disciplinary action, if it is stayed, my lord, then I'll agree.
Lords, no, my lords, we can't agree to that for this reason. Firstly, my lords, the impugned interim order will open the floodgates for all the other similarly placed petitioners, my lord. Secondly, if at all it is stayed, my lords, they will start commissioning the projects from the solar cells which they've already procured from overseas. They should not commission the project, my lords.
My lord, what has happened is, government projects, my lord, there's no bar. For, my lord, private projects, there's a bar. And, my lord, 1st of June, my lord, my lords are aware, my lord. They say we must complete it, my lord, by commission it by 1st of June. We require, my lord, land. We have to, my lord, procure, my lord, from abroad. We, my lord, have placed orders. 1st of June, my lord, land acquisition, my lord, permission, sanctions, approvals. Please come to, my lord, page 118 for a minute. 118.
No, what is the interim prayer you're
My lord,
seeking?
interim prayer, my lord, we have sought for many. All that I would say is, my lord, I am liable for prosecution, my lord, under the Indian, my lord, Bureau of Indian Standards Act. Let me not be, my lord, page 54, my lord.
Still say as far as only this prayer number A is concerned.
Please, my lord.
Till Monday, don't take any action. Monday, you argue the matter.
Lords, we cannot take any action also. Our only problem is they should not start the project. In fact, by not denying interim order, they will not be harmed in any manner. There is no irreversible damage that will be caused to them, my lords. It will remain, status quo will remain. But they should not commission the project. In fact, we have to ask them not to take precipitative
Direct
action.
maintenance of status quo.
But let them not commission the project, my lords.
Status quo means that.
Please,
Not do anything.
all right, please.
The Learned Council appearing for the respondents, so and so submits that she'll get instructions and seeks time. And a senior counsel appearing for the petitioner submits that if the respondent resort to what are the coercive steps?
Coercive step is, my lord, under the Bureau of Indian Standards Act. They are requiring me to, my lord, use only, my lord, those solar cells which they have approved, my lord, in
If the coercive steps are taken, it would cause a lot of prejudice to the petitioner. Considering the same, there shall be an order of status quo
Please.
obtained as on today.
Please.
Let's this
Great.
matter on when?
First, my lords.
First or second? Because everybody is asking first, court will be flooded with all these cases on the day.
First week.
First matter on 4th of June.
Please.
Print the name of so and so.
May I make the submission, my lord?
Delete the name of Mr. Shanti Bhushan.
No, Gautam Devullal is up.
Delete the name of Shanti Bhushan. Print the name of so and so. Yes.
My lord, sir.
Lord, serial number 49.
Yes, that will take up now.
That's the matter because I went through the file. My lords had directed us to take instructions. 34 weeks of pregnancy has commenced, my lords. They are seeking for an order for termination, but then it has to go before the medical board. My lords, I have spoken to my officers. Even today they can go. If the medical board says there is no harm for the
Directed
mother,
to go before the medical board, my lord.
today or tomorrow itself they can go, my lords. With that direction, matter will be posted on 1st or 2nd.
49, I appear for the union. I appear for the union. Medical examination.
Yeah, they can. Today or
Please.
tomorrow they can ready.
Please, my lords, we are okay with the medical
Go with their
examination.
convenience, they can go today or tomorrow itself before the board, my lord. That
We will go
direction
before the
may-
board. Maybe directed to go before the board. We will go
Both the
today.
respondents,
One is state and two is the union, my lord.
state, AAG appears for the first respondent. Second respondent, so and so, is so and so. What Gautam?
No, in this
So and
matter,
so
I appear.
Has instructions to appear.
In serial number 49, I appear, my lords, for second
So
respondent.
and so has instructions to appear on behalf of the second respondent. It's a case of the petitioner that, what is, how many months now? How many weeks?
32 weeks, what they say. 32 weeks.
Like, no,
32.
that the current pregnancy, the length of the current pregnancy has exceeded 32 weeks. And the ultrasound disclose that through the ultrasound, the doctors identified some abnormalities in the fetus. In view of the same, it was advised by the qualified doctors that the petitioner advised for the doctors that to consider the termination of the pregnancy as an option following review by the board. Leonard AAG submits that as it is, he said 32 months.
32 weeks.
Pregnancy.
Stand corrected.
He can appear before the medical board whenever, as per the convenience of the petitioner, they can appear before the medical board. The petitioner shall appear before the medical board tomorrow.
Yes.
Tomorrow. Yes, this is matter. And basing on that, they will basing on the shall appear before the medical board, basing on the
First. We listed on first.
But it can be, whatever the directions or whatever the advice given
The
by the
Honorable
medical.
Apex Court states, anything more than 24 weeks, it is only this court or the Honorable Apex Court has the powers to intervene and say that whether it can be terminated,
And
because both
the
for the
report
child
shall
and the
be
mother.
placed before this court on Monday.
Monday.
But in the interim order, Vani Vilas Hospital may be directed because the board constitutes the Vani Vilas Hospital. That may be, the hospital at Vani Vilas may be
No,
mentioned
he'll
as per
inform.
the interim order.
He'll inform. AG will inform.
I'll inform, Lords. It's called
he shall
the
appear
Medical
before
Board
the
for
medical-
Termination of Pregnancy.
And after examining the petitioner, medical board shall place a report before this court. Place the matter on first.
Grateful.
The order may be given on hand.
Yes, next.
Cell number,
Pass over, sir, how many? Call it.
pass over matter, cell number 1, list number 1,
For petitioner, Lord.
Mahesh Aruddin,
Serial number 1, my lord, sorry, my lord. In this, my lord, in this case, my lord, the Azada Maulana institution is constructing, my lord, in the local.
Constructing?
Yes, my lord.
So there is.
Since from, my lord, 2 months, my lord, they are constructing. Now they are before this honorable court, my lord.
They started the construction in 21.
No. In the 2 months back.
Lord, notice was ordered. They are appearing before this court. Lord. They have
When
not
was
filed any
the
statement.
notice ordered?
Lord.
When was the notice ordered?
Notice was ordered, my lord, on 28 and 25.
Notice is not served on them.
Lord, it is served, Lord. All are served, Lord.
All are served and Wakalat also filed, my lord. They have not served the copy.
All the respondents are served.
No, which respondent is constructing?
My lord, respondent number, my lord.
Respondent number, my lord, 4. my lord.
Government Maulana Azad Model.
Yes, my lord.
It's a government institution.
But separate, they have filed.
What separate?
Wakalat has been filed by the respondent number 4. I'll accept. We
What is the relief you are seeking in this
Lord,
petition?
The land in question, my lord, is a Gomad land. Total extent is, my lord, 88 acres, 32 guntas. Number of cattle, my lord, in the village, my lord, is 496. According to the impugned order itself, my lord, total extent of land needed for grazing of these cattle is, my lord, 148 acres, 32 guntas. There is already shortage of land, my lord, for grazing cattle.
Who are you?
Lord, petitioners are, my lord, agriculturists and owning, my lord, cattle, my lord, and depend upon the income, my lord, from the milk, my lord, they are getting from the cows, my lord.
Yes.
They are, my lord, affected because, my lord, their cattle are, my lord, denied, my lord, right of grazing, my lord, in the land in question. Total extent is, my lord, 88 acres. What is required is 148 acres. Impugned order says like this, my lord. 148 acres.
This order is passed on 24/9/2024.
Lord, the writ petition was filed on 22/8/25, Lord. I moved the matter several times. It listed also, Lord. Not reached at all, Lord.
So what is this order? Order dated 24/9.
The 22-8, impugned order, my lord. So far as fourth respondent is concerned, my lord, 2 acres was given. The fifth respondent, 9 acres was given, and sixth respondent, my lord, 3 acres is given out of this land, my lord. There is already shortage of land, my lord, for grazing, my lord, cattle of the villagers. If this is taken away, my lord, our right to livelihood.
What is allotted to them is 2 acres. What is there is 84 acres. Nothing will happen. You can wait. Let's just matter on 8th of June. Yes.
Seal number 13. Pass out by seal number 13.
For the petitioner,
Sanjay Kumar.
I have seeken instructions from the petitioner. He is ready to pay 2 lakhs on Monday, my lords.
How much?
2 lakh rupees on.
Where is the counsel for the respondent?
They're not present.
Give that affidavit.
My lords, one more point, my lords. When we went to serve the copy of the hand summons to them, at that point of time, they refused to take it, saying that CO is on leave and he will be available on this day, Friday. At that moment also, if we had told the outstanding amount as 17 lakhs, we would have given affidavit with that amount only, my lords.
On the last occasion, it is submitted with the land council that they're ready to clear the entire amount if a reasonable time is granted. Hence, the matter is adjourned to today for filing the affidavit.
My lords,
Today,
auction is posted for tomorrow, actually.
today the affidavit is filed stating that the outstanding amount is 15,10,779, and within a period of 3 months from today, they'll clear the entire amount. Land council appearing for the second respondent has appeared in the forenoon and submitted that he has 2 objections. One is the amount as stated, that is 15,10,779, is not the outstanding, but the outstanding is
17 lakh 1,706 as on this day.
17 lakhs 1,706 as on today.
Yes.
That's what he said.
Yes, what we have mentioned is as per the.
As on today, and it is submitted that if the petitioner to show his bona fides, as the auction is scheduled tomorrow, the petitioner shall pay some amount. The land council has sought for a passover, and in the forenoon, there is no representation on behalf of the second respondent. Land council for the petitioner submits that they are ready to pay an amount of rupees 2 lakhs by tomorrow. Accordingly, hence there shall be there shall be a stay of the auction on the condition that the petitioner pays an amount of 2 lakhs by the auction.
By Monday, sir.
Not Monday, by tomorrow.
Please, my lords, we have requested.
Then what is the purpose? If they stall the auction tomorrow, you don't pay on Monday, what will happen? You pay it by tomorrow, but on the condition that he pays an amount of rupees 2 lakhs, but before the auction time. And also shall file an undertaking affidavit with regard to the exact outstanding amount. This is matter on 10th of June. Yes.
Is continued. Seal number 41. Seal number 41.
Objections.
Sir Kadbi.
Take those objections.
Great.
First the writ petition or the MFA?
Pardon?
First the writ petition
Writ
or?
petition, your lordship. Let's say a license agreement came to be entered into between the petitioner and the respondent, Bangalore Metro, my lords, on 9/6/2025, Annexure D at page 54, my lords.
On?
9th of June 2025. Lord, the period is 12 years.
Hmm.
Annexure D is the license, but can I just trouble your lordships to straight away take your
Is
lordship?
it the case where they were arguing on the last occasion about the
That no
sublease?
rents have not paid at all.
Sublease also.
Sublicensing, they say now sublicensing. Anyway, it's the same. It's a license deed, so it has to be. So there are two things that I did not take prior approval, and the draft which I had sent, it had mentioned as a rent agreement. They take objection to that, and also they said that no rents were paid continuously from October, and that only 10 lakhs I paid after termination is what they had submitted. That's for one. Kindly come to page 68, the termination clause in the agreement. Running page 68, clause 13 minutes.
Yes.
13.1 says, my lords, the notices how it has to be, for what conditions it can be terminated. But please turn over to page 69, 13.2.
Yes.
Provided that on the occurrence of any license event of default listed in clause 13.1 above, BMRCL shall issue a notice to the licensee requiring it to cure such licensee event of default. The licensee shall have a period of 30 days from receipt of such notice to cure the licensee event of default. If the licensee repeats any licensee event of default, including non-payment of license fee and other charges, BMRCL will issue a maximum of 3 notices to the licensee. If the licensee repeats fourth time or the due amount exceeds 50% of the security deposit, please mark that 50% of the security deposit, BMRCL will issue a notice of termination.
How much is the security deposit?
Security deposit is 1 crore. That's 1 crore 75 lakhs 42,008.
Now what they say is you have not paid for the month of September and October, or September alone?
Their entire claim was from September onwards till
No,
May.
no, the other day they clarified it saying September or October.
Now I clarified saying it is only for October and November what is due. Because I was asking for a fit out period for
It
the.
is 20 lakhs.
It will be
40 lakhs
per month, it's about 19 lakhs 49,000 minutes. It comes to about 21 lakhs, which includes GST of about.
So 42 lakhs.
About 42 lakhs.
Hmm.
Now, my lords, this was the clause. Now, first time they terminated, I came before this honorable court. The first notice, my lords, of termination I showed to your lordship. This honorable court granted an interim order. First time termination was on 16/9/25, annexure, page 82, my lords.
That is pending.
That writ is pending with an interim order. Please come to page 84.
What was the ground on that day for termination?
Because the bank guarantee, that's a security deposit bank guarantee which had been furnished. One of the partners had withdrawn that bank guarantee.
Yes.
Lords, at 84, your lordship should get, my lords.
So that interim order has no bearing on this in.
No,
this
but
order.
this honorable court said, please see at 85 for a moment. '85, the second unnumbered para therein. These submissions are considered and records, including photographs, are perused. Court is of the considered view that the merits of decision to cancel the license agreement in the peculiarities of this case will have to be re-examined, and there should not be any precipitation until then.
That is pursuant to that.
That's it, absolutely. That's my understanding is they could not have done anything.
No, but.
Then
because
Lord,
on
this
some
honorable
reason,
court said,
the issue that was, that made you to come before this court is altogether different.
Lords, they had also said about the lease at page 83, your lordship should get in the notice, earlier notice of termination.
Yes.
At running page 83, the top para, my lords. The successful bidder, it starts with that sentence. Has to obtain prior approval from BMRCL for any construction modification and any other changes as per clause 5.1A of the tender, and has to obtain prior approval from BMRCL for subleasing to any third party or agency as per clause 5.8 of the tender document. It's also noticed you have allowed a third person who is now carrying out interior works without information to BMRCL and submission and approval of the drawings. So they were aware. So this also was one of the conditions, subleasing or a subleasing, or so that was one of the conditions for termination.
Where is the present notice?
Now, my lord, the first notice came after this writ order on 13/1/2026, annexure M, page 158. $158.
58 or?
158, 158, annexure M. think the page numbers probably your lordship may find it difficult. It's a, after those drawings, my lords. Starts with, it's a letterhead of Bangalore Metro Corporation.
That is at page 158.
Now, please see, my lords, it's heading itself, rent and security deposit default notice. They give the references, then please see para 8, my lords. I mean, sorry, reference number 8 at this very same page. Your request was 158, Annexure M.
Page 158.
My 158 is different, as I just want.
After the plans, it is there.
My 158.
That's your notice. It's next year. You have produced it along with your statement of objection. That's not there, I'll find. It's missed out, but they have produced along with their statement of objections. In that reference number 8, if your lordship sees, your request for sub-license, your lordships have that one. Waive of license fee, OMC charges and security deposit for so and so. Now, my lords, please see para 2 therein, my lords. Further, it is observed that you engaged third parties without obtaining prior approval from BMRCL for sublicensing, which is a violation of clause 9.3 of the article 9 of tender document. Hence, you are advised to submit the sub-licensee details along with your draft license agreement with the sub-licensee as per the tender conditions. Then for everything I had sought, they give a reply. And at 159, your lordship may kindly
What
see.
are the others, like that, next page?
Exemptions
159?
from the security charges, maintenance
No,
charge.
what happened to one page prior to that?
Lords, that
It
according
says
to us,
about 8, 9, 10, 11, 12. What about 1 to 8?
1 to 8, my lords, is our request, which is not available even with us, my lords, unfortunately. That is also not available with us. But only just for the thing.
Have a
Please,
copy of this.
I will be having. But
in their state,
I will be having that copy. I can.
in their statement of
Within 10
objection,
minutes,
Objections.
along with objections, I have not produced that.
35, page 35, along with the statement of objections, my lords.
Take that.
Statement of objections, our Ankadrala ಈಗ.
E ಕೊಟ್ನಲ್ಲ ಈಗ. Which is the document you are
Page
referring
number?
35, my lords. 35.
to? It is the one that is my learner friend is reading, 13 one.
ಅದು ನಿಮ್ದ್ರಲ್ಲಿ statement of objections, it is R3.
That's continuation is there. Due to
1,
violation
2,
of,
3, water seepage, that's my complaints, my lords.
due to violation of the payment terms.
Yes, those are my complaints which they answer. If your lordships have 37 minutes, the table 1 to 8 are only our thing about seepage and other things, borewell charges. That's not necessary. my
What
lord.
you have filed is page 158. It has only one page.
Yes, ma'am.
There is a continuation page.
One
That
page is missing in one.
That 36, what is that? We have to see.
That is at 37, your lordships will see at 37. In that statement of objections. It
Yes,
starts with
we will read 36.
36, yes, my lords. Yes, due to violation, your lordships have that, my lords. Of the payment terms mentioned in clause 5.5,
So, as per this show-cause notice, one is the sub-licensing the premises.
Yes.
Number 2 is with regard to the payments.
payments have not done.
And again, please come to the earlier termination notice, just now you referred.
Lords, that's in the writ petition, it is at page 83, 82. 82, it starts at 82.
So the new ground is only about non-payment of that amount.
Non-payment and third party, your sub-licensing. But my lords, at page 159, at page 37, your lordships read, it's the same thing, my lords. If your lordship come to 159 in my writ, please see column 12, my lords. Licensee requested, your lordships have that, my lords, table 12. Licensee requested NOC for sublicensing to third parties as per clause 5.8 of section 5 of the
That I have
10.
seen. Now, what happened after this 13/1/2026?
I gave a reply, my lords.
Where is that?
That reply your lordships would get at, my lords, it's an email, but your lordships will get, my lords, please come to Annexure N1 at page 169. Email exchanges are there, but please come to 169. On 14/1/2026, I gave a reply. Then I also say for December 25, January 25, so and so TDS amount was deducted and will submit the TDS form quarterly.
Yes. Your reply is on, date is,
Well, it's 14/1/26. For 13/1, 14/1, I give a reply.
what happened there?
Thereafter, they issue me one more notice on 30th January 2026.
Where is that?
That is at page 176.
Yes.
That's a final notice, they call it. At 176, your lordship should get subject rejection of request for extension of fit out period at Metro. And they refer to my email responses. And at para 3, let's please come to page 178, para 5. Regarding subleasing.
Para 3 deals with that bank guarantee.
Bank guarantee.
Which is part of the earlier.
Earlier writ petition.
Next
And
4.
then, my lords, para 4, they say your present contention that closure of premises during termination period prevented completion of fit out works is legally unsustainable, since fit out period has already lapsed prior to termination and no fit out entitlement subsisted during the termination
What is
period.
that they are referring to?
My lords, fit out period is under the lease agreement, certain period, about 90 days was used as a fit out period so that I carry out works, and that is not liable for that period of about 90
Which extension you sought for another?
Because, my lords, it was terminated, there was dispute, I was not able to do it. That's a rent-free period.
Next
fit
5.
out. Then para 5, you are expressly permitted under clause 11 of the license agreement, clause so and so of the 10.
This is also subject matter of the other writ petition.
Yes, to sublease, subject to intimation, it is evident from your representations, you have not been able to secure subleases for that. They say that I am not able to secure.
6.
Para 6, they say you are obliged to submit to BMRCL all subletting agreements and
This
arrangements.
is also pertaining to that.
Yes, you are called upon to submit copies of the subletting agreements.
7.
7, my lords, is maintenance issues which I had raised. They say what you have raised is not tenable. Then, my lords, 8 is about BMRCL giving us, that's for the fit out period, my lords, to say that you are not liable. They say delay in operational reasons is because of me. Then please see.
These are all the answers for your
my things.
representation.
Yes. And at para 10, if your lordship sees, my lords, at 179.
So in view of the foregoing,
Your request for extension or revival of fit out period is hereby rejected. It is clarified.
No, if this is rejected, what is the consequences?
Only 2 months rent I had to pay. And also in that very same para 10, my lords, last 3 sentences, if your lordship sees. You are accordingly directed to expedite onboarding of sublessees, operationalize the shops forthwith, and ensure strict compliance with all remaining contractual obligations. My lords, this was the notice for this also. Yes, next also. It is further observed that security deposit for electrical charges and license fee of 77 lakhs 41,319 due and payable as on date remains outstanding, annexure A to this notice. You are hereby called upon to remit the entire outstanding license fee immediately. Failing such payment, BMRCL shall be entitled to adjust the outstanding license fee against the existing bank guarantee. Upon such adjustment, you are hereby directed to top up and restore the bank guarantee to the contractually stipulated value within 7 days from date of intimation.
Now with regard to this bank guarantee and all, they're part of the.
They have also encashed the bank guarantee. 1 crore 72 immediately, my lords, after the impugned order at annexure.
After him, one after that.
Lords, this is what they said. For that also I give a reply. Then comes, my lords, annexure A, impugned order at annexure A. It's not an order, it's a notice.
Page number?
Page number 39, 16/3/2026.
Yes.
In that, my lords, please come to page 40. Para 2, they say it was restored, but it is without prejudice to our rights. Then, my lords, at para 3, accordingly, this conditional termination notice is issued calling upon you to clear entire outstanding license fee amounting to 91,41,440 and interest as on date of 4,03,941 as per clause 7.1 of article 7 of tender document and clause 8.5 of the license agreement, and water consumption charges of 14,629 as provided under clause 5.10b within 10 days. Then, my lords, at 41, if your lordship sees. You can read it. What I want to read, I will read. Please come to, my lords. The following are the reasons for issuing this conditional termination notice. They raise a demand for 91 lakhs, but please see B. What is important is B, my lords, at page 41. Under license agreement clause 3.3 read with so and so, permits subleasing of the built-up shops can be done with the prior written approval of BMRC. It has been observed that you have forwarded on 20/01/26 a draft document styled as a rent agreement instead of submitting
So
a
what is
draft.
this amount they're referring to?
91 lakhs is the license. But please see the same annexure attached to that notice at page 43. It's a part of the notice sent. It is 73 lakhs 28,911. In that, please see October, November, and March also they include the rents. Then, my lords, delay payment interest they charge, GST and interest they charge. Then water consumption charges they charge, though under the agreement it is only borewell charges. Anyway, they have charged water consumption charges. So they say 73 lakhs is due. This, my lords, is even less than 50% of my security deposit which was lying with them. For this also I give a reply.
No, why don't you pay?
My lords, only that day, my lords, I say, you please consider this 40 lakhs was what was due. For that, what they do is, my lords, after issuing this, my lords, since the earlier writ was pending, we moved IAS in those writ, in the pending writ petition, seeking a stay of this. It got moved, it did not reach even during the vacation. In May first week, they encashed the bank guarantee also. My security deposit of 1,75 lakhs is encashed by them. So they can adjust that 40 lakhs. According to us, it's not even 40 lakhs. We have made a calculation, it's about 34 lakhs. Though the demand was less, almost about only 34 lakhs, they've encashed the entire thing. Now, my lords, they also take police help, put locks on the premises. I am left helter-skelter. This is my position. And according to the agreement, 4 notices had to be issued. Each time they raise a different issue. Each time I give a reply. And my bank statement says, I have paid except for the month of, my lords, October and November, all rents were paid. TDS done, GST done, returns also given to them. In fact, my lords, we have prepared a memo. We served on a copy on my other side, just to show the production. Though I have produced the bank statement, my lords, your lordship sees, periodic payments are made. It's not that I have made only once. Every month, payments were being made.
We'll ask.
Then, my lords, the only other thing I did not bring to my lords. Now, if your lordships have their statement of objections, please turn over to my lords. Annexure R7 at page 50, subject to correction, it should be 54, my lords. 53, sorry, 53 in their statement of objections. That's an internal meeting they have conducted. The lordships have that, my lords. They say outstanding is about 70 lakhs. Now, my lords, if you turn over, please come to 54. The third unnumbered para therein. It was further decided bank guarantee amounting to 1,75,42,008 available with BMRCL shall be invoked and adjusted against towards the outstanding dues and the balance forfeited in accordance with the terms of the license agreement. With regard to existing sub-licensees, it was decided that after securing the premises, they shall be called to the head office at Shantinagar and informed that their current arrangements with the licensee are not recognized by BMRCL and do not confer any independent right of occupation. However, in order to ensure continuity of business and avoid disruption, it was decided that such occupants may be given an opportunity to continue the operations as licensees under BMRCL, subject to execution of appropriate arrangement and payment of applicable charges directly to BMRCL. The meeting with the sub-licensee could take place subsequently and depending on the outcome of the meeting with them, and if the terms are favorable to BMRCL, said licensees could be given an opportunity to continue their business.
Yes.
Oh, my lords, they just want to kick me out. They forfeited my entire bank guarantee. It is a dispute for only 34 lakhs. If your lordship sees my memo of calculation, my lord,
I've seen that.
I have stated every amount is through NEFT. There is no difference. Oh, I had given a draft. If you are not happy with the draft saying it's a rent agreement, all you have to do is change the nomenclature. In my reply, I have told them, you give a draft, I'll agree with it. That's the only thing.
Yes.
Suit is filed. I'm not taking to your lordships to the suit. What they do is it was listed on 11.
Suit is for, what is the relief sought?
Injunction suit to restrain me from interfering with their possession, because their case is on 6th of May. They took possession by putting locks and keys. It was our case. It was not done. They moved we had moved the court, vacation court on 12th. Matter did not reach. Interim order was extended. The earlier matter. 14th it was listed. It did not reach. Interim order was extended up to 4th of June. On 11th, MFA they moved the suit on 12th of May 2026 for an injunction suit, except mentioning one writ is pending, that they do not even mention that the matter was listed. Our IAs are pending consideration. They say a possession is taken on 6th of May. Interim order, ex parte interim order of injunction was obtained. I file an IA for vacating stay. I also seek for restoration, breaking open the seal and lock. That IA is rejected, my lords, and the interim injunction is confirmed. But what is found is that the trial court also says that this termination prima facie appears to be harsh, and that I had not challenged the termination notice. That is a different cause. Maybe I'll have to seek relief under that. That's the suit.
Ink page 54, annexure D. Some of the clauses are only read. The principal point, the first point for my lord's kind consideration is the earlier writ petition has nothing to do with the present writ petition in terms of cause of action.
What was the basis?
Kindly see the interim order passed by this honorable court in ink page 85. That was not read to my lords. The order portion may kindly be seen in ink page 85. There were three. It was the interim order was laced with certain conditions.
85 of is read.
Great.
He has read it.
He did not read the conditions. He only read para 2. He did not read the order portion of the. It is laced with conditions. It is not a blanket stay order that was given by this court. First one, the petitioner with effect from 1/9/25 shall pay the license fee, and this license fee shall be paid before 5th of each succeeding month.
This order is passed when
26/9. So he was directed to pay for the month of September, October, November onwards. So he has not paid. This is my statement that he has not paid the rent fee, license fee for September, October, November. He himself has written to us under annexure R5 and R6 saying that he will pay the rentals from license fee from December onwards. That is, I will take my lot to that portion later. Second one, the petitioner shall stand by the statement today that the bank guarantee for a sum of rupees 145.42 will be substituted. He has done it, man. He has done it. He has done it on 7/11/25. So I have no grouse so far as that is concerned. The third one, the petitioner's right to commence operations will be subject to further orders of this court, but the petitioner will be at liberty to complete the pending work at his own risk and subject to further orders. He has never sought any, made no application whatsoever for putting other persons on the board there. So he has not, according to the conditions of the license, There were 3 to 4 things that he was required to do. Condition number 1 was to pay the license fee. It is not just 19 lakhs. Kindly come to license agreement at ink page 54. 62, my lord, may kindly see. 60.
No, Mr. Senior Counsel, when this order is subject to the condition that you should pay that,
Yes.
and you have not paid it, then how can you have the
But only
benefit of that
October
order?
and November is the only.
No, forget about whether it is October only or November alone. But the order says so. You're entitled for an interim order subject to that
Yes,
condition. So you have not done it.
Only
Whatever
for-
is the reason, but
yes,
you have not
only
done
for
it.
2 months. September, my learned friend says September I have not paid. Their impugned order
Then
itself. says
October, November, you have not paid.
Only October, November. So
That
October,
means you have not complied with the interim
only
order.
those 2 months because I went and requested. Lords, that's why they gave a notice.
But you cannot, under the guise of this order, you have to pay it.
Lords, I
And if you request
probably yes.
anything.
Lords, I will not stand. But they themselves in their second notice said, we will adjust it. If you do not pay, we will take it out from your bank guarantee and you will have to give that 40 lakhs or so, whatever is the amount. You have to top up your bank guarantee for that. They could have done that.
So had you paid this, all this wouldn't have arisen.
Yes,
2 months.
No, even if you had
that of
paid,
course, Lord.
even if
That
you had,
will-
even if the other side had paid the money, still there are defaults which I'll show. My lord, it is not from October. This honorable court has stated the petitioner with effect from 1/9/20, that's the first condition. 1/9 September. So he himself,
September, October, November.
3 months.
But as per
Yes.
what he has placed before the court for the month of September, there
October
appears to be some payment.
Kindly see, that is not correct for the reason. Kindly see, is an act of estoppel by conduct, estoppel by pleading. Kindly see my statement of objections in page 51 and 52, annexure R5 and R6. That's his communication to us made on 13/1/2016. Second para. We compulsorily need these extension of rent free until November 30th, as there was disruption of the premises due to bank guarantee issue and termination letter. Will not get it.
That he has already read.
No, he didn't read this. In page annexure R5.
Oh, your,
That's statement of objection.
yes.
Never said.
Yes.
So the para 3, this is written on 13. We humbly resist it. It should be request. We humbly request you to consider raise invoices from December. He wants us to raise the invoice from December. He has taken an order on 26/9/2025. It is laced with 3 conditions. One of the condition is to pay the rentals before the 5th of every succeeding month, commencing from September. He doesn't pay on September, October, November. He requests us that invoices should be raised from December, which presupposes, implies that he does not want to pay license fee for September, October and November. This is again buttressed with the next communication in page 52, R6, para 2.
Yes.
In light of these efforts and operational requirements, we humbly request an extension of rent-free period until November 30th. So he himself admits here, he wants that moratorium till November 30th, which is against directly glaring against the order of this honorable court. So that is clear now that he has not paid the rental. Kindly now see the license agreement. It is not one, multiple. We have issued not just 3 notices, we have issued 5 notices. I will demonstrate. Kindly see, now my learned friend gave one,
You take, when was the position taken?
taken 6/5. 6/5. Kindly see now they have given a statement. In the statement, in the letter, he says he doesn't want to pay up till November 30th. In this statement, he says he has made payment in September and October. It's a false statement.
Bank statement can't be a false.
No, kindly see this.
Please come.
It's not a bank statement.
This is matter along with the other writ petition on second.
Your lordship,
What is the number?
MFA number.
No, WP number.
WP is
2969.
2969,
1 of 25.
1 of 25.
Second.
But your lordships have passed an interim order in this, not to take coercive action. Let them not enter into, if they enter.
I am in
into-
possession. They admit my possession.
Already taken position.
My possession.
Let there be a status quo till Tuesday.
My lord?
Let there be a status quo, whatever it is.
Yes.
I am already in
Because
possession.
then, my lords, they will enter into agreements with the sub-licensees.
There shall be an order of status quo till Tuesday.
Please.
List the matters on Tuesday. Yes,
My lords, I am told the connected matter is listed on 4th,
fourth, yes, fourth.
along with that.
And even the MFA can be lifted. All emanates from the same. MFA also can be listed.
MFA also.
Great.
Fourth, yes.
Then number 42, preliminary hearing. Mohammed Irfan.
Your Honor, I am appearing for the petitioner in this case. I filed a memo along with the translated copy of the annexure A.
Where is the translation?
Your Honor, kindly ink page number 7.
Who appears for the respondents?
Yes, sir.
State.
Yes, where is
This
the
one number.
HDM?
Forty-two.
42, my lord.
Your Honor, I'm challenging the garnish order. I'm the
Recovery
guarantor.
of loan.
Yes,
Action,
Your
they
Honor.
have challenged.
Your Honor, I am a guarantor. Your Honor. My entire salary has been attached. Your Honor. As per CPC section 60, Your Honor, only 1/3 of the salary has been attachable for the loan recovery for the execution proceedings. In this, my entire salary has been attached, Your Honor.
What is your salary?
Salary 1 lakh, Your Honor.
Hmm?
1 lakh, 1 lakh. I am a guarantee, Your Honor. Already the principal borrower's account also been attached, Your Honor. He having salary of 1 lakh
They
50,000.
There is no bar, there is no bar to initiate
No,
the proceedings against.
no, Your Honor, but entire salary, Your Honor. The loan amount is 20 lakh, Your Honor, plus interest 4 lakh interest. The already my 2 months salary has
When was
been,
this order passed?
Your Honor,
When was this order passed?
23 to 2026, Your Honor.
Yes, this matter
Your
on
Honor,
9th June.
Your Honor, kindly interim stay, Your Honor. My next month salary will be, Your Honor, please.
We'll see, we'll see.
43.
Yes.
Yes,
Same
yes,
man.
Same man.
Same man.
Yes, this
Same.
also. Yes,
Yes.
it's 44.
Then number 44. 44. Prakash MH.
Yes.
Shokas notice issued by the respondent number 2, it, school authorities on the petitioner, Mirror Education Institution, indicating the fact that the recognition will be cancelled and a report will be submitted to the CBSE for withdrawal of the affiliation. I think the
What
reason
is
that,
this official memorandum?
says, please, Lord, I may be permitted to file this memo, which is
Take
a
that.
translated copy of,
Take that.
please. At the instance of the respondent number 4, my lord, a complaint was submitted to the respondent number 2, upon which, my lord, initially a identical show cause notice was issued, for which we have replied, and thereupon, my lord, the recent one, which is impugned herein, so which is under challenge. Lord, the respondent number 4 is ಎಲ್ಲೋ ಇದು ಏನೇನೋ ಹಾಕಿದ್ಯಲ್ಲ. ಓ ಸರಿ ಸಾರಿ.
No, they've asked for an explanation.
Yes, yes.
Where
yes.
is the explanation?
My lord, explanation is, and in fact, it is in Kannada. My lord, it is produced in the writ petition itself. From it is at page 55, annexure L. Lord, let me place certain facts which lead to for issuance of this notice.
Only this, the
Please, please.
only
Yes.
issue in this is
Yes, yes, yes.
whether you're having a lease or not. Without a lease,
Yes,
you
so
can't
that's why-
continue and
that's- that's why-
there can't be any intake.
That's why there was a lease. My lord, the respond number 4 is none other than a sitting director of the education institution. The company, I mean, the society registered of the Society Registration Act. In fact, he is the establisher of the school in 2009. My lord, by constituting a society wherein almost all the family members are the directors, the school was running. My lord, in 2018, my lord, the
Is it a registered document?
yes, yes, it was a registered document. In 2018, his son was the president. He
Where
was
is the document?
Annexure A is the first document.
Page number?
Lord, page number 18. For a period of 30 years, which is prescribed under the education rules, which a education institution is supposed to have this kind of lease. Lord, this is for 30 years. With the previous management, wherein his son was the president and respond number 4 was the secretary of it. Lord, thereafter,
Other document?
What?
Cancelling it.
Cancellation. Cancellation is the recent one in 2025. Lord, 30. Which is at page 31, annexure F. Well, under this document, why this cancellation come to?
No, whatever, however it
Yes,
has
yes,
come.
sir, that's why.
The implication of this.
Please, implication is, my lord, 800 students are studying in the school, and if this notice is being issued, which will destabilize the equilibrium of the institution, my lord, we are in end of May, and we are admitting the students, and what about the rest of the students? But at the instance of a private influence, if the state authorities were to act in this manner, my lord, I am questioning because of that, my lord, the validity of the show cause notice is issued. Kindly permit me to place a little bit facts, my lord. What happened? Because of his financial mismanagement, my lord, he has approached the present the secretary, who is a pioneer in in another school. My lord, more than
Please understand,
Yes.
neither the respondents nor this court is interested in the interstate disputes between the petitioner and the other director.
Yes,
Now,
a private dispute.
now, if the respondents do not interfere in this and you continue to have the intake of students,
Yes.
and in view of the disputes between you and the other persons, if this premises is not available, what will happen to the students?
My lord, they have to be shifted. Parents will be under severe distress and inconvenience. 800 students, all of a sudden, if they were forced to, make alternative.
What did the
What happened? What happened?
What did they say now by this? By the improved
I need to produce a lease agreement within 3 days. Otherwise, so this is the indication in the impugned notice that the recognition will be withdrawn and the report will be sent to the CBSE for withdrawal of the affiliation. So this is the threat. But what happened? For cancellation of this lease deed, my lord, immediately thereafter, the respond number 4 has executed.
Date of cancellation?
My lord, it's on 19/2/2025. On the same day, my lord, he has executed registered sale, agreement in favor of the petitioners. The sum and substance of the cancellation is that, my lord, I seek kind assistance from the learned government advocate at page 33. My lord, for the purpose of enabling the present management to run the school, this lease deed is cancelled, and for execution of appropriate document in favor of the present management. That is the text, but page 33, first paragraph. And because of that reason, my lord, the next document, this document number is 4499, and 4500 is the registered.
The date of
Same day.
No.
Please.
What is the date of the lease deed?
Lease deed in the year 2018, 7/6/2018 for a period of 30 years.
Cancelled on?
Cancelled on 19/2/2025. cancelled for the reason that they are selling the entire property in favor of the present secretary, and immediately thereafter, my lord, a registered sale agreement was executed. And part and parcel of this cancellation deed is that in order to enable, facilitate the present setup to run the school, and this document is executed, and he has complained to the authorities. My lord, first he has, please.
Then comes for the petitioner submits that there was a lease deed for a period of 30 years. 30 years, and that there are about 800 students in the school. Which respondent is this? The fourth respondent.
Fourth respondent.
Has cancelled the registered sale date, stating that to facilitate to execute a registered sale date.
Appropriate agreement, that's what.
Appropriate document. In favor of the school. In favor of the school.
Yes.
In favor of the school. The document is cancelled. Later he gave a complaint to the respondents. Basing on that, the present impugned proceedings are issued, wherein the petitioner was directed to produce the lease deed, or else in 3 days, or else the the authorization will, what is it?
The recognition will be withdrawn and report to
Recognition
CBSE.
will be cancelled. Then council, the recognition will be cancelled. Then council submits that there are about 1,800 students in the school, and at the behest of a private party, without looking into any of the aspects, the respondents cannot issue such a communication. Learned AGA takes notice on behalf of respondents
1 to
3. Notice to fourth respondent, they shall be stay of all further proceedings pursuant to the
Annexure P, my lords.
pursuant to the proceedings dated 19/5/2026. Mrs.
I
Smart,
request,
in the month of, on 29 July,
I request for hand delivery of the.
hand delivery.
Grateful.
Yes, thanks.
Siddaramaiah, VP, 45.
For petitioner, the petitioner's mother has filed an application before the Assistant Commissioner for cancellation of the gift deed executed in favor of the second respondent.
That is
In
allowed?
Yes, please.
That is allowed?
No, it was pending. In pendency of the application, the petitioner's mother has expelled. Petitioner has filed an IA to come on record as LR of the petitioner. That IA has been rejected, my lord, challenging
Ground?
this. On the ground that LR is not entitled to seek the,
There are no orders passed.
no order is passed. In pendency of the.
No, she is no more.
Yes,
She is no more, therefore, my lord, close.
no more.
If there is any order passed,
Yes,
then you brought on record, that's a different aspect. No, she has filed the application and she is no more.
yes.
So why should, how can you
We
proceed
being the
that
LR, my
matter?
lord, we are having right to contest this.
How can, if there is an order, then we can, then
Notice-
there is
no-
something
the
in what you
Notice
say.
may be ordered, my lord, it is the
No,
family members will settle it, my lord. For limited-
The present petition is filed. Seeing the following prayer.
My lord, the petitioner's right will be affected, my lord, it is the,
Oh.
so.
If you're right, you have an independent right or remedy elsewhere. Before the senior citizens, the commission, you don't have.
With that observation with liberty to find out.
The petition is filed seeing the following prayer. When counsel appearing for the petition submits that the petitioner's mother has filed an application before the, under the maintenance of the Senior Citizens Act 2007. Under the Maintenance and Welfare of the Parents and Senior Citizens Act 2007. And during the pendency of the petition, the mother died. And the petitioner, who is the daughter, son
Petitioner
filed
is
an
the son.
IA to implead himself. And that came to be dismissed by the commissioner, agreed thereby. The petition is before this court. It is land council submits that if this the petitioner's rights will be affected if this application is not allowed. And further, the commission has failed to consider all these aspects. Next para. Learned AG appearing for the respondent submits that the commission has rightly dismissed the application under the right to, under the act, the dispute, the interstate disputes between the petitioner and other family members cannot be decided. And the court has rightly dismissed the commission has rightly dismissed the petition. Expera, having heard the counsels on either side, peruse the material on record under the maintenance and welfare of the parents and senior citizens act. The agreed party is a senior citizen or a parent. In this case, there are no orders passed by the commissioner. During the pendency of the petition, the mother died. In those circumstances, if there are any disputes between the petitioner and the second respondent, Karen, his remedy is to go before, his remedy is to avail the appropriate remedy before the appropriate forum, but not before the commissioner. In that view of the matter, the writ petition is disposed of, giving liberty to the petitioner to avail the writ petition disposed. This court do not find any irregularity with the order impugned. However, liberty is reserved to the petitioner if at all he has any grievance to avail the appropriate remedy. Number two, notice to the respondent. This court is not issuing notice to the respondent as no adverse orders are passed. AGA takes notice on behalf of respondent number one. Yes, next.
46. 46.
For petition minor, the property was acquired by the land acquisition. Property is acquired. The land acquisition respondent passed the order. The property involved in the acquisition proceeding, the property is an ancestral property.
Who is the 12th respondent?
First respondent is the father.
12th respondent.
12th respondent is KADB. SLAO KADB.
To issue a writ, quashing the order by the
Annexure E. Annexure E.
and direct the 12th respondent to deposit the compensation amount in judicial deposit. Yes, who appears?
Pradeep Kumar H. Pradeep Kumar H.
Yes, Mr. Pradeep Kumar
HL.
H.
L.
N is directed to take notice on behalf of the 12th respondent. 12th respondent. This is matter on 9th of June.
Stay member.
Yes.
47. H. Manjunath.
Notice to the other respondents.
Advocate for the
Yes. 47.
advocate for the petitioner in this case.
Yes.
My lords, this is a case which we have filed for GM police. My lords,
What is this? Read your prayer. Issue a writ of certiorari quashing Annexure A.
Yes, my lords.
To the respondent number 14.
11 and 12 to take a initiative disciplinary
The
action against
Deputy Commissioner of Police is.
My lords.
14 is
Bayapnalli police, my lord, police station.
What endorsement they gave?
They have given endorsement stating that this dispute is arising civil matter, so approach the honorable civil court. So my contention is that I am the agreement holder, agreement of sale holder, dated 1 second.
Purely dispute. My lord, it said
My lord?
tenant and owner dispute. My lord. Owners and tenant dispute. My lord.
I am the agreement.
Owner and tenant dispute.
My lords,
Therefore, my lord,
kindly refer the.
File a private complaint before the magistrate.
No, already we have gone all through procedure. We have given all representations.
Go to the magistrate. Go to the magistrate and file a private complaint.
Senior will come and explain.
This
Kindly
is matter
on 4th, my lord.
on 9th of June. AGA takes notice on behalf of respondent.
on behalf of my lord. Respondent 1.
And
1, 11, 12, 13, 14.
11, 1 and 11 to 14. Notice to other respondents. Yes.
Then number 48. Chetan Kumar L.
My lords, in this matter, the notification issued by the government in page number 24, my lords, impugned in this writ petition, my lords. the government has issued this notification, my lords, issuing directions to the 8 hospitals to procure the dietary food directly from a particular institution, my lords, that too without calling for any tenders. It is direct in violation of the
What is
KTPP.
the amount?
My lords, 14 crore 23 lakh 800, my lords.
It means. Now I called him, my lord, but they have not.
How can there be such a direction? Where is that order? Let's see.
My lords, in page number 26, my lords, it is in Kannada, my lords, page number 26.
Order on 4/5/2026.
They should procure this from whom?
From the bidders, my lords. They have to issue a tender notification and they have to call for the tender notification, and then the tender will apply for it, and then finally they can.
No. What is this order? As per this order?
As per this order, my lords, the government has issued this order to a particular institution.
Where is that institution? What is the name of the institution? Which respondent it is?
My lords, respondent number 4, my lords. Respondent number 4, my lord.
What they have to procure?
The dietary food, my lords. Dietary food for the patient in the hospital, my lords. Nowadays, till so far, my lords, they have secured.
Respondents 1 to 3, AGA takes notice. Fourth notice to respondent number 4.
My lords, there is one circular, my lords, wherein the circular of the government says that such an order cannot be issued if there are any.
I understand that's a general order as far as this food is concerned.
Please, my lord.
And the fourth respondent.
Please, my lord.
They're doing it at a minimal price. That
No,
is
my
the
lords,
reason.
it's 500 times higher, my lords.
What? We'll see. We'll see. This is a matter on 11th of June.
My lords, shorter date, my lord, because they will start supplying from.
This is a matter on 5th of June.
Great.
Petition is, in addition, petition is permitted to take out hand summons on the fourth respondent. Yes.
49, order, serial number 50. N. Nanjareddy.
Therefore, the revision of pension has been reduced by about 35,000 millard. Annexure millard B is the original pension fixed millard 75,300 original pension, for which millard DA 42%. And for the millard original pension annexure B, page 18, you last may kindly see. Pension has been fixed millard at 42% DA and millard 17% interim leave. That has been millard reduced to 14.25%. Without notice to us, annexure C millard. They have
When you
reduced
have
it.
retired?
Millard 2024. Just July 2024.
Earlier, how much pension you were receiving?
Millard 1,24,000.
Now that is reduced to?
Reduced to millard 70,839.
Let's see that. Let's see the proceedings.
Annexure B, you lost my kindly see. Page 18.
Why?
Revision. It should be increased, otherwise.
But this order passed in the year, my lord, 2025 only. Therefore, my lord.
No, 23, 26 annexure H. Circular has been
Circular,
issued.
my lord, based on the government order, my lord, circular has
Circular
been
has
passed in the year 2026, 31/3/2026.
Basing on the?
Based on the government order, my lord. On.
Where is that order?
My lord, annexure F, my lord.
That is question now.
That is question.
30th June 2025, my lord. Page number 27.
Based on that annexure H 36.
Based on this, my lord, this
31
circular has been.
I think there are some orders in this.
Yes, my lord, I have to, that's why, that's what I have to verify.
Any connected petitions?
Yes.
Well,
I'll-
With respect to this issue?
It has not yet been given effect to millard. Let that millard be stayed.
I think some matters I've seen
Yes,
in
ma'am, yes, ma'am. That's-
Dharwad benches
Yes,
also.
ma'am, that's what I'll verify and also we'll file it in the written.
No,
The only interim prayer.
it is not affected so far.
Not yet affected. That
Then
is
where
the
is the communication that it will be affected, which is questioned by you?
annexure H millard. That
Page
is
number?
Page 40.
40, my lord.
Circular.
Circular passed by the.
No, so far you are receiving the same amount.
Same amount.
The presented petition is filed. Questioning the government order dated 36/2025. and the circular dated 31/3/2025. Passed by Treasury Commissioner. There's a fourth respondent here. Land Council submits that earlier. By virtue of this, this circular, the petitioner who retired in 2024 was receiving the pension of 1,24,000. Now the same is reduced to 70,830. Hence the petition is agreed with the same. And further it is submitted that there is no rationale. And so far they have not given effect to that. Considering the same, the respondents shall not give effect to the
Revised.
circular dated 31/3/2026 and the order dated 36/2025 as far as the petition is concerned till the next date of hearing.
Respect of petitioners.
AGA, you appear for them?
All the
Here
respondents.
for my lord,
All the
respondents, all
respondents.
the respondents.
Respondents 1 to 4. AGA takes notice. They shall come file their objections within 4 weeks. Does this matter on 15th of July?
My lord,
Published.
in respect of petitioner only, my lord.
I said so.
Petitioners, two petitioners, sir.
As far as the petitioners are concerned.
Published.
51.
What is this? A memo is filed seeking to withdraw the writ
51 as a
petition.
defreeze ಆಗಿದೆ.
Accordingly,
Yes.
the writ petition is dismissed as withdrawn. Yes, 52?
Till number 52,
Copy for the petitioner, my lord.
Chandrasekhar
The
L.
respondent has sought to recover 6 lakhs for non-payment of housing loan, my lord. Before this honorable court on the ground that,
Vacation or dismiss?
Allah, before, my lord, any amount below 20 lakhs DRT doesn't have jurisdiction. That is the first round taken.
They can agitate before the appropriate.
My lord, what they have done is being aware of the fact that below 20 lakhs they had.
Understand.
Yes.
Now, once we say that writ is maintainable, question of considering all these issues will come.
Please.
I am also not saying that an alternative remedy. I am saying the writ is not maintainable. That question of considering all this will not arise. Or if you want, I can post it after vacation, but I will not pass any order because there's a consistent view taken by me.
It may be posted immediately after vacation.
No, my lord.
Second,
My lord, one submission, my lord.
There's a matter on 4th, so and so, for in the name of so and so.
Narayan Swami D.
Yes. Yes.
4th
next
June, my lord.
53,
4th June. Yes,
Please.
53.
53.
For petitioner, my lords. My lords, land, the scheduled property was granted to the petitioner in 2002, my lords, and Saguvali chit was granted in 2005. He had applied for form number 53 in 1998, my lords.
Issuing an order dated 12/3/2026.
Yes, my lords, respondent number 5 had filed an appeal before Assistant Commissioner, who is respondent number 3, challenging the grant order. And Assistant Commissioner, respondent number 3 has allowed the petition and the grant has been cancelled. 24-year-old outstanding grant has been cancelled. Now, petitioner has preferred an appeal before the District Commissioner, who is read as respondent number 2 in this petition. Since summer vacation recess is going on, matter is not has been taken up in the district court.
When did you file the appeal before the deputy commissioner?
In first week of May, my lords. In the May itself,
In the month of May.
But since vacation recess is going on, they're not taking up the matter, and we have a IA for stay.
My lord, we will take it.
Huh?
Till
We are
6th
taking
of
up, taken up. We'll take. Registering, my lord.
What is that?
Registering, we are registering, but I don't know.
cases are being registered, my lords, but
Not resisting.
Yeah, my lord, they are seeking
Until
for
6th
passing of
June,
the annexure. Yeah, my lord.
sitting is
Stop.
suspended, my lords.
The deputy commissioner has not taken they have not taken the file for registration. Therefore, they have rushed to before the honorable court. 108K, my lord. It is a appeal provision before
Petition
the
is
deputy
in
commissioner.
progress.
He has already filed, it seems.
No, no, no.
You have not filed?
My lords, we have given it before the DC. They have not registered
They
or
have not
not put up
registered. They
the.
are
We'll ask them to do. We'll ask them to do.
Yes, my lords. Until then, now
You have filed and an IA is pending for them. If he is not considering, that's a different aspect. But without filing, just simply saying that he is not taking.
my lords, until 6th of June, they are not taking up any matters, my lords.
No, my lord.
And
The petition is filed.
revenue department is trying to mutate the kata, my lords.
The petition is filed.
At least until the disposal of this application in DC court.
No, that just for the sake of getting an order from the High Court, this
No, my
can't be
lords.
the,
Seriously, they are sitting is suspended.
let him do. The present petition is filed, questioning an order dated 12/3/2026, passed by the, yes, sir. Then what are you doing from 12/3/26 till May?
My lords, there is a 60 days period for the appeal.
The questioning the order passed by
The status quo of the Khata, at
Assistant
least, to
Commissioner
maintain
on
the
12/3/2026.
revenue entries, my lords.
Before the Deputy Commissioner.
Yes.
It is the case of the petitioner that the Deputy Commissioner has not taken up the matter as it is in the vacation. As such, he has come before this court. The Leonard DGA on instruction submits that the such submission made with the petition is not correct. In fact, they're taking all the appeals and hearing the matters. Considering the submission of the Leonard AGA, the petition is disposed of, directing the respondent for Deputy Commissioner to take up the matter and hear the same in accordance with the law. He shall take up the matter and consider the IA within 1 week from the date of receipt of the copy of this order.
I'll accept notice for 1 to 4. Respond number 1 to 4.
AGA takes notice for respondent
1 to 4.
1 to 5.
5 is private practice.
5, as this court is not passing any adverse orders, no notice is issued to the respondents. Yes.
Number 54.
I'm appearing on behalf of the petitioners, my lords.
Yes.
My lords, this is concerning the agricultural quota practical examination test that was held on 10th of May 2026, my lords. My lords, the petitioners before this court are the students who took up this test and have secured very good marks, my lords. My lords, over 2,200 students have appeared for this test in 17 different centers, my lords. However, upon a letter that is written by respondent number 4 to respondent number 3, retest has been ordered only in one particular center, whereas 17 centers have conducted this examination. Only one center they've ordered for a retest.
On what ground?
On the ground that there is alleged malpractice and a lot of students have scored good marks. So there may be malpractice that may be involved. All of these are aspersions. All of these are allegations without a shred of proof, without a shred of evidence. Absolutely nothing is placed on record in order to establish why
When
there
is
is a
the exam
requirement.
going to be conducted?
1st of June, my lords. Not a single reason. If I may request my lords to kindly come to Annexure A. Not a single reason. My lords may directly come to page 24, translated copy. My lords may see that in the reference column, your letter number so and so dated 18/5/2026. This is the respondent number 4's letter to the respondent number 3, the respondent number 2, my lords. And in furtherance of that, in page 25,
That letter,
please, my lords.
where is that letter?
We have not been able to get a copy of that letter, my lord. I will place it along with a memo on the next date of hearing. However, there is a reference to this letter. And upon the letter, they have issued this order without giving any reason.
Unless and until you have that letter, how can you say that there is no basis or?
My lords, that is more or less of a representation that is provided to the undersecretary.
By whom?
By respondent number 4.
Who is
Respondent number 4 is a university. My lords may come to, that is University of Agricultural Sciences, Shivamogga. They give a representation to the undersecretary saying that there may be malpractice. So we request you to conduct re-examination in this review. We have not been able to get a copy of that. We have applied for a copy of it.
You cannot say that that is what the university said. Unless and until we have that.
Please, my lords, but that is a representation that is given to the government.
Oh, in that, he
Please.
must have stated, so what all happened, what malpractices that were taken place.
All of those are alleged malpractices. Absolutely nothing has been proved. Upon those allegations, more than 100 students have been forced to take a retest wherein they've already secured good marks, my lords. And I also would like to place
Without
on
that
record.
letter, we cannot pass any order. And we can't stop the exam.
My lords, it is scheduled on 1st June. That is the only urgency, my
Exam
lords.
we will see.
My lords,
We can't interfere like that in education matters.
if I may make one submission, my lords, I will place that on record, my lords. But then, can the examination be deferred, my lords? I mean, at the end of it, if my lords come to a conclusion that the letter holds weight, then the examination may be conducted. But at the end of the day, if my lords were to come to a conclusion,
Feel that there is some force, we'll set aside, we will say that you only consider the earlier result, not this. Why should we
That-
stop? No. Respondents 1, 2,
may I at least request for a pass over, my lords? I will try to secure the letter. I'm so grateful.
only 4:30.
Please, I'm grateful. I'm grateful.
Copy I have not received.
55,
Copy I have not received on copy.
It has been so. I'll serve a copy. I'm so grateful.
Yes, next.
55, Shivanand Reddy.
In this case, I'm for the petitioners, my lord. Petitioners is the agriculturist. They are set up the piggery forum in survey number 50/2050, my lordship. In say, please, my lordship. At Shivkote Gram Panchayati, Linganalli village, my lordship, the fourth respondent has issued notice.
You have
for-
questioned a show cause notice.
Please, my lordship.
What is the show cause notice?
Cause, final notice.
What is that notice?
That notice is the remove the piggery farm, my lordship.
Remove the?
Remove the piggery farm, stop the running the piggery, and demolish the piggery farm, my lordship. That is the subsequent to that. You have received the communicate the letter and the CEO, the third respondent, for take a necessary action against the piggery farm, my lordship. The coordinate bench is passed order in similar matter, my lordship. Stay the notice, my lordship. May I produce the copy of the stay order, my lordship. Is the entire family are depending upon the piggery farm, my lordship. They are the 10 members in the depending upon the piggery farm. The entire agriculture family, agriculture products, the they have obtained the loan from the bank more than.
Why was this order passed?
My
Why
lordship,
did they ask you to
reason
remove
is-
that farm?
They are not maintaining the neatness. That is the one problem. My lordship,
Where is it situated? Within the village?
Within the village. Not within the village. They are more than 1 kilometer. This is agriculture land. Survey number. They are stating that that is, my lordship. The photos is seen, my lordship. They are the trees and the photos.
Inconvenience, not only your livelihood, that others also should live.
Lordship. My
It's
lordship,
not
there is a-
about your livelihood, others should also live.
There is no any disturbance. The only or the mollified intention. The villagers are the.
Where is the notice given to you? What
My
did the
lordship, link
notice?
page number 16, my lordship.
What it says?
My lordship, this is the they are stating that the piggery farm is running since from 10 years. Since from 10 years there is no disturbance.
That they won't say. You read what that says.
My lordship, in Kannada, my lordship, email.
Translate.
In
My
this,
lordship.
Translate that.
in this, my lord, piggery farm is within the 500 meters of the village. One is another one is, my lord, they are collecting the seeds of poultry farm. They are putting in the piggeries. Thereafter,
No.
my lord, there is a stingy in the surrounding area. That entire seeds of the piggery is to run to the ponds, near the ponds.
When they have issued a show cause notice, what was his reply to that?
No, there is no reply.
Huh?
No reply.
You didn't give them the reply?
This is not a show cause notice, my lordship. This is the notice for final notice for.
They didn't give you a notice at all?
My lordship, they are not given notice. They are not given any notice. I approached after issuing of this notice, I approached the memorandum with memorandum. They are refused, categorically refused. And apart from
I'll dispose of this writ petition saying that let them give you a show cause notice, follow your due process of.
My lordship,
You can't stay it.
please, my lordship, the stay is not, my lordship, this honorable court has a similar
not
matter.
stay.
My lordship, on 25th, the Taluka executive magistrate has issued the notice in today the notice has served. And through WhatsApp, I have received the notice from the petitioners. They are
That's what I'm saying. I'll ask them to issue a show cause notice, give you a reasonable opportunity, and then pass final orders. I will not stay the proceedings.
But here, my
Till
lord,
such time, they will not do anything.
please, my lordship. Tomorrow will be entered into the.
That's what tomorrow they'll not do anything. Please come. The present writ petition is filed. Agreed by the notice dated 21/5/2020.
I'll accept notice for only respondent number 1, my lord. Other than, my lord, it's a Gram Panchayat.
The local body is they were involved in.
Gram
Who has given the notice?
Gram Panchayat.
PDF,
FPS, you don't appear
respondent
for-
number 4.
I will not. I appear only first respondent.
Then I'll keep this writ petition pending till such time, let them proceed and let them not take any coercive steps. The petition is filed questioning the notice issued by the
Respondent number one, I'll accept.
fourth respondent, whereby the petitioner was directed to remove the piggery farm situated at Linganahalli village. It is a case of the petitioner that the petitioner's farm is not creating any nuisance and it is situated outside the village and it's been there from the last 10 years. Before passing the impugned order, no opportunity is given to the petitioner. No opportunity is given to the petitioner. And without following the principles of natural justice, the impugned notice is issued directing the petitioner to vacate the premises. Considering the submission of the land counsel for the petitioner, the respondents are directed not to take any coercive steps. However, the respondents are at liberty to issue a notice to the petitioner and follow this interim order will not preclude the respondents from taking the steps in accordance with law. AGA takes notice on behalf of the
Respondent number one.
first respondent, notice to respondents 2, 3 and 4.
My lordship. Order may be hand delivery, my lordship.
Yes, hand
Number
delivery.
56.
Please. Much obliged.
My lord, I'm challenging the impugned order found at Annexure A, my lord. It's arising out of an application filed under section 24 seeking interim maintenance by the respondent. The respondent is the wife of the petitioner, my lord.
Which one this is? Serial number?
56. Annexure A is at page number 10, my lord. My lord, through her application, the respondent had sought for 30,000. However, my lord, the trial court has ordered 15,000 that requires to be paid. My lord, in the asset and liability statement, a lot of false expenses has been claimed by the respondent.
What is your income?
My lord, I am not employed, my lord. I have a fixed deposit of 7 lakhs rupees. The interest that has been accrued on that, my lord, that is what I am using for my everyday expenses, my lord. I have also submitted my bank statement to show that, my lord. I am getting about 7,000 per month, my lord. I have also taken, my lord, there are 2 children, both of them are major as on date. My lord, I have taken care of all their educational expenses and that has been admitted and also noted by the trial court judge, my lord, in the impugned order. My lord, to the best of my abilities, I've taken care.
Till they come, you have to pay half of it.
Please, my lord.
Pay half of it.
My lord, I'm ready to pay 5,000, my lord, my lord.
Please come. Land counsel for the petitioner submits that. The petitioner's income is 7,500 per month. As he's not having any, he is not working and that amount is derived from as an interest from the fixed deposit. The court has failed to consider the same and granted 15,000. 15,000 per month. In fact, he has taken care of the educational necessities of the children, which is an admitted fact. Considering the same, there shall be stay of all further proceedings on the condition that the petitioner shall pay an amount of rupees 5,000 per month and the arrears also at 5,000.
My lord, the interim prayer, my lord, which has just passed, it is stay of all proceedings. However, my interim prayer is only stay of implementation of Annexure A.
Pursuant to so and so, stay of all further proceedings, pursuant to the order.
Please.
Yes. If the petitioner fails to pay the amount, the stay granted by this court stands vacated. This matter on 1st of July, the petitioner is permitted to take out hand summons on the counsel appearing for the respondent before the trial court. Is 57?
Number 57.
57. Complaints of office objections. I'll have to serve a fresh copy, my lord, on the council. KV Lokesh is appearing. I'll serve it. It may kindly be taken up, my lord, on first. It's an NBFC. I am aware, my lord may not.
Canfin Homes Limited.
First June.
This is matter in the first week.
No, first June, Lord, because second is the auction, 1st June. I'll serve the copy, my lord, on KV.
Yes, 58.
1st June.
Yes.
Yes, Lordship, hearing for respondent bank, my lord. Kindly permit.
Challenging the possession notice and also sale notice and
Issued
also
by whom?
irregularities of the bank, also pendency of the OTS, my lord. Is a since driven from the 2020 due to the.
Is his OTS
tense-
proposal pending?
Yes, my lordship, he has offered 3 crores as an OTS against total liabilities of 8.3 crores.
10%.
Pay it, let him submit. What is that?
My lordship, 3 crores OTS offer has been given against a total outstanding liability of 8.3 crores, which is not viable, my lordship. Their bank has not considered it. They are communicating it in writing.
So there is nothing pending as on today.
No, my lordship.
It is not order, it is not taken decision.
He says they have taken the decision.
No, we are not communicated.
They will be communicating,
Still
my
it is
lordship.
pending. Their upfront amount also pending before the bank.
Yes.
Lordship, I have the instructions saying that they will be communicating it in a couple of days.
Pay 10% upfront amount. It is pending before the bank. Still not communicated. Not only the OTS issues, other irregulars, so many irregulars. We are completing the orders of the High Court, Honorable High Court also. Please.
What do you have questioned? Then go before the DRT and question all this. Why should
He's
you come to
questioning
High Court?
possession notice, my lordship. One
Go to the
pertinent
DRT.
point.
Whatever all
Yes,
the
madam.
issues.
Lot of things are.
All
still-
those issues raised before the DRT.
No, there is maintainability regarding this.
What
bigger
maintainability?
natural justice violation thing.
All these can be raised before the DRT. Why should this court go into all these issues?
The total Surface Act is not acted in properly, madam.
That is what.
Proceedings
that-
are entirely false.
The DRT
The declaration
is
of NPA is false.
DRT is
Then
for
the-
that purpose.
Madam, just to go through one order, madam. Your lordship passed an order regarding this case, madam. Please.
Yes, where is that?
Page number 259.
Yes. Yes.
The final order passed by your good. Directed to give reply to the 13-2 notice, my lord. Already given reply to the notice, and same has been counter reply also received, denied our consideration. But in this, after the reply under section 13 subclass 3A, bank has to proceed further and issuing the position notice and sale notice. But here is quite reverse. They issued position notice, issued sale notice. Later onwards, they replied to the 13-2 notice. It's
That is
totally
not
contrary to the
correct,
surface.
my lordship.
Date of issuance is position notice is earlier than the reply given to the 13 subclass 3A notice.
When did you
This-
reply?
My lordship, this reply was given in terms of the order which my learned
Reply
counsel
given
on the other side has pointed out. That is
11/5/2026.
11/5?
2026.
When is the order of this
Their
court?
position notice is dated 9/1.
Please
Okay.
wait.
Order is
8th April
8 April. My
2026
lord.
is the
Correct.
order.
Yes.
Yes, my lordship.
Within 15
Wherein
days,
there
we given the
is
reply to the
directed
bank.
to give a reply, representation and to reply.
Completed.
Both of you argue like this, I can't understand. I'll ask you, Mr. Counsel. Yes, 8th April
8
2026
April
is the,
dispose the matter, giving liberty to give reply to the bank
When did you
within
give the
15 days from the
reply?
date of receipt of the copy. Same has been complied. We are given 5/5.
when did you receive the copy?
I think
Don't think, you should state correctly, when is it?
we received the copy on 11/5.
15 days will complete when?
No. Where is it? Actually, afterwards we apply for certified copy. Based on the online copy, we are given the reply.
Why should you when did you receive the copy? When the copy is uploaded?
It is not mentioned in the final order copy. We applied 11/5.
So whenever you apply that's the day the limitation will start.
20th of April.
Oh.
It has been uploaded.
Hmm.
20th, I think 21st of April. Within 15 days, we given reply, madam. My lord.
So and so takes notice. The respondent shall file their objections. Yes,
Yes, my lord.
59.
Then number 59.
I represent for the petitioner. The respondent number 3 is an association owner, apartment owners association, registered under the Karnataka Societies Registration in violations of the Karnataka Apartment Ownership Act 1972. But whereas the resolution has been placed by the respondent number 3, my lord, in page number
66. It is nothing but a back.
Action of the second respondent
Sec-
in registering the society.
Yes, ma'am.
Against it, there is no appeal.
Please, ma'am.
Against this, there is no appeal.
No appeal. Ma'am.
No appeal.
This is covered by
But
judgment,
here,
my lord.
Huh?
No appeal, my lord. The registration in the year 2010, my lord. Now they are challenging.
It is a covered by judgment, madam. Wherever the,
Convention.
it is recent Justice Suraj Goendraj.
Yes.
I may permit pass on. Society
No,
is
it has been done long back. The
irrespective, my lord,
respondent-
it is under violations of the Karnataka apartment.
It was
ownership.
done in 2010. There is no urgency to suspend it now.
For suspending that, I am not seeking. I have started there is a resolution boycotting this petitioner from the social team. Madam, they have taken resolution on 17/5/2026. It is in page number 66, madam.
We have to stop the resolution
Yes,
that
ma'am.
is
That's the
taken by
interim.
a,
Yes, madam.
that is taken by the
Respondent number 3.
association.
Yes, madam. Which has been registered and in violations of the Apartment Ownership Act. They have taken a by
Respondent
exceed.
1 and 2, AGA takes notice 3. Petition is permitted to take out hand summons. Does this matter on 10th of June?
Please.
59, 60.
For the private response. Read paper served today, my lord. I'll file objections to this.
This is
Finally,
matter
our date may be fixed.
on 10th of June for filing objections.
Number 61, Vivek S.
No, petitioners have agreed with the impugned action of respondent number 3, wherein revenue entries are mutated in undue haste, my lords. Background of the matter is, my lords, respondent number 4 had filed an application before respondent number 1, my lords, for resumption of land under the provisions of PTCL Act. Said petition came to be allowed on 11/5/2026, my lords. And respondent number 3 on the very same day has mutated the revenue records, my lords. So it is also contrary to the guidelines laid by coordinate bench of this honorable court.
We'll see after vacation. First, respondents 1 to 3, AGA takes notice. Notice to the fourth respondent. Does this matter on 11th of June?
Number
Yes, 62.
Number 62, Rajesh.
My lord, I
Nayak.
appear for petitioner, my lord. My lord, the husband presented the above petition challenging the interim maintenance awarded by the.
How much?
12,000, my lord, without considering the assets and liabilities of the petitioner, my lord. The petitioner is, my lord, is under chronic depression, my lord. He is not capable of doing anything. My lord,
File your statement of assets and liabilities.
please, my lord.
As per that, what is your
I
income?
have produced here also.
What is your income as per that?
My lord, he is not working. He is chronic, under chronic
Come to the
depression.
order. What did the court say?
My lord, the court, my lord, without considering the.
Where is that? Where is
My
the
lord,
order?
annexure K at page number 95.
Yes.
My lord, the court below, my lord, fixed the interim maintenance mechanically. Your lordship, kindly come to reasoning paras. Page number 98. May I read, my lord? My lord, the relevant para is, my lord, 15 at page number 105. My lord, the petitioner in, my lord, ready to pay 50% of the interim maintenance awarded by the court.
The petitioner husband is working as civil engineer and running own construction company.
Earlier, my lord, not now. That is a false facts given by the wife.
It is stated that he is not working and has no income to pay maintenance.
Please,
But
my
to that effect, no materials are placed before the court.
Please, my lord, I have produced assets and liabilities, my lord.
That you are suffering with depression and you are not working, what is the material for that?
My lord, medical records I have produced
Before the trial court, you have not produced. That's what the court's observation.
Produced, my lord. I have copy also here. My lord, the petitioner is ready to pay 50% of the maintenance. The court below,
How
my
will
lord,
you pay 50% of the maintenance? When you're not working, you're not having
my lord,
money.
otherwise it is 12,000. the petitioner is not capable of paying such an huge amount. My lord, while passing the order impugned, the trial court without referring the
What
order
is this?
passed by the Honorable
What is
Apex
this
Court.
order? What is this order?
Please, my lord.
Order that you have placed at page number 107.
This Honorable Court has passed the.
In your case?
Not in my case, my lord. In the similar circumstances, this Honorable Court, your Lordship has passed this order without in the similar circumstances, this Honorable Court has passed the order that the court must consider the guidelines issued by the Honorable Apex Court while determining the compensation.
Court has considered it.
No, my lord.
Court says you have not placed anything on record to show that you have a medical issue. Have you placed?
I have, please, my lord.
Show that. Take that.
These are the copies I have produced before the court below. He is suffering from chronic depression. My lord, the respondent, my lord, while submitting her assets and liabilities, statement of assets and
No,
liabilities.
we'll not go into that now. First of all, let's see what is it. What these documents disclose?
This is he is taking continuously treatment for his illness. He has produced all those documents before the court below.
Please come. The petitioner husband is agreed with the order of the family court, whereby the maintenance of an amount of rupees 10,000 is awarded to the wife. Is granted an amount of rupees 12,000 towards maintenance. It is submitted that the petitioner is suffering with depression and is not in a position to work. Though this fact was brought to the notice of the court, by filing all the relevant documents, the court has failed to consider the same. This court has perused the order wherein it is mentioned that the petitioner has not placed the documents in support of the same. However, petitioner has placed before the court the statement before the court to show that all the medical records are placed before the court. Considering these aspects, there shall be stay of all further proceedings pursuant to the order dated so and so, on the condition that the petitioner shall pay an amount of rupees 6,000 per month, and the arrears also at 6,000 within 4 weeks, or is the stay granted by this court stands vacated. Petitioner shall take out hand summons on the counsel appearing for the respondent. We shall file a memo to that effect by 29th. Even if the memo is not filed, the stay granted shall be vacated. Yes.
Much obliged.
63. Vignesh Shetty.
Lords, though the order under challenge is passed by the NCLT, my lords, some kind of procedural impropriety is what we are faced with. Lords, an order, lords, the IBC proceedings were initiated against us. Lords, that came to be challenged before this honorable court. A settlement was entered into before this honorable court, which was recorded by the division bench saying that they will have to withdraw the application. We have to give them additional security, and I will have to ensure that the flats are sold in a particular block and the money has to be paid. This was the sum and substance of the settlement, which forms a part of the order. Lords, it so happened that after this order was passed, there was one more IBC proceedings which was initiated against me by another creditor, which came to be admitted. So the IBC proceedings filed by them came to be rejected by saying that since there is already an appointment of the interim resolution professional in another matter, in this matter it is not necessary. However, if that matter is closed, you are reserved the liberty to revive this matter. But in the interregnum, the settlement had already taken place where there was an obligation on them to withdraw the proceedings before them. Notes, without whispering on this settlement, they file an application before the NCLT saying that the proceedings is to be restored by referring to that latter order. We objected before this, before the NCLT saying that this can't be done because there is an obligation for them to withdraw this, which they have not done. Further, it says that in the event of there being a default, they have to freshly initiate the proceedings. Now, based on the earlier default which was committed, which is already merged into the latter undertakings before the court, which is recorded, you cannot continue with the same proceedings. This is a sum and substance of the application filed. We also filed an application for seeking LOC, the NOC, that is the no objection certificates for selling the flat so that we can make good the money, which was again in furtherance of the orders passed by this honorable court. Notice what the tribunal does is, it passes an order restoring the application on 19/2/2025. No difficulty, it's passed an order. I have a right of appeal. Notice the order is not released till 22/5/2026. It is uploaded on Friday night, that is 22/20. Then at least I should be given the right of appeal, because I have a right of appeal, my lords, against that order. Matter is posted on the next day. Then we said that this is an order which has been passed. I should go through the order. If there is a right of appeal, I will have to pursue the appeal. The court says, no, nothing doing. So far as your application for the no objection is concerned, I am going to pass an order tomorrow. I said that at least let me be heard in the matter. Says, no. If at all you have got anything, you file a written submissions, post it for tomorrow. On that day itself, it said, no, I am going to reject this application. Posted the matter for next day. Again, the application is rejected, the order copy is not available. Even as on today, I stand before your lordship, the order copy is not available. Notice, this is the manner in which the proceedings are conducted. The matter now stands posted for 4th for admission. Once the matter gets admitted, the board of directors gets discharged by appointment of an IRP. So I will have absolutely no rights to pursue before any court. This is the scenario with which we are presented. Can I just draw your lordship's attention, my lords, to page number 67.
Which is that order dated where your no opportunity was given to you to file an appeal
Lords,
because order copy was not ready.
Lords, kindly have a look at page number 240.
That order is dated.
Lords, that is an order which is, Lords, that is page number 240. Lords, in the bottom, the second entry, my lords. Number 1, 25/5/26, the order is said to be passed. For admission, it is said is adjourned. Lords, serial number 1 in the bottom, my lords, at page 240. 25/5/26, listing purpose admission adjourned. Next listing disposal 26/5. Next listing purposes for orders. Order upload date time not applicable. So the order is not uploaded.
No, passed on 25.
On 26th.
26?
Yes, Lords, I just, there is one order copy which they have missed out, that pass list.
No, the first order I am referring to.
Lords, first order, your lords will kindly see. This is at page number, the order which has been now released as page number 226. This is the order.
226.
This is the order which they have released on 22/5/2026.
22/5/2026. Which was pronounced on?
This was pronounced on 19/2/2025. I'm sorry, 19/2/2026. I stand corrected.
Then now the second order is passed on 26/5.
26/5, and that order is not released. Matter is again proceeded with. Note, this is some kind of procedural impropriety because, notes, I can understand, because matters came up whether the reasons to follow orders could be passed by the inferior tribunals. The Supreme Court said that it is only the prerogative of the Supreme Court because reasons to follow cannot be passed by any of the inferior tribunals, which is subjected to any supervisory jurisdiction of the higher courts, whether it by means of an appeal, writ jurisdiction, or even by specially. This is the manner in which, my lords, we are getting the proceedings conducted. Lords, I'm not saying, my lords, that the orders which has been passed is not amenable to appeal, etc. But the procedural impropriety with which it is being conducted. Now, matters listed on 4th, I don't have a chance to file an appeal against the first order where the statutory period for limitation is 30 days. No, it is not listed beyond 30 days. Even the second order, when I'm entitled to seek for an appeal because it's asking for an NOC pursuant to the orders of the division bench of this honorable court, again, the matter is again listed on 4th. Now, this is the difficulty with which we are placed.
Can I just say this? Now, the first order, of course, I'm not on KVA, but I'm obliged that your lordships is asking me. I don't have a copy of the petition, so I may not be able to point out page numbers. The first order, my lords, was, as my learned friend rightly pointed out, it was pronounced in open court on, I think, 18th or 19th of February this year. In fact, my lords, even we repeatedly asked the Honorable Tribunal to upload the order. The only question was uploading the orders. Now, it was uploaded on 22nd of May. 27th of May, my lords, the NCLAT was sitting in a vacation bench. So the first order, my lords, they had time to move the vacation bench. That would be point number 1. Point number 2, my lords, the matter is listed on 4th. It's not as if the matter will get admitted on 4th of June. And I'll also explain why it's listed on 4th of June.
No, had an order been passed on this 19/2/2026
Correct,
order,
lords.
this
It was only
next order
uploaded.
wouldn't have,
It was only, it's not reasons to follow. The order was passed. It got uploaded for some reasons.
He has to have there's a
Of
copy
course, the right to
order.
appeal. That's all I'm.
I'm saying, no, if that order is made available to them.
22nd
And
May.
if they have appeal and the appellate forum comes to their rescue.
Correct, Manas, correct.
This order on 26/5/2025 wouldn't have.
No,
been passed.
26.5, I'll come to the second order in a bit. Second order, there may be, in all fairness, Manas, I'll come to that. But the first order, Manas, they were aware of the order. Of course, they could not have filed an appeal, obviously, unless the order is uploaded. But what I'm trying to submit is on twofold, Manas. One is 27th May, the vacation bench or the NCLAT was sitting. So let's assume, Manas, they have the time to file this writ petition. They could have easily moved the vacation bench. That's point number 1. Point number 2, 4th of June, the matter is listed for the precise reason that there is another creditor's petition that is also listed on 4th of June. So it's not as if the NCLT is going to hear the matter and admit the matter on the same day. They will have ample time. In fact, today we are on 29th of May. Time is there till 4th of June. They can approach the NCLAT.
No, what are the consequences of this order?
If the, yes,
5/2020.
26.5, Maharaj, is a, if I may use the words, it's a bit of a far-reaching prayer itself. What the NCLT, I'm on instruction I'm submitting, I was not there in the NCLT on that day. I'm told, my lords, what happened was they moved this IA to direct the respondent, that is the financial creditor, to release certain NOCs. Now, the bench clearly expressed that we don't have the power to enforce a settlement. We don't have the power to direct them to issue NOCs. You want to argue the matter, but we are not going to allow it, is what I'm told happened. And in fact, even liberty was granted, file your written submissions, to which I'm told, my lords, on instructions that they said we will not file written submission, and it was said that the application is dismissed. Now, even there, my lords, the order, yes, of course, there is, that will not have any implication on the hearing per se. I have, in all fairness, I will admit that, assuming, my lords, 4th of June, miraculously, both matters are heard, both matters are reserved, and next day order is passed, yes, maybe their rights would be prejudiced. But it's not, I mean, for all practical purposes, it's not going to happen. So all that has happened is on 4th of June, the other financial creditor who is owed a far larger sum of money, they will have to first address arguments, because at their behest, that their application also came to be restored. After they argue, then we will have to argue. Then the NCLT will have to pronounce orders. In the meantime, they will have ample time to approach the NCLAT. And if the NCLAT grants the stay, there ends the matter. But it is not as if something is going to happen on the 4th of June itself. So that's all my respectful submission. And then there is 5 days time. They can approach the NCLAT. It's not as if we are advancing the matter. So to that extent, I don't think there will be prejudice. But yes, in all fairness, if an order is, let's say, the matter was reserved for admission. After hearing on admission, matter was reserved for orders. And let us say that is posted on 4th of June. Yes, I would be fair enough to say that, of course, their rights would be prejudiced. But both sides have to argue. And in fact, as far as that first submission is concerned, that there was a settlement entered into, yes, there was a settlement. There were certain timelines. Both sides dispute that you were supposed to do something first. Those arguments were addressed in the restoration application. In fact, I don't have the full the page numbering, but at paragraph 12 of the order, the NCLT has said, all that we will hear you, but let us at least restore the application.
Still such order of 26/5/2026.
Yes,
it's approved, right?
Yes,
no, they shall not hear on 4th.
Admissions. They should not hear on the admission.
But the other, yeah, very well must be.
Because unless there is, the party has a right of appeal against an order. No, if the right of, unless and until they exercise it, the tribunal cannot keep on proceeding with the matter.
No, Then could your lordships consider this, my lords? Then fourth would be Thursday, my lords.
Yes.
Lordships may consider having it on Tuesday. We'll probably file our counter in the meantime, my lords. And if the need so arises, my lords, then we can always take. I'll
just
get
keep
instructions.
I'll just keep it pending. I'll
Yes,
just
ma'am.
say the tribunal is directed not to proceed with the matter.
That would be, my lords.
Not releasing.
Then, my lords, or at least your lordships may
They are
consider
not
having
on
it on
caveat,
second or
my
third.
lords.
In the meantime, let me get instructions. If I can make a submission on the next date, that we will possibly take an adjournment. There ends the matter. But my only concern is any order from your lordships directing the NCLT not to.
I'll record no, instead of postponing the matter or adjourning the matter, I'll say that the respondent submits that they'll not, they'll not proceed with the matter on the next date of hearing.
Only till the next date of hearing, then we will see.
Fourth.
Lords. If by that
They'll
time,
not
if it has
proceed with the
happened, then we
matter
will
on
see.
4th.
My learned friend is a little concerned that it should not come from us, but I quite see what your lordships is saying. That, but my only submission is, my lords, fourth, nothing, because, my lords, the other financial creditor.
Then we'll put I'll adjourn it to second.
Second, or
So
at least
that
we'll
is the
file our
same,
counter. And if by then, my lords, if I am able to prevail upon my learned friend to make such a submission, then at least.
That would be the.
Yes, but I'll make that endeavor. I'll make that endeavor. And if I'm very certain fourth, nothing will happen. But my lords may call it on second. I'll get instructions in the meantime.
On second.
Great.
Yes.
Bill number 64. P. Mahesh.
The submissions could have been recorded, my lords, because it comes before a different
Counsel-
bench.
Very well, Madam.
And
Very well,
senior
absolutely.
counsel appearing for the petitioner submits that an order was passed by the NCLT on 22/5 on 19/2/2026 until 22/5/2026. That order is not uploaded. Again, another order was passed on 26/5/2026. So far, that order is also not uploaded.
Not uploaded. The other one is uploaded. That order is not uploaded.
No, the order that is, the order dated 19/2/2026 is uploaded
Yes.
on 22/5/2026. And another order was passed on 26/5/2026. That order is not uploaded
Yes.
so far. It is submitted that the petitioner is deprived of an opportunity to assign the order dated 19/2/2026 for a period of 3 months. And now the matter is listed on 4/5/2026. Learned senior counsel appearing for the, what should I record?
Lords should say that they take notice.
My learned friend will
because they're
take
not on
notice. My
caveat.
learned friend will take notice. I will just write down. He'll take note.
So,
He'll notice and he'll
As-
file wakalat by tomorrow.
It submits that they have instructions to file wakalat on behalf of respondents.
Please, only sole respondent.
Only one respondent. Only one.
On behalf of the respondent. And he seeks time to get instructions.
Very
As a matter is listed on 4/6, list this matter on 2/6/20.
Grateful.
Please, Lords.
Yes.
Great.
Name. Bill number 64. Name.
Yes.
My lordship, appearing for petitioner. This is my lordship against the divergent finding of the both the authorities, assistant commissioner and deputy commissioner, my lordship. Lordship, I am the owner of land bearing survey number 181/1B, which was entered in the year 1945, my lordship. Since 1945, my lordship, this land is standing in my grandmother name. 1945. Previously, my lordship, in my grandmother's name. Subsequently, my lordship, my father's name has been entered in the year 1972. Now, my lordship, in the year 2000, my lordship, 2001, 2002, we both the petitioners, my lordship, got divided the property and got entered the mutation, my lordship. In the year 2024, after lapse of 80 years, my lordship, these respondents 4 to 6, my lordship, questioned the entries made in the year 1945 before the assistant commissioner. Assistant commissioner, straight away, after hearing both the parties, my lordship, has rejected the appeal, holding that.
Reverse for the deputy commissioner.
Yes, my lordship. Now that
What is the finding of the deputy commissioner?
deputy commissioner, my lordship, it has to be one way, my lordship. He says that, my lordship, right of the party has to be determined by the civil code. And again, my lordship, he only direct the Tahsildar to conduct an inquiry and pass an order within 3 months and set aside all the orders of 1945 and all the mutations.
Only, my lord, it is with respect, my lord, it is a civil dispute, my lord. Thereafter, my lord, therefore, my
cannot
lord, mutation
decide.
in the, and regards, regarding maintenance, mutation and RTCs, my lord, concern. They has to approach before the Tahsildar. Once again, he has to verify, re-verify.
Lordship, how can he decide the rights of the party?
Because
Decided in 1940. My Lordship, moreover, one more point, my Lordship, already a civil suit is pending.
So 88 is not
Status quo.
necessary that all the time you should support or you make submissions, whatever your, whatever the respondent passes. It reflects on you.
That's
is
what my line friend does. 1 to 3, my Lordship, my land friend. take.
AGA takes notice on behalf of
1
respondents.
to 3, man.
1 to 3.
Notice to respondents 4, 5, and 6. Then counsel with the petitioner submits that the revenue, the petitioner's names are mutated in the revenue records. The family, the grandfather's name is mutated in the revenue records in 1945. And in the year 1972, the father of the petitioner, after the demise of the father of the petitioner, the petitioner's names are mutated. After 18 years, the respondent number
4 to 6.
4 to 6 have made a complaint. And basing on that, all the revenue entries right from 1945 are set aside with the respondent number 2.
Number 1.
Respondent number.
Special Deputy Commissioner.
Respondent number 1. Considering the fact that the petitioner's family, their names are there in the revenue records right from 1945. And unless the respondents enter appearance and the respondent 1 file objections, this cannot be decided. And if the interim order is not granted, it would cause hardship to the petitioner. There shall be an order of stay of the operation of the further proceedings. The order passed by the first respondent, Special Deputy Commissioner in RP number 120 of 2025 dated 22/5/2026. Yes, next.
Number 65.
My lords, I beg to appeal for the respondent corporation, my lords. I filed an IA vacating stay, my
my
lords.
lord. My lord, vacating stay application, my lord, was served on yesterday night, my lord. May I seek for short accommodation.
This matter on first. Yes, 66.
Interim order may be extended.
Interim order only granted is
Lords,
extended.
may I make only one request, my lords? Lordships, I only seek my lordship's indulgence that the petitioner be directed not to put up any further construction, my lords. Only to that extent, my lord.
A senior is not in station, my lord. That
Only
is.
to put up any further construction. My lord, there is
When your senior is not in station, you can have interim orders can be extended.
No, my lord.
What is the interim order passed by this
my lord,
court?
the interim, my lord, the interim order.
Then don't make any further construction.
That is all that I am
Till
asking.
Tuesday. The
My lord, senior is not in station.
interim order, earlier interim order is granted not to take any coercive steps.
Please.
The respondents have filed the vacate petition. Land counsel for the petition, respondent submits that the petitioners are proceeding with further unauthorized constructions. Accordingly, this court is modifying the interim order. The respondents are directed not to take any coercive steps, and the petitioner shall also not make any further construction. Yes.
Deeply
Place
obliged.
this matter on 18th of June. Yes.
Deeply obliged.
Cell number 66.
My lord, I appear for the permission, my lord. I like to submit the wakalat for R5, my lord.
Yes.
This is
So submits that he has instructions to, he is filing wakalat on behalf of R5.
R5. My lord, one submission, my lord.
I appear for R4, my lord.
I'll get east.
You also filed wakalat or you are ready to?
I have already filed. My name is shown.
The last 26th they have
Yes.
appeared. Well, one
Yes,
submission.
what is the relief you are seeking?
My lord, one submission, my lord.
Hmm.
The petitioner is questioning the order of the learned assistant commissioner, my lord. My lord, findings in the impugned order, page 80, my lord. One para. This is in Kannada. I am translating that, my lord. There is no any financial difficulties or the 3 daughters taking care of the father turn by turn, and he is turn by turn. 10 days each. They are taking care of the,
I heard this matter on the last occasion.
Yes,
What
madam.
is the amount?
26.
Forget about, don't take for term by term. Give him the money, he'll take. care of
money
himself.
already, my lord, that's what I wanted to bring this notice of this honorable court. There is a common account. All rental incomes will be deposited to the common account. From that account, every month, the money was transferred to the father, my
How
lord.
much, how much?
That is whatever that I will place before this honorable court.
That is why it is
No,
adjourned to this week.
now what happened is the eldest daughter, she intermeddled with the financial transactions. That is the reason for this dispute, my lord. She wanted to grab the property.
Let's forget about the daughter.
Yes.
What is that you're giving to the father? That I wanted to know. That's why the matter is adjourned.
I don't understand. My lord, only I'll place the all
You're not doing.
bank statement before this honorable court, my lord. Already it was going, my lord.
List this matter on Monday.
Or Tuesday, my lord.
Request of Tuesday, the request of land council appearing for the fifth respondent.
Fifth respondent.
By that date, it shall be submitted before the court. What is the amount every
Already-
month they are giving to the father?
And the statement to which amount was transferred to the,
And even if at all any amount is transferred, the statement shall be placed before the court. Yes.
7. Sir Raju, MC.
Lord, the petitioner is a person of disability. On the basis of opinion given by the medical board, my lord, he was accommodated light work since 2013. My lord, subsequently, my lord, as per the direction of this honorable court, again he was referred
Where
to.
is Mr. BL Sanjeev?
My lord, I have already served.
In last occasion also he was not there.
He is on VC.
Let them, my request is, my
Sanjeev,
lord,
sir.
let them continue to extract light work, my lord.
Let them?
Continue to extract light work. 22nd onwards, my lord, this month.
Last occasion, though it's submitted that the papers are served, as there was no representation, this court has directed the name of Mr. BL Sanjeev for the respondents to be printed in the cause list. Today also, his name is printed. There is no representation. Considering the submission of the land council for the petitioner, the respondents are directed to continue the petitioner in the present placement till the next date of hearing. List this matter in the month of, on 14th of July. Yes, next.
Case number 68, adjourned 69.
For petitioner. That's tender matter, not my whole ground was that 90 days had expired and that proceeded with the tender matters. No, my lords, I want to place, my lords, what has happened on Wednesday, my lords. Because on Tuesday, my lords, my apprehension that they will issue work order.
Yes.
I would like to place what has happened on Wednesday, my lords. Through
Let us
this,
see what is the tender.
my lords, tender is for maintenance of STP plant, my lords. It was published on 13/11/2025, my lords.
Directing the respondents number 2
To recall the
tender
tender.
proceedings pursuant to the notification is so and so. Why they have not completed within 90 days?
Within 90 days, my lords. Now they have proceeded, my lords. On Tuesday, my lords, it was only till the stage of technical bid, my lords. On Wednesday, they have
time to
opened the
time.
financial bid also.
Time to time it has been extended, my lord. Time to time it has been extended. Thereafter, my lord, permission has been sought from
Well,
the
that's
petitioner.
one submission.
Petitioner is admitting. My
Well,
lord, he has rejected. He is not agreed upon. Therefore, my lord, once again we are.
No, you only have to say what the circular says, whether you have, whether you are following that circular or not.
My lord, time to time we have extended.
My lords, time to time, they have,
Extend from time
Following
to
the
time.
circular, my lord.
my lords, that
Following the circular, my lord, we have extended.
What is that circular? How do you extend it?
After 90 days, my lord, we have to give a notice to the author, both the entire bidders, not the bidder, my lord, petitioner. He is not agreed
When
upon.
did
All
you
the-
extend last
all of-
time?
18, my lords, it's at Annexure D, my lords, 18/5. 15/5, they have sought for extension, my lords, 15/5/2026. On 17/5/2026, we have refused our consent to extend.
You are the only one. How many are the other bidders?
My lords, there were 5 bidders, my lords. Now, my lords, in order to, my lords, to favor one particular tenderer, my lords, they have proceeded to open the financial bid also, even after refusal of the tender, the extension, my lords. And my lords, for 7 months, they didn't do anything, my lords. Only on 15th May, my lords, they seek for extension. So the submission that they were extended time to time is false, my lords.
Then counts for the petition submit start. The respondents contrary to the, what is that circular? Contrary to the Karnataka Transparency in Public Procurement Rules 2000.
Rule 22, my lords. Rule 22.
Rule 22, 3 of the Karnataka Transparency in Public Procurement Rules. Even after expiry of 90 days, without following the procedure, now they have proceeded to open the
Financial bid also.
financial bid to favor uh, one of the participants. Learned AGA takes notice on behalf of already taken. Learned AGA submits that you would get instructions in this regard. The respondents are directed not to proceed with the they shall be stay of all further proceedings in respect of tender reference number. Look at the interim prayer till the next date of hearing.
That's hand delivery, my lords.
This is matter. He'll inform when the AGA is there why you want.
That's because, my lords,
delivery.
only apprehension, my lords. On Tuesday also, they told same.
To inform the same to the respondents. List is matter on 17 June. Yes,
Grateful, my lords.
yes, 54.
Hearing on the other petitions. I was not able to receive a copy of the letter. However, if I may make one last endeavor, my lords. My lords, the order that has been passed by the government, it's not at all a speaking order, my lord. All that they have said, if I may only read the order, my lord, all that they have told us, pursuant to the...
In these kind of educational matters, we will not just like that interfere without,
Correct, my lords.
without material on record. List this matter on...
at least that may be recorded, my lords, that once we produce the copy, my lords, and if
Then
the...
counsel for the petitioner submits that the government has issued now the government is now the respondent university is going to conduct the examination on 1st of June. It is submitted that the examination earlier conducted was cancelled without any basis. Basing on a letter addressed by the university, the government has taken the decision. The petitioner has not placed before the court the letter that is addressed by the university. Those circumstances, at this point of time, this court is not inclined to grant any interim order. Does this matter when?
second itself, first or second, subject to the...
Already your clients have to write exam on 1st. Let's just matter on 5th of June.
And
Yes, next.
notice.
Grateful.
It's all these civil matters, they can come up on Monday, Tuesday, dates whenever you want.
Cause list 2, serial number 1, your lordship. I'm withdrawing the petition because it is
You want
not
to withdraw the
maintainable as per law, your lordship. It is not maintainable as per law because the trial court has rejected the application which was filed under order 1 rule 10 sub clause 2 of code, your lordship. So writ has to be filed instead of CRP. So
The office has raised the objection with regard to maintainability. As an application order 1 rule 10 is rejected and the petitioner has filed a writ petition under 227 but not CRP.
Serial number
Accordingly,
14,
the
my
memo
lord.
is-
Yeah, that's a-
I'll call the matters. Accordingly, the memo is taken on record and dismissed as withdrawn.
Your lordship.
Lord, I appear in serial. You will take up the matter because not listed today. Because there was an option that
That I'll take up.
Number 2.
Lord, I appear in serial number 2 for the.
And all the records shall be, all the documents shall be returned to the petitioner forthwith. Number 2.
Serial number 2, Rishabh.
My lord, appear for the appellant here. My lord, the appellant before my lord is the defendant who has suffered an ex parte identity mortgage.
It can come up.
Monday, my lord.
Yes, but not all the matters on Monday.
My lord, I have urgency here because 4 orders of
This is
judicial.
matter on 1st. Yes, at the request of the counsel petitioner.
I have appeared gave it your lordship. Can you maybe have it on 3rd or 4th, your lordship? I served the copy to me.
Counsel shall note the purpose of the. Yes, nothing will happen on 4th. Yes, 4th.
Serial number 4.
Yes, next week. 5.
Serial number 5.
Fine.
complaint.
5 on 10th of June.
For petitioner in serial number 6, my lord. Lords have challenged an application, my lords, which is
Yes, sixth on fourth. Yes,
my lords,
seven.
it's before trial court. It's on third, my lords. Serial number 6.
Filing a memo, my lord.
Memo for?
KVT is not maintainable with regard to the competency with regard to filing the memo, wakalat and.
Now I am not looking into all that. Seven,
you are
serial
asking-
number 7 on 9th of June. File it in the registry, it will come. Yes, 9.
My lords, I am appearing for petitioner.
Petitioner, my lord.
Issuance of
My lord, item 7.
Yes.
I am for the petitioner, which is the trust, my lord.
7
I
is
can
adjourned to 9/6, sir.
9/6.
8.
my lords, I am appearing for petitioners, my lord. My lords, matter pertains to issuance of delivery warrant of the property, immovable property, my lord. With regard to the statutory appeal also, there is a stay has been granted only with respect to the payment of decretal amount. My lords, on Friday, the respondent has once all of come suddenly and he has posted in a picture that stating that this matter is pending to litigation. Grateful, my lord.
9. 5th. 10. 3rd. 11. Yes, 5th. 12. 12 on 10. Fifth.
13.1 is there. 8.
14. Yes. 14.
Monday, my lord, attachment of mobiles have been amended. Monday.
Yes, 15.
Please, my lord. Tuesday, my lord.
Tuesday. 16.
We also same matter.
Tuesday.
17.
My lord, June 2nd. June 2nd.
2nd.
17. 2/6. Please.
18.
Next week,
18, my lord. 18, my lord.
4.
My lord, 18, I am here for the appellate, but there is a impugned order to be completed within 30 days. But that requires today, but there is an urgency in the matter.
I am for the cabinet.
Monday, my
Monday.
because I am within
Monday.
Monday, my lord, because
Monday.
there is
Monday. Yes. Yes, 19 on Wednesday. 20.
My lords, in serial 20, my lords, I'm for respondent. My lord, by virtue of interim order, they have posted the notice for general body meeting on Monday evening at 6 o'clock. Any time before that, my lords. Monday, please.
Yes, next.
My lords, in serial number 6. My lords, in serial number 6, my lords, case is posted on Wednesday, my lords. Kindly have it on Tuesday, my lords.
Number 3. Secondly.
My lords, in serial number 6, my lords. It's posted before trial court on Wednesday, that is on 3rd, my lords. Kindly have it on Tuesday, my lords.
Yes, what is that? Code officer. Tuesday.
Is the serial number, sir?
That is asking.
Serial number 6, my lords.
Serial number?
Serial number 6, my lords.
6 in list number 2.
Yes.
Please, my lords, please. That's
It is
posted
urgent
before
to
the trial
4/6.
court on 3rd.
Urgent to
Please.
4/6.
My lords, on before the trial court, its post date is given on 3, my lords. 3/6.
Then post it on
And
Tuesday.
please, my lords, please oblige.
Mentioned
Bill
by.
number 20, interim order.
List 2, my lord.
Extend. Yes.
Please.
MFA 3550.
Serial number 12, my lord. Serial number 12, my lord. Second list. We have it first day of application post granted the interim order.
My lord, the respondent, number 20.
You can mute all the disturbance. Yes.
My lord, respondent number 20, please, my lord, he is trying to alienate the property. My lord, defendant number 11 and 12.
Is the order impugned?
My lord, 34/2026. One day, my lord, last day of the vacation. I mean, sorry,
So-
not the last day of the week.
That's what. Now we are at the end of the month. What could have happened all these days? It could have as well, it can wait till Monday.
My lord, 3426, please, my lord, was the last.
That's what I'm saying. It can come.
Immediately I filed an
Let's
appeal.
This matter on Monday. Yes,
The
next
office
matter.
objections may be overruled.
What is the office objection?
Lord,
On
in the memo of documents, typed copy is not
Monday
furnished.
that can be done by the court. Yes, two.
Please.
Chair number 2, B.B. Ravishankar.
Your Lords, what has been properties bought for auction by the corporation,
Hmm.
saying that in fact, as on the date of the issuance of the notice of petition, the owner of the property was dead. Your Lords, there's a due of what they claim about 11,71,000 rupees, Your Lords. That is at page 25, annexure
It
A.
appears with the respondents.
Respond corporation, Your Lords.
Should have you served the papers
I've
on them?
served the copy, Your Lords.
Why,
Served the
then
copy.
why are they not representing before the court?
I've served the copy even day before this, when the appeal was filed.
On what, no, on what ground you're questioning this?
Please, Your Lords, what happened? The respondent, the mother of the petitioner is dead long back. So in the month of, somewhere in the month of 2025, notice has been issued on 14/5 to her, Srimati Geeta. She is not alive.
After her death, the notice is issued.
After death of her, notice has
Now
been
the property belonging to a dead person is
Dead
put
person,
to auction.
yeah.
When counsel for the petitioner submits that, the
Death certificate is
property,
annexure I,
the
Your
mother of
Lords.
the property belongs to the mother of the petitioner. And after her death, the notice is issued and the property is put to auction. The proceedings are against a dead person. It is submitted that they have served the notice on the respondent, on the respondents, and he also filed a
Endorsement,
proof of the same.
proof of the same.
It is submitted that he has a proof of the same. In spite of the same, there is no representation on behalf of the respondents, considering the fact that a notice that is issued in favor of, against a dead person and the property is put to sale, there shall be stay of all further proceedings pursuant to the sale notice dated 14/5/2026. List this matter. Print the name of, who is the counsel?
Councillor, please, Your Lords, I will inform.
Who appears for
Corporation. BBMP.
It's not BBMP.
BL Sanjeev.
Huh?
BL Sanjeev. BL Sanjeev.
Pin the name of Mr. DL Sanjeev. This is matter on 24th.
Second list, my lord, serial number 12, my lord, kindly have it Monday, my lord. Serial number 12, my lord, second list, my lord, kindly have it Monday, my lord. There is an urgency, my lord.
Which one?
Serial number 12, my lord, second list.
When is it posted?
Monday,
Tuesday.
my lord. Please.
Why, what is urgency on Monday?
My lord, the vacation court granted the interim order in favor of the first respondent, my lord. They are interfering the position, my lord.
Nothing will happen. List this
She-
matter on the same day. No urgency for that.
My lord, she executed the agreement, my lord, in favor of me, my lord, with along with position, my lord. Now she is seeking a interim order, my lord. Therefore, my lord.
ಹೇಳ್ತೀನಿ ಹೇಳ್ತೀನಿ